Yes.
But I am also, my case also, my lord, I have mentioned the last official, my lord. My lord is a directive to get the matter to be mentioned. Because well, I want just by the disposal of my previous petition. But the matter has not came, my lord. Sir,
I don't know. Hand over the slip. Let us check up.
My lord, this petition, have you heard, your lordship had the matter on 6th July and directed to submit a report on 10th July by the state, but the matter has not been appeared by. I will pray for the.
There is no such urgency. Let me take up the other matters. Yes, Mr. Bush.
Old lady, the petitioner.
I'm sorry, but not right now. Yes.
My matter is appearing in a lordship state under review application. But I was transferred on the basis of a recommendation of the SC/ST Commission. My office, Railway Authority, had preferred a writ petition questioning the propriety of the order. Ultimately, on the very next day, they withdrawn the writ petition. But no liberty was sought for from your lordship. I was one of the petitioners. I filed an application for review, which is pending. Now, my lord, unless a question, my lord, already transfer order has been passed. If I don't,
Please hand over the ask your junior to hand over this.
8/30/21.
321 at a Friday.
8/21.
Friday, Mr. Bose, I'll take up the applications and contempt applications first. It application listed opore diye deben Friday. Thank you. Yes.
number 454 of the monthly list challenges my lord to the issuance for a request of lookout circular.
Mr. Bose, please give the number.
21. Sorry. 8/21.
Please ask your junior to hand over a slip so that they can keep a record. Yes.
It's item 454 of the monthly list challenges my lord to the request for issuance of a lookout circular on the ground that there are bank dues. I am covered by your lordship judgment, other ordinate bench judgments. Any day convenient to my lord if this matter can be given some precedence.
Hand over this. It upgraded দিয়ে দেবেন. Upgraded list হবে.
I'm grateful.
Yes.
Lordship, I mentioned item number 580 of the monthly list. It's a fixed matter. It has not been taken up in June and July. So I'm praying for release of the matter.
No, not on that ground. I've had a talk with the Chief Justice, not possible. Yes.
Very Parliament mentioned two matters. This is the new domestic electric connection. Your lordship directed to submit a report whether there is any visible inquiry has already been made. Now let it be taken as a domestic connection. New.
But I cannot give precedence to that. Let it appear when it will. No, not right now.
That is appear in the combined list.
Oh, then it let it appear.
563, 64.
Not right now. Yes, Mr.
Well, this
Mr.
matter
Chatterjee, yes.
in the last one day, 858 is the combined list. This is an application, but I moved this motion on 13th March. This is relating to registration of a deed. According to me, the stamp duty will be 75. According to government, it is 6,000 something, 6 lakh something. We have deposited that amount without prejudice. That amount is with them. In the meantime, one application has been made by the erstwhile owner. The erstwhile owner wants to sell us. Now we will be the owner of the property within 2-3 weeks. But if this matter be taken up by your lordship, then we can say something so that the amount can be adjusted.
Mr. Chatterjee, please wait for some more time. I'm sorry, not right now.
This is the urgency matter. I have
Mr. Chatterjee, I appreciate, but there are
I have already
more urgent matters.
And your lordship has assured me that the next week onwards the applications will be taken up.
That yes, from next Friday it will be taken. My regular officer is not there. I had a talk with him. Every Monday he has some ailment or the other. So this Friday it will definitely be there. আপনি না একটু আসুন তো আপনি কালকের লিস্ট থেকে দিয়ে দেবেন Friday application and contempt application will be taken. First application, then contempt application, then other matters. Friday. যদি ডাউট থাকে আমার সঙ্গে কথা বলুন এই Friday. It will be taken up on Friday.
That will suffice my
No, it has to. I am also.
That will suffice my purpose.
Yes.
I'm not asking for any precedence or
May I pray for leave to file this writ application and move it urgently, because urgency is that my lord, SEBI issued a notice of my residence, put it in a e-auction bid of my residential flat, which has been purchased in the year 2012.
Hand over.
My lord.
এটা একটু লিভ দিয়ে দিতে হবে, কালকের লিস্টে থাকবে আর্জেন্ট হিসেবে। Yes, Mr. Das. Not right now, Mr. Das.
He deposited some deed, so-called loan. Loan has been given to to the LIC, but the LIC authority is not giving back the original deeds.
No, Mr. Das, you have to, not right now, yes.
4 years old, my lord.
I'm sorry, not right now, yes.
Lordship leave to mention, my lord, after taking possession of the secured asset, the secured creditor, my lord, have been taken, attempted to alienate and encumber the movable properties of the lying in the secured asset. So I have once an immediate stay order, and I also covered by the judgment of your lordship. First,
Please wait for some time.
This is also
Please wait for some time, wait for some time. Yes, Mr. Brother.
Dispose of the minor.
Wait for some time.
Upgradation, my lord.
No.
only
Lord,
upgradation.
my lord, upgraded this matter. This appear on 1st of August, my lord, as new motion item 16. But the CSC, my lord, there's a threat of disconnection. CSC paid for time, your lordship's adjourn the matter. Now it has gone down in the list. Now, my lord, what happened is I am a tenant in the property. Developer started construction. But I have a decree in my favor. What the developer did, my lord, forging my signature, they filed an application for surrender of my meter. Now CSC is running after me to disconnect the supply. I have written to them.
Hide
Now,
the
my lord,
pendency, Mr. Chakraborty, not
I'm
right
not,
now.
no, if it is disconnected, then Lord, I'll be Lord. It's a case of disconnection.
Not right
My
now.
Lord, your Lordship Lord has already
Not
upgraded
right now,
this.
Mr. Chakraborty, yes. No further upgradation, yes.
My lord, may I be permitted to mention with regard to item number 378, my lord? My lord, the urgency is that the petitioner is a cultivator. My lord, he cannot cultivate his land for last 6 years. Private respondents, my lord, obstructed to the access of his land to my lord, and by making construction over the government land. My lord, the proceedings has already been done, and that proceedings may be concluded within a specific time. This is a very short matter, my lord. My lord, a cultivator cannot cultivate his land for last 6 years, my lord.
What is the stage of the proceeding?
My lord, they have initiated a proceedings for eviction of the unauthorized construction.
That is your only prayer.
My lord,
Hand over.
lordship, I'm
Upgraded.
gratefully, lordship.
Upgraded থাকবে।
Lordship, I'm gratefully, lordship.
Number 431, my lord. My lord, the urgency is, my lord, the tender is given to the other side, my lord, violating the terms and condition of the tender. I made the objection, and objection, my lord, was not disposed of. There is a rules that the objection will be disposed of within 48 hours, my lord. That has not been done. The work is going on, my lord. Therefore, my lord, if the
Work has already been handed over to somebody else.
my lord.
Yes.
My lord, in this matter, my lord, my last Monday, I also mentioned in this tender matter. My lord, my tender was initially my lord accepted, and when I had admitted, thereafter during technical bid, my lord, there is a mandatory provision that the insufficient or my lord minor default can be cured by asking the sufficient papers during my lord technical bid. My lord, they did not disclose this. They, my lord,
No, Mr. Guchet, not right now.
rejected my tender on 7th.
No, not right now.
18, they have opened
The next man, please. Yes. Yes.
On last Monday, I have also mentioned this matter, the hospital is shut down.
I entertained it probably. It is not appearing.
It has to be, it will have to be included in the list.
So did I include last one? What is the urgency?
Hospital is shut down, the hospital is want to serve the people, but
Hospital shut down since when?
from last March.
Last March.
Yes, your lordship.
Hand over.
The respondent has started illegal construction on the irrigation land property. And the exact ingress of petition is totally blocked without the permission of the concerned authorities. Lordship, they have started the construction.
You are a third party.
Lordship,
Who are you?
I'm petitioner of my exact ingress totally blocked.
No, then file a civil suit. No, not right now. Yes.
Here, I have to mention, CSC, already directed on, passed on October 22nd July, I directed the developer to be a party in the developer as a party. The petitioner could not obtain the developers details within time. Kindly pray for lifting the matter. Please, I can pray for leave.
I'm sorry, not right now. Yes.
It's fine to mention.
No, you are not in the line. She's in the line. Yes.
On the last petition matter, on the last one, the matter was already appeared as item number 12 matter. Then the other side has take the adjournment and it has come to the adjourn motion. The fact is that matter, the petitioner.
Nothing. No, I cannot. No, no further. No, nothing further. Yes. You are ready to pay the money. Hand over. It upgraded the other. Upgrade. What matter?
One matter,
one matter was previously, I give the.
তিনটে ম্যাটার দেখি ওপরটা চুজ করে বাকি দুটো ফেরত দিয়ে দাও অনেক থ্যাংক ইউ এরম এরম কেউ যদি মিথ্যে কথা বলে দেন আমার পয়েন্ট আউট করে দেবে ইয়েস
বলে দিলেই হয়ে যেত।
What is the urgency? What is the urgency in the matter? No, this is not an urgency. I'm sorry, there are extremely urgent matters. So many people are waiting. You're wasting time. Yes, next man, please.
I have been appointed as President Qazi in the matter of under the.
What is the cause of action now?
Just for last Thursday, my lord, I have to work in Lakshuria. Another person have been appointed, the same district, sir, he can't be wrong. I work in Lakshuria.
Hand over, upgraded.
740. Appointment of Muslim marriage register.
Not right now. Yes.
Your Lordship, may I be permitted to mention, this is for inclusion of the year 2022 urgency is that private respondent has raised on a mobile tower by filling of Jol Jomi and encroached my boundary. It is pending
It has
since.
been constructed, whatever your damages, your relief lies in damages. So wait for some time. Yes.
My lord, I'm praying for upgradation of two matters, my lord.
Urgency.
My lord, the urgency is that in one, the doctor has made medical negligence, my lord, and he performed a cancer surgery without having the oncology degree. The petitioner made a RTI before the Calcutta Medical College, my lord, but they have not responded.
What is the other one?
My lord, the other one is that the panel will expire, my lord. The petitioner sat for a recruitment process, my lord. That is also related to
Please
RTI.
hand over the second one, panel, not the first.
Grateful, my lord.
This was filed in the month of February 2023, but it's yet to see the light of the day, my lord.
It will remain
reads-
in the dark for some time more. Yes. Urgency, 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 only urgency. Family pension, hand over. Please be a bit louder. Mr. Das, please take the microphone. Yes. Yes.
Under a changed circumstances, an application was taken out in respect of a tender matter, which the authorities sought to settle with a single tender, excluding me from the zone of consideration, having all requisite qualification. And in that matter, affidavits are called for, affidavits have been completed. Now, pending the matter, the authorities sought to issue, possibly it has been issued the work order, for which an application has been taken out, or
That application, hand over.
it has to be heard out, otherwise the entire matter is frustrated.
My lord, may I, my lord, kindly to my lord, obtain my lord the short service leave and my lord move tomorrow. My lord,
Urgency.
my lord, 2000 laborers quarters, my lord, they have received the disconnection notice yesterday, some and some.
Labor quarter, electricity notice.
Yes, yes.
Hand over. Liftটা দিয়ে দিন কালকে থাকবে. Yes.
My lord, may I permit to mention for upgradation, this is a tender matter, my lord. Tender has been issued unqualified, my lord.
Apology. Apart from apology, I'm not taking anything unqualified. Tender matter, wait for some time. It's in the list. Show your client that. Yes. You won't succeed, sir. You.
সবগুলো তো ঠিক বসে যাচ্ছি কিনা দেখতে হবে, আমি বলি কোন রকমে, তারপর তুই এখানে আসবি তারপরে বলবি।
All behind this auction. And now he's in road, and now he has no. And now
Auction purchase participated, he is on road. Cannot be.
He has no shelter to lead right now. And
Why did he participate in the auction purchase?
my lordship, he has purchased a flat, and the bank yet not.
Auction purchase of a flat. Where will hand over? Nin. Yes. And the computer form at least you have to fill up. ওটা দিয়ে দেবেন ওকে করে দিয়ে দেবেন। Yes. Yes. What is the urgency? Tell me.
Since the money of bank is already in danger because the.
You're for the bank.
Yes, sir.
Wait for time sometime. Yes. Why? Yes. Your client has been removed. Hand over, it will be in the list, but no upgradation right now. Actor Nina. Yes. Hand over. Yes.
না এটা পরে করবি
The petitioner was paying the tender.
Money claim, please wait for some time. It's a money claim, please wait for some time. Appreciate, but wait for some time. Yes. No. Then I'm consistent at least. Yes. Section?
Section 10 of my lord, the Highways Act, my lord, matter appeared on my lord 10, my lord, at item note 10, my lord, the private respondent appeared, and my lord, despite serving of the back. Lordship, that will come back after tomorrow. State government, my lord, took time, my lord, until my lord, only to demolish my lord, my livelihood at stake, my lord, my guarantees which are late for my lord,
No, no.
different person, my lord.
Not the, yes. Hand over. Yes. No, you're there. Sorry. Yes.
My technical bid was rejected for some minor mistake, my lord, in terms of minor, don't my lord.
Work order issued. Hand over. Yes.
I have your lordship's kind leave to mention, my lord, item 43 of your lordship is the upgradation. Urgency is, my lord, the bank account for partnership firm has been frozen. Statutory payments of 2 workmen, etc. cannot be made.
Please hand over. Under এটা ইয়েতে ওই উপরের দিকে দিয়ে দেবে যেটা।
I'm good.
Yes.
Permission to mention 2 matters for inclusion. One is petitioner
Upgrade ही দিয়ে दिए top and upgrade. Yes.
the petitioner applied for OBC certificate to the concerned authority, having his father as a OBC certificate. The candidate is a civil servant aspirant, but without showing any reason.
Hand over. এটা upgrade দিয়ে দেবেন একদম।
Another one is
No, your quota is over. Yes.
may I permit to mention a matter? I am praying for inclusion as motion.
Please repeat louder.
That I am praying for inclusion as motion the matter. The matter is the bank did not return my money. I submitted succession certificate. My father nominated me. Everything I submitted, but the financial.
Hand over the slip. Yes.
May I have my lord's kind leave? My lord may remember, my lord, one tender matter I moved because the track.
I absolutely don't remember. I'm sorry.
My lord, this is relating to my lord Poschimachal Unnayan portion.
Yes.
My lord, only for the reason that the track report was not there, but it could not be taken up. Now, my lord, a track report came, my lord, long ago. The matter could not be reached. My lord, they are going to, my lord, issue the work order. Unless it is heard, my lord, the tender matter will be infructuous.
Wait for some time.
My lord, your lordship kindly appreciate.
Not so many tender matters. I'm not being able to take about.
And my lord, the 3 other matters are there. My lord, eviction notice has been issued in respect of the retired employees of Farakka Barrage project. This is appearing, my lord. It's long.
Retired employee, you have to leave.
No, my lord, those quarters are abandoned. They prayed for a settlement or, my lord, to allow them to stay because they do not have any, my lord, roof over their head. My lord, it is appearing.
Well, hand over. It is appearing in the list.
Yes, my lord.
No upgradation. I'm sorry. No.
My lord, your lordship. And my lord, one is there, my lord.
No. Other.
My lord, only one, my lord. It's a
if you take the entire time, others cannot mention.
No, my lord. It's a matter of 90 years old man. My lord, your lordship kindly allow it, my lord. There was some pursuant to this honorable court.
I'm sorry, I had to mention refuse 94 this morning. So I'm sorry for now. Yes.
Permission to mention before a lordship upgradation the matter which is running here today, please. 284 matter is urgency is, my lord. Petitioner made an application for new electric connection in the year 2022, but till today they have not given the electric connection by the WBACDC.
Not right now. Yes.
Lordship's kind leave to mention item number 295, my lord. The difficulty is also a tender matter. I've challenged an entire tender process floated by the urban development, wherein the tender has been granted in favor of someone absolutely arbitrarily.
Wait for some time. This will take some time to.
The urgency, my lord, is that the work order has been issued, but the work has not commenced, my lord.
No.
Absolutely arbitrary.
No.
My lord, may I be permitted to mention a matter for upgradation? My lord, this matter was mentioned on the last occasion. Your lordship asked me to wait. My lord, I submitted a bank guarantee to get hold of the security deposit of 3 crores. My lord, I am facing surfacey proceedings against me, my lord. I am in a very difficult situation, my lord. Only a short matter, my lord.
What can be done by the writ court? Go before the tribunal.
I submitted the bank guarantee to get hold of the security deposit. They are neither releasing the security deposit nor giving the bank
No,
guarantee.
you have to go before this tribunal. High court cannot be
Tender
stopped.
matter, my lord, tender.
No. Yes.
But may I be permitted to mention item number 804 of the monthly list, my lord? This matter was filed in December 22, my lord. Till now, it has not been taken up, my lord.
What
I
is
had
that,
mentioned-
Nancy?
My lord, we had prayed for waiver of rent. Notification was issued, part waiver was given, part was not given. Even the part waiver which was given, that has not been complied with, my lord. I will kindly upgrade, my lord.
Sorry, no.
It has not been taken once, my lord.
Cannot be. Yes.
May I permit to mention one matter for the upgradation? My lord, petitioner is entitled to get certain payment which already paid by the petitioner to the respondent number 1 as a service tax which ought to be given by the respondent number 1. And in this regard, my lord, around 9 lakhs already given, which as a contractual obligation, it is required to be paid by the respondent number 1. But there's a notice issued by the concerned income tax department, and that's why respondent petitioner has to pay the amount and already paid. And now he wants
Wait
to
for some time. You are claiming a sum of money. Please wait for some time.
this is a long pending matter. Well,
Sorry. No. Yes, you.
May I be permitted to mention contempt application?
Yes.
My lord, in this matter, the petitioner, he exported certain consignment of fish in Russia, my lord, against the letter of credit. State Bank of India has declined to process the letter of credit, although the Reserve Bank of India has categorically stated.
Hand over. Yes.
File this petition with notice with illegible copy, my lord.
No.
That is supplied by the authority itself. That is the subject matter of challenge. It is
Illegible copy, no.
No, that is the subject.
No. If I can't look into the matter, how can I?
Subject matter.
No. Yes. No. I can't get you. It's in the list.
Yes, but 176. In the list of petitioner, waiver bill already paid in the March. This part of the payment is connection.
Hand over.
For upgradation, the used against the high tension line for protection of the petitioner's building has fallen down. The railway officials have not fixed it.
Hand over. It's in the list. Upgrade the give the item numbers. Write it on a slip of paper, please. It upgrade list as well. Yes.
Item number 131 of your lordship, that was coming for upgradation. Also, that successful auction purchase, the bank might be well aware that there's an order of TRT and injunction on that property and proceed with the auction. My money is stuck there. I have an urgent need of funds.
Hand over. You want a refund? Yes. This will take some time, not right now. This is a full-fledged hearing matter. No, not possible. Mr. Haldar, yes. No, not right now. This is a full-fledged hearing matter. Yes, Mr. Haldar. Hand over it, upgrade. Yes, Mr. Bhattacharya. Yes, contempt handover.
The contempt application was all.
Contempt applications handover. Contempt applications and applications you can hand over without mentioning. Applications and contempt.
Withdrawal of the writ petition, my lord. Withdrawal of the writ.
That is to be mentioned. Right to be mentioned. Withdraw for withdrawal and hand it over. I'll take it. Yes. Mr. Bhattacharya, yes.
new mission, new.
Let the application, the slips come over first. आपने एগুলো নিয়ে নিতে তারপরে নিচ্ছি বাকি।
The application.
অ্যাপ্লিকেশন তো আমি নেবই শুক্রবার ওই দিন হ্যাঁ নিয়ে নাও দিচ্ছে নিয়ে না থাক নিতে তো অসুবিধা নেই কাগজ দরকার অ্যাপ্লিকেশন কন্টেস্টেড অ্যাপ্লিকেশন কন্টেম্প্ট অ্যাপ্লিকেশন এমনিতেই থাকবে ইয়েতে শুক্রবার yes Mr. Bhattacharya 400 something
Go down was constructed, everything was done as per their norms. Thereacter, they said that they would fire it because I was beyond time, according to them. Be that as it may, now I am seeking to offer the godown for FCI. Now, my lord, they are declining. Food and Supplies Department is not issuing the, my lord, apparent no objection, so as to, my lord, enable me to offer my godown to Food and Supplies Department, to the FCI. Now, my lord, this is the urgency. The matter is item number 439. It's a motion. Any day convenient to your lordship, my lord, any day. Any next week, week after next, my lord, any day kindly fix.
It will not be in weeks, Mr. Bhattacharya. It will not be in weeks. No, not right. No. Yes.
Agencies, my lord, my livelihood is at stake, my lord, because I am not allowed to operate the submersible pump, and therefore the decision has to commence. My lord, cultivation work is there, total stall, my lord, and my since I have not allowed this, that's why my lord.
Livelihood is not pertinent for submersible pump.
Running the submersible pump by the source, my lord, the income. My lord,
Not right now.
Others
No. Not right now. Not right now.
Not allowed the submersible pump.
Your fluency won't help you. No. Yes.
Item 209, 300, my lord. This matter, my lord, I am paying for upgradation, my lord. Here, my lord, I have been declared as willful defaulter, my lord, without following any rules, my lord, of master circular, my lord. Now, my lord, my agency is this, my lord.
Go before the review committee.
My name will be.
Go before the review committee. No, not right now.
Has also passed, my lord, order, my lord, that.
Then court will not interfere. Don't mention it. Why hasten the dismissal?
Followed my objection.
No, not right now. Yes.
My lord, may I be permitted to, my lord, mention item number 474, my lord, senior citizen, my lord, credit card for fraud, my lord. Every day, my lord, they are sending collection agents, my lord, to my house, my lord.
I'm sorry.
Every day, my lord.
Not right.
My lord, another, my lord, ESI, my lord, another, my lord, mentioning, my lord, ESI, my lord, they have sent it for execution, my lord. They are coming. I am a confectionery, my lord, with 5 laborers, my lord.
ESI, what is
they
your
have,
claim?
ESI, they have made a order against me. They have, firstly, my lord, they have conducted an inquiry where I have 5 laborers, my lord. I am not under ESI, my lord. They have then passed a order, my lord. Now they have sent the order for execution, my lord. They are coming to my confection.
Hand over. Yes.
Lordship, I have mentioned.
Please use the microphone.
I mentioned this matter on previous occasions as well, my lord. This is
That is not an urgency.
this is a money claim matter, lordship.
You know my answer.
Thank you.
Not right now. I'm sorry. Yes.
Relating to family pension, not getting, my lord, since
Hand over.
my lord, upgradation.
Upgradation.
Is in the list upgradation. Well, he's not getting, my lord, since 1989. Well, different forum, different direction.
They
my
will
lord.
hand over.
Lord.
Upgradation. Yes.
So during the pendency
It's
of the
upgradation.
writ petition, my lord, the bank authorities and the DM has issued a notice that to take possession of my flat and shop on the 10th of August, my lord.
Hand over. Upgrade.
Tender matter, my lord. Non-refund of security deposit.
Expression won't do. No.
My business has been.
Not right now. I'm sorry. No. Yes.
My lord, may I mention one matter for inclusion, my lord?
Urgency.
My lord, the petitioner's brother had executed a will in his favor. Probate was taken, but the LIC authorities are not disbursing the service benefits, my lord. The urgency is that, my lord, the petitioner is living without a kidney, my lord. He's living with one.
Upgraded it. Yes.
Grateful.
Sir, may
Yes.
Sir, as per your order date.
You're appearing in person.
Yes, sir.
Please wait for the advocates have a prior right. Let them mention first, then I'll hear you definitely.
Okay, sir.
Yes.
Oh, advocate के बाद.
Please wait. I'll take up after all the advocates are finished.
Wherein the election of Noida District Pass Owners Association has been stalled. I am the petitioner. I have challenged that the election is going to be held. He holds the bylaws, which says the bylaws.
When is the election scheduled?
Well, last month I have already obtained an order of stay. Now, what is the problem is that the small bus owners, we have only 1 or 2 buses. They are
No,
not
no.
getting.
You already obtained an order of stay now.
What has happened? As I have obtained the stay, that the law was that if a bus owner have 5 buses, he will be entitled to only 1 vote. Well, what they have done, if I have 5 buses, I'll be entitled to give 5 votes. On that point, it was stayed. Now, what is the problem? The existing board is now functioning, and the bus owners, we are having only 2 buses, but they are not getting the right time. Only the best of time, they are enjoying.
No, Mr. Charge, wait for some time. No, not so urgent.
There are only 1 bus, they are suffering. They are running.
Not right now. Not right now. Yes.
Regularly, I'm paying the installments of the house building loan. In spite of that 32 notice has been issued, I even reply 30 in spite of that, lordship, they are sending the recovery. The matter is running, I can come to
Hand over upgraded. Yes.
So lordship, I'm for the widow lady, and I should refuse to deposit the matured value as well as the bank.
Hand over.
Can we
Two
permit
items are
my lord?
টু আইটেম সেটা নিয়ে দিয়ে দেবেন প্লিজ। হ্যাঁ, টু আইটেমস আছে বলে দিয়েছে।
Mention matter, two date petition matter, which is for inclusion matter, the section 14 of the SABYASACHI Act. The learned district magistrate has not disposed of the
হ্যান্ড ওভার এটা আপগ্রেডে দিয়ে দাও দুটো। ইয়েস ইয়েস when is the financial bid scheduled? হ্যান্ড ওভার আপগ্রেডে দিয়ে দেবেন। নিউ মোশন হলেও আপগ্রেডে দিয়ে দেবেন। ইয়েস State Bank has SABYASACHI Act.
At that point of time, I'm already suffering from right. In this point of time, my two child is out from my home. I'm deciding in 100%.
Hand over. Yes.
Motion, your lordship. But the petitioner applied for.
It upgraded list দিয়ে দেবেন। I can advise put it in the upgrade list, but there are already 100 upgraded matters for me. Yes.
Applied for my lord, the passport, my lord, but no decision has been taken by the authorities. But the petitioner is working in an aviation company, your lord.
Oh, hand over.
My lord's permission, I'm mentioning my matter for accommodation. Starting with the list is item number 4. Is the suspension of Aadhaar card by the other court authorities.
I can't hear this question. Yes.
The suspension of Aadhaar card by the other card authorities.
Suspension of
Aadhaar card.
Aadhaar.
Now the current scenario is, my lord, the petitioner's bank is non-operational due to the necessity of Aadhaar card.
Hand over.
But
Yes.
this is for upgradation. My lord has taken up this matter on first. Due to one of the respondent, private respondent was not served. So my lord had kept it in the combined list. I wanted an upgradation matter.
No question now.
This is for upgradation matter, serial number 399. Your lordship already taking the matter and passed out an order regarding engagement on contractual basis of selling of tickets, and an unemployed lady, my lord.
Not right now. I'm sorry. Wait for some.
Lord, eviction notice under Highways Act, it has been passed in terms of a direction of the district magistrate. Therefore, I cannot also prefer an appeal. Lord, eviction will take place by Wednesday.
Hand over.
Lord, I'm praying for leave.
লিভ দিয়ে দিন, কালকে থাকবে লিস্ট। মোশন ইস
Lordship, if I may be permitted to mention, your lordship, this is a matter where the petitioner is a litigant, your lordship, under the WBAC-DCL, and he's requesting for disbursement of fund, your lordship. The reason that the state is showing is that he has not signed on the bills that were provided.
Sir, please wait for some time. You are asking for a money claim. Wait for some time. Yes.
Lordship, may I permit to mention for upgradation item number 397, the urgency is that the challenging the e-auction notice dated 28/2022, the process of e-auction conducting by the respondent bank during the pendency of this instant writ petition, the presently some unauthorized person demolishing the existing structure of the mortgage property and trying to alienate and change the nature and change the character of the entire property. Kindly upgrade this.
You have a relief before another forum? No. Yes.
My lord, new option, my lord, I'm not being supplied by the electricity, my lord. It is in the monthly list 322.
Electricity matters, I am refusing. I cannot do anything. Let
My
me
lord,
take
no
up.
option, no electricity is being supplied, my lord.
Wait for some time.
Very short
please.
matter, my lord.
Electricity matters, wait for some time.
Kindly
Yes.
give in the
No,
abbreviation.
not right now.
I beg to mention one application, my lord, for application. The remuneration of the opposite parties has been stopped by the BDO. All right. And
What are you? You are employees there?
Yes,
In what capacity? Group D or what? What are you? What is your designation?
Group D cook.
Hand over. এটা আপগ্রেডে দিয়ে দেবেন। Yes.
Grateful, my lord.
Money, home loan amount by the respondent bank. He has been already sanctioned and home loan. And once the deed get mortgage, when the possession, it came to the possession, he has been told that the possession is to another person.
Please hand over.
Who has been given by the home.
Hand over. Yes.
I am mentioning on that level, that the health department has is paying money for that department. The 28 lakhs has not been paid to the petitioner.
Money claims I'm not immediately entertaining unless
by taking loan from the bank, cannot.
I appreciate, I fully appreciate, but
Specializing to return the.
there are too many matters in the list, not right now. Yes. Mr. Korma.
What is matter that some renters kept partnered. Now, not the difficulty is getting formation of a apartment ownership not association. Now, not in the dispute, pending the dispute, nobody is paying maintenance. And for the developer, your entire thing has been stopped. So anytime I go to them to ask for the maintenance, they only show this.
Mr. Kormakar will have to wait for some time. Partnered matters I cannot touch now. There are so many partnered. No. No, I'm sorry, no.
I'm the owner of the liquor shop, but it is come with the benefit and for last 3 years it's not
2.5
lakh.
is due from whom?
Where the money stuck, we have not received the goods.
Wait for some time. Wait for some. Yes.
Lord, may I mention one?
Hello. Yes. Upgradation is the two matters. Well, activate. Yeah. Hello. Hello. Yes.
Applied for getting information about the.
Not given. Hello. It upgraded the. Yes. Urgency. Electricity item, ma'am, please wait for some time. Yes, not right now.
Urgency is that the petitioner husband died on March 2023. Child benefit of the petitioner husband has not been disbursed.
Hello. Upgradation. Upgradation. Upgrade. Yes.
It's a case of LOC. Your Lordship, I am covered by your Lordship's judgment or for a simple default of loan. My travel has been restricted. I am in the export-import business.
Stay for some time in India.
By the end of August, Your Lordship, I made several applications.
Why?
I also can application for my business trip. I have tickets as well, Your Lordship. The urgency is that I have earlier got an interim order, but for a particular trip.
Please wait for some time more.
Kindly I mentioned this.
Not right now. Yes.
Lordship, may I be permitted to
Not
mention for upgradation of serial number 582, Lordship, petitioner is suffering from 100% disability, having an independent source of income.
Upgraded. It upgradation. Upgrade matter. Yes.
My lord, there is a bit of urgency in the matter, my lord. The private respondent is a society running a college. My lord, due to my lord, the misappropriation of funds, my lord, and furnishing of forged document, I had taken out an application before the registrar. Registrar had cancelled the registration of the society, but the society is still, my lord, admitting students, and it is running. But no, my lord, ancillary, my lord, steps has been taken under the act. That brings me before your lordship, my lord. There is.
Let the society run for some time.
My lord, because but they're still, my lord, admitting students. In fact, there is no registration of the society.
Not right.
Let it appear in the list at least. Lord, because third party interests are, my lord, affected.
Not right now. Not right.
Let it appear in the list.
No. No. Yes.
Lordship, may I be permitted to mention one matter for upgradation, Lordship. It is appearing in item number 756 in your Lordship's monthly list. Your Lordship, in 2019 and appeared for examination for assistant secretary in the Nihati municipality. I gave the examination. I got selected for the interview. After the interview, they have not revealed the result. Filed an RTA, but they have not given any response. So, Lordship, that's why.
Hand over.
Grateful.
My lord, may I be permitted to mention in this matter, WPA 2074 of 2023, it was filed in the year, in the month of January. And the petitioner here is a law student, my lord, in the 4th semester, my lord. And he had applied for a credit card loan under the Bengal scheme, my lord, West Bengal scheme, but he is being declined on flimsy grounds, my lord.
That's a student loan.
Yes, yes, my lord.
Hand over it upgraded.
Yes, my lord.
Upgrade. Yes.
And after 2 weeks, my lord, he will be having an exam. He doesn't give the fees, then he will.
I like let it be in the upgrade list wherever it appears.
Deeply obliged.
Yes.
The subject matter of the writ petition belong to the class group 5 of the classification list, my lord, but it is wrongly filed under the group 9.
To be mentioned, kalke de deven. To be mentioned, kalke de. Yes.
My lord.
My lord, one electricity connection, madam, my lord, 2000 since 2000.
Electricity connection. 2000.
2019. Since 2019, I am not getting electricity connection, man.
I've been refusing other electricity matters. Wait for some time. What is the next?
Madam, another matter is that wrongly filed in group 9, my lord. It was group 1.
That definitely. Area 2 mentioned the other one. Yes, Mr.
Miller, there is a matter 628 in the monthly list. The urgency is this: I have purchased a property from a particular person in Tollygunj. It's a residence premises. The permission apparently has to be taken according to state of West Bengal to transfer it from the people who are there. Now, Milord, they passed an order terminating the entire lease after I paid 1,94 as Milord for sale of the for purchase of the property stamp duty. Milord, this order has been stayed. Directions were given. Milord, I can't move into the property for residential with husband and wife. Milord, until your lordship.
Mr. Bush, I appreciate the difficulty, but cannot be
Milord,
increased.
628, Milord.
No upgradation right now, Mr. Bush. I'm sorry. I fully appreciate they cannot move in everything, but no, not.
This is a proper.
More urgent matters I am refusing.
My misfortune was that they asked for the permission because all property in Tollygunj Milord apparently is owned by the state. So no permission is required. But Milord, this is two individuals who just cannot move into the property.
Mr. Bush, please give me some more time. No, not right now. Yes. Mr.
Lord, I beg to appear, Milord.
Yes, Mr. Rahim.
Lord, I beg to appear, Lord, and want to mention one matter, Milord. Lord, I had mentioned, Lord, last month. Your Lordship said, wait for some time and mention. Lord, there's some urgency, Milord. The pleadings are complete. I promise to take, Milord, only 10 minutes of your Lordship's time, Milord. I'll give my written submission, Milord. One day I'll come to Calcutta, Milord. I'll give my written submission. There's great urgency, Milord. A person, Milord, not having any qualification is functioning, Milord, as a member of the Waqf board, Milord. All pleadings are complete. I'll give my written submission, Milord, and I promise, Milord, not to take more than 10 minutes.
It's appearing in the list.
Lord, it's not in the list, Milord, but if your Lordship may have it included. Any day, Milord, in the last week of August, Milord, or first week of September, Milord, I'll
hand over the slip. We'll try.
I'm much obliged, much grateful, Milord, much grateful.
On my only receipt, my lord, home statement, I voted my lord to transfer. Directed the DM to remove it. Thereafter, the DM SDO had directed to remove it. Despite of that, only the home statement, my lord, transformer has been installed. Now I am started.
We'll hand over. It's appearing in the list.
Yes, 314 of. But I know that.
What's the use of giving putting it in on the upgrade list? Wait for some time. Now nothing doing. এখন নিও না এটা আপগ্রেড আর দিয়ে লাভ নেই নো নট রাইট নাও ইয়েস hand over yes please be a bit louder.
Authorities have issued a caste certificate.
No chance of hearing you. I'm sorry.
May I permit to mention?
Yes, you are permitted. What is the urgency?
Authorities have issued caste certificate to my daughter illegally, though we are not entitled to receive the same. My signature has been forged. I made the representation, but has not been concerned.
Not right now. Not right now. Yes.
May I permit to mention, Lordship, on matter for upgradation, Lordship? This is new connection, Lordship.
Connections. Wait for some time, please. Yes.
I have a lot to mention the matter. New connection. I think is the one that
Electricity connections. Please wait for.
I have applied in the year of 1915. My mother's age is 80 years. She's suffering from chronic bronchitis. Anytime she will know more. Now it is grateful to us.
We'll hand over. It is upgradation. Yes.
And may I be permitted to mention on matter for upgradation matters item number 768 that the petitioner is entitled for a employment and the legal heirs of the petitioner is also entitled for a employment against a land acquisition by Eastern Railways, my lord. Since 2015, I am serving representations. So almost 10 to 12 numbers of representation I have served to the railway authorities. They are sitting writing over the matter.
You're wanting only a representation consideration.
No, my lord, I am wanting.
Wait for some time. Wait for some time.
My lord, may I be permitted to mention one matter? Writ petition, my lord. I am entitled to get
a subsidy under the scheme of Ministry of Commerce.
Small scale industry or a normal industry?
My lord, it's a large scale industry. I'm a tea exporter and manufacturer. Matter was heard and affidavit in opposition. A respondent was directed to submit affidavit in opposition, but matter did not appear in the list. My lord.
Not right now. Hearing matter cannot. Sorry, wait for time. Sorry. Yes.
My lord.
My lord, may I permit to mention one item number 315, renewal of license, security agency license. My lord, license is not renewable till date, and my client and all the members of there.
You are
are
asking
facing
for
hardship.
inclusion in the list?
Yes, upgradation for the list.
No upgradation, no. Yes.
My lord, may I be permitted to mention?
Please take the
list-
microphone.
list
Yes.
matter for adjournment, Lordship. Item number 20.
For adjournment, miss?
Lordship, not this week, because a similar matter has been reserved for judgment by your Lordship. So all I was praying is let
If it is called on for hearing, then have it mentioned to somebody, whoever. When it is called on.
Lordship.
Yes. Oh, yes. I'm sorry. Yes.
After receiving full outstanding amount, the bank did not issue no objections or which the petitioner could not be able to renew his permit.
Renew his
Permit. Stage
Per-
carriage permit.
carriage permit.
Stage carriage permit.
Stage carriage permit. Please hand over. Yes. No, he's.
The petitioner is a 83 years old lady. She had applied
Once
for,
I've refused 94 in the morning, 94 years, it's easier now.
she has applied for in the refugee rehabilitation.
I'm sorry,
department.
I'm extremely sorry. I cannot give precedence to these people, but not right now. I cannot. Yes.
My lords, kindly to mention item number 34 of my lords.
You are much younger.
Ma-
No, Mr.
Item number 34, my lord, there excise
The
license.
Banerjee matter is item 34 you were mentioning.
My lord, there is some urgency, my lord, in the matter. It has been pending in the list for a while, my lord. As
No. Yes.
My lord, I am a government medicine supplier. My amount 57 lakh is due from government since 2020. It's my total capital, my lord. Please, my lord, without release, my
Very well, hand over.
thank you.
May I permit it for mention one motion, my lord, only for inclusion in the list, my lord.
No, only for inclusion. What is the urgency in there?
It was pending, my lord, from 2021.
No, not right now. I'm sorry.
Only inclusion in the list, my lord.
Not right now. Yes. Bolun.
Sir, as per your order dated 14 June 2013, she had applied for taking admission to the Director of Medical Education, but they are denying for giving admission as per your order, seat is reserved. They are denying that there is no clarity in the order copy for giving admission to her. So we are requesting for giving clarification to the order copy.
You have filed an application for clarification. File an application for clarification. Mention it. I'll include the application and pass an order. You have to file a formal application giving the reasons.
Sir, in this courtroom?
In the computer section for this courtroom.
Okay, sir. Thank you, sir.
Thank you. Doctor.
It has raised item number 1.
Excuse me.
I got it.
Your lordship, one mention in person.
Accordingly, WPA 12719 of 2023 is dismissed on contest without any orders to court. Sergeant certified copies, no orders to court.
My lord, stay of 4 weeks. My lord, considering, my lord, this is a auction matter.
So what was the direction? What is the effect of this?
I am opposing the stay also.
No, obviously.
Serial number 230 monthly list.
They not even obtained an interim order at the time of preliminary hearing of this matter.
My lord, I understand lordship is dismissing. My lord, I am praying for a stay, my lord, considering this is a co-linkage matter, my lord. If I try my luck, my lord.
No. What was challenged here?
My lord, the model FSA, my lord, the terms of the model FSA being arbitrary.
What is the use of a stay of a dismissal order? I mean, the writ petition revised.
Yes,
my lord.
Has no meaning.
Yes, my lord.
After the order judgment is passed, comma, an order of stay is prayed for. So, however, comma, since the writ petition itself has been dismissed, comma, a stay of operation of the same would not serve any effective purpose for either of the parties. Full stop. Accordingly, such prayer is refused.
Lord, I'm grateful.
I'm grateful.
Serial number 230 monthly list.
আচ্ছা এইটা না একটুখানি ইয়ে করে এটার সঙ্গে অ্যাড হয়ে তারপর হবে আমি সই করলাম নিশ্চয় কারণ এটা একটা কারেকশন হবে লাস্ট ইয়েস করো নেক্সট
Item number 2.
Serial number 230 monthly list.
item 2 who is appearing
She wants to mention.
Yes.
She is waiting for since long, sir, your lordship.
Wait, mention.
মেনশনিং হয়ে গেছে তো মেনশন ইজ ওভার
She was already here, your lordship. Just
অনেকক্ষণ ধরে ছিলাম এখানে।
ইয়েস কি মেনশনিং
অ্যাকচুয়ালি আমরা আমাদের লাইফ টাইম সেভিংস দিয়ে একটা প্রপার্টি নিয়েছিলাম, না আমরা প্রপার্টিটা পেয়েছি, না আমাদের ব্যাংক টাকাটা ফেরত দিচ্ছে।
দিন yes
my lord, it's a group 5 matter, my lord, appearing before you.
acha since the matter pertains to group 5 of the classification of writ petitions as submitted by learned counsel for the petitioner comma the matter is released from my list for lack of determination with liberty to the parties for mentioning before the appropriate bench having determination. Thank you.
Great.
Item number 3.
Seated. Yes.
I'm a state. Item number 2.
Yes, Mr. Jana, what is that? Yes, yes.
I'm, my lord, extremely sorry, my lord, for disturbing you, my lord.
No.
Because, my lord, I have failed to understand what your lordship wanted to know. My lord, I have prepared the, my lord, supplementary affidavit, my lord, annexing all the documents, what happened. And also a list of dates is given, prepared, my lord.
Have you given copies to the other side?
Yes, my lord.
No. I just
Without copies, how can?
Today I have affirmed, my lord. Just today I have affirmed.
A supplementary affidavit and list of dates filed by the petitioner today be kept on record, which of copies thereof are being circulated here and now to the learned advocates for the respondents, full-stop, to enable learned counsel for the respondents to come prepared in the matter, comma, let the matter stand adjourned till tomorrow. Please come back tomorrow, take your instructions on this.
Short matter, my lord, because, my lord, your lordship wanted to know.
Adjourned till tomorrow, na day after tomorrow.
Day after.
Please come back day after tomorrow under the same heading. It will. I'm taking these on record. I'll hear on this. Thank you.
Copy list of dates. List of dates.
Yes, list of date and supplementary list, supplementary affidavit, both. Hand over copies of both.
Yes.
Sometimes this list of dates are argumentative. So better give copies.
Yes, Lord, the matter appear before 3 division bench. 3 division bench, Lord, my lord, Mrs. Chief Justice Ashok Kumar Mathu. He heard and long for some time. My lord, thereafter CAB, thereafter here. Thereafter another, my lord.
So I take a cue from that. I'll do the same.
My lord,
I'll do the
this
same.
is not the fault of the lawyer or the petitioner.
Not at all. Definitely not.
After
Whoever remains, it's the fault of
the
me.
lordship will be surprised to see one division.
Let me
bench-
take up the other matters. Mr. Jana had a hard press for time. I'm sorry.
Huh?
Yes, call on the next one. Call on.
Number 4.
Item 4 is my application, my lord.
Yes.
28.
My lord, I'm
10,
appealing for the
logically, lordship subject, the lordship.
I've
Lord, like it-
directed it to appear day after tomorrow. It will appear day after tomorrow under the same heading. Pardon?
10th August.
No, day after tomorrow. Yes.
My lord, I'm
Item
appealing for the respondent bank. My lord,
Yes. You want to say something?
yes. My lord, if your lordship allow me to read the last order of your lordship. My lord, kindly come to the order. Primarily, 2 points have been taken by the petitioner for challenging the willful defaulter identification of the first committee.
Oh, that.
Identification committee had passed the order, whereas the concerned Reserve Bank of India circular stipulates that there has to be at least 3-member committee. And secondly, the petitioner alleged that no prior so-called notice was issued to the petitioner. This is the 2 issues, my lord. My lord, I'm handing over to you the circular of the Reserve Bank, along with all the communications and so-called notice. My lord, if your lordships come to the circular. Close. Clause 5. My lord, clause 5. The second page, my lord. This is the
Clause 5C.
Yes.
Clause 5C. The order of the committee should be reviewed by another committee headed by the chairman, CEO, and MD of the consisting in addition to independent directors of the bank, and order shall be become final and after it is confirmed by the state review committee. It is under process. My lord, firstly come to the order.
His point
passed by
was the first committee order
Yes.
that was without jurisdiction being comprised of only one member.
My lord, no, there are 5 members, headed by 5 members. I am giving you the attendance sheet. 5 members.
So these have to come on record then. And what about the second point? What is your
And
stand?
the second point is the so-called notice. My lord, there is.
You say that
It
you
was
have
also-
issued a
it was
so-called.
also annexed. It was also annexed. My lord, this is the second point. So-called notice was served, my lord. On October 2022.
Actually, may I take
After,
1 minute?
Let me finish.
Sorry.
My lord, after the first order, initial order, we have twice communicated to the petition. Twice. 15 days time was given.
Let me hear him and I'll come back to you before passing any order. Yes.
Lordship, my learned friend has already summarized my case for me. But in addition, I will be taking up one more point that the order that has been passed by the Willful Defaulter Identification Committee is also an unreasoned order. I will take your Lordship through that. Your Lordship had already recorded 2 points that I had raised on the previous occasion.
What
I'm
reasoning
not
is
troubling.
required for this willful defaulter?
Lordship, a reasoning that
No,
is.
no, no, go before the review committee.
No, I cannot, my lord, because the order by itself is a nullity.
Why?
The order is a nullity because it has been passed by one member. That is the order. Your lordship looks at the order once, my lord. Lordship looks at the only annexure. Lordship, before I take your lordship through the order, may I just hand up 2 documents? This should have ideally come in my REIT application, but this could not because this was made over to me subsequent to the filing of the REIT application. I had filed an RTI application, my lord, asking for the copy of the show cause notice. And when the show
Keep
cause
it with you first. Show me the order.
lordship looks at the only annexure, my lord.
Yes.
Lordship, this is an order dated 2nd of June, my lord.
Hmm.
Lordship looks at the last. Lordship, perhaps this has been printed on the reverse side, my lord. I'm carrying another page for the order. Lordship looks at the annexure. Right after the affidavit page, my lord, there would be a letter dated 12th of June 2023.
Yes.
That is the covering letter. The page right after that is the order, my lord.
This is the
Without-
entire order.
This is the entire order. It's a 1.5 page order, less than 1.5 page. Lordship looks at the end of the order. It's signed by one person who is called the Deputy General Manager, dated June 2nd, 2023. First of all, they call this a reasoned order passed by the Willful Defaulter Identification Committee, passed by only one member in absolute contravention of the rules. I'm sorry, my lord, the Master Circular. This is the order that they are trying to defend.
Yes.
All members of the executive committee headed to the meeting. My
You
lord,
are
I have
producing
given the
another paper. It has to be reflected in the order itself.
My lord, there is no communication. Communication, my lord, says that there are 5 members headed to the committee meeting. All are agreed, one side.
Where is it? Where does
I have
it
given,
state?
my lord,
The
I have
order
given,
is-
my lord, the head of the committee.
The order
Up to page 19. That is the impugned order. Page 19 of the
Yes, my lord,
repetition.
I have the impugned order here.
You cannot improve it subsequently. Page 19 order does not say it's by 5 people. It only
But
gives.
it's signed-
It is only signed by one person.
Signed by one person, but the attendance sheet says here are 5 members.
Your attendance sheet, keep it with you. It has to be reflected in the order itself.
My
You
lord,
can manufacture attendance sheets anytime.
my lord, though it is in process, we have not.
What
yet
in
declared.
process?
Has to
This is
stand
a
or fall
palpably
on its-
bad order. This is not an order at all. The law gives you a priority. That does not mean you can do whatever with it. One person has signed it first. Secondly, it's not even cryptic. It's beyond that. Nothing has been stated here.
My lord, last.
Hence, it starts with hence.
No.
What no?
So, hence, my lord, is the second page.
That is what I'm asking repeatedly. Is this the entire order?
No, my lord.
This is the
No,
entire.
my lord.
Show me the entire order.
Please.
You haven't got a copy of the writ petition.
Yes, my, it's been served.
It's not the final.
Oh no, it
page.
starts from the previous page.
Yes,
The previous
yes.
page, my lord. I'm showing a portion of
You
the
have
free
annexed
page.
the second page first here.
That could be a clerical mistake. Lordship kindly pardons me for that. It starts, my lord, with on the heading, my lord, that it says order, but it does not take into account that all the 5 purported persons have signed in it. It's not mentioned anywhere.
My lord, kindly come to the guideline, my lord.
Yes, you want to add anything else? Then I'll come to you. Yes.
Lordship, yes, my lord. Excellent. Lordship, I was also carrying a judgment passed by your lordship that in a situation, there's only one difficulty, my lord. I have a copy. May I read out the relevant portion, my lord, only for your lordship? Consider, I'll hand up a copy to my lord's officer. Lordship, this is an order passed by your lordship in the case of Kejriwal Mining Private Limited.
It's
Lordship.
unreported. You have to give a copy to him.
I'll make over a copy, my lord. I'll make over the same copy.
What was held there? What is the
Lordship, only
proposition?
one paragraph, my lord, that the issue to be decided at the outset is the scope of interference by a writ court in the matter. Injustice is the key trigger for interference in whatever language couched. It may be in the form of violation of fundamental right or tenets of natural justice, or in the form of arbitrariness, gross miscarriage of justice, a patent illegality, or exercise of power by the state, its instrumentalities or entities discharging the functions of the state beyond their jurisdiction. These are various shades of injustice. The sum and substance.
That is not German at all.
No, to the extent, my lord, that once
that's a general proposition.
Then your lordship disregards the judgment. Lordship only hears me on the point that if an order is a nullity, it is absolutely non-est, then I cannot be made to go against the order before the
If it's
review
a
of-
nullity, yes.
If it's a nullity, in this case, it is passed without jurisdiction. Therefore, it would be a nullity. I cannot be forced to go before an
You
appellate
said without show cause notice, and only one person has signed it.
only one person has signed it, not by the quorum which has been prescribed by the master circular. Also, my lord, on a bare perusal, I'm not saying that the order has to be foolproof
Even
in
then,
terms of
lack of
reasoning.
reasons.
In terms of reasoning that a civil court would pass after evidence, but prima facie it has to disclose some amount of reasoning. Here they take into account whatever purportedly, my lord, was the ground for their show cause, without getting into the details of the matter or the facts of the matter. They decide that because I have not filed a show cause notice, there would be an adverse inference taken against me, and therefore the order of the WDIC is passed against me. They, even if I am not replied to a show cause, which is their highest case and my worst case, even in that scenario, they are duty bound to get into the factual reasoning, my lord. This is the third case which I had failed to bring to your lordship's notice on the previous occasion. I was handing up, my lord, 2 documents. These have been made over to me subsequent to the filing of the writ application. If your lordship deems it fit, my lord, I may file a supplementary affidavit. I had made a representation, my lord, under the RTI Act. I'm making 2 queries. One is whether a show cause notice was served upon me. What is the show cause notice? And if a show cause notice was served upon me, then when was it served upon me? These were my only 2 queries. My lord, in response to that, they reply, my lord, in which they say they answer the 2 queries that would be in the first page, my lord, which is the response of the Bank of Baroda. In reply, my lord, to my first query, any show cause notice dated 2012-2022 by the Identification Committee on willful default has been issued to me. They respond, yes. Then my second query, my lord, if yes, when was the notice, when the notice was sent? The response is the notice was dated 20th October 2022. There are no track reports. There is no proof evidencing that it's been served upon me. I was only bringing it to lordship's notice. I don't want to conceal these documents, but the fact that the show cause notice has not been served upon me, my lord, they have not been able to prove. I'm sorry, my lord, the notice has been served upon me. They haven't been able to. I will not be, my lord, be able to prove the negative that it's not been served.
Anything else?
These are my humble submissions.
Take it. Yes.
My lord. 2 queries issued, 2 issues framed. My lord, first of all, the RBI guidelines was in clause 5C. It says that the order of the committee should be reviewed and another committee headed by the chairman. There are 5 members headed. My lord, we have given you the attendance sheet, and one person.
Which clause of the circular are you
It is
reading?
in clause 5C. Clause 5C.
Yes, yes.
Page 2.
Should be reviewed. That is the review committee.
It is a review committee.
Oh, they have challenged. No, they have challenged the original identification committee report.
Oh, my lord.
That is clause
It is
3,
in
my lord.
Clause 5A. 5A. The evidence of willful default on the part of the borrowing company and its promoter, whole-time director at the irrelevant time should be examined by committee headed by the executive director and consisting of 2 other senior officers of the rank of GM and DGM. My lord, kindly come to the attendance sheet. There are almost 5 to 7 members. All are the same rank. We have twice communicated that order, twice. One on 12th June, then after 10th July. Not even a single reply they have sent, and now this is writ petition. All the track reports, consignment reports are there.
If the committee has to be comprised of 3 members,
3 members. DGM.
how can one sign?
My lords, all are agreed, one signed, but the attendance sheet says there are 5 members. My lord, take a look to the rank of the committee members.
Has to
All
be
are
reflected
exhibit-
in the order.
My lord, they are all agreed, one signed.
No, you cannot do that.
That is the instruction, my lord. All are agreed. And that instruction comes from the RM.
So,
Sorry, DGM.
so what?
My lord, it's a written in instruction from them.
Post facto. After the writ petition is filed, interim order is passed after then.
No, no, my lord. As per my queries, my lord's queries, I have inquired and they have sent it to
No,
me.
no. That has to be reflected in the order itself.
My lord, one dignitary signed, but all are there. All are there they are headed in the meeting.
Only deputy
My lord,
general
check
manager.
check the rank.
Very good. So this is a, and you say Shukaz you have served.
Yes, sir. 20th October.
Very good. These are all.
Grateful.
Yes, any reply?
30 seconds reply, my lord, that the order passed, any impugned order, my lord, either has to stand or fall on its own merit. They will not be able to supplement it. I'm not showing any judgment. It's a settled proposition of law. So at this juncture, my lord, the fact that it's not been signed cannot be supplemented by an additional document. So even if, my lord, I take their highest case for a moment without conceding, even if I take, for instance, my lord, hypothetically, that there were 5 members present, the fact that 5 of them has failed to sign on the date of passing of the impugned order, they will not be able to supplement that shortcoming at this stage. But either way, my lord, my submission would stand that there was only 1 member comprised of who has passed this impugned order. And because on the basis of that, because it's non-compliance of the master circular, the order is a nullity. Against an order which is a nullity, I cannot be forced to go and appeal, expect a fair appeal, which is passed, my lord, in an unfair trial. That is my stance. I cannot be forced to lose a forum. These will be my submissions. I'll not waste your lordship's time.
Learned counsel for the petitioner has taken 3 objections to the impugned order of the first committee identifying the petitioner as a willful defaulter. First of next para, the first ground is that no show cause notice was served on the petitioner prior to the passing of the impugned order. First of next para, secondly, comma, only a single person signed the said order, comma, although the RBI master circular concerning willful defaulters stipulates that there has to be at least 3 designated members of the said committee. First of next para, thirdly, comma, it is argued that the order does not contain any reason. First of, for the above, on the above grounds, comma, it is contended that the impugned order is a nullity and, comma, as such, comma, the remedy to go before a review committee available to the petitioner would be a mere illusory remedy. Full stop next para. Learned counsel appearing for the bank opposes such contentions and argues that in terms of the master circular of the RBI, comma, there has to be certain designated members, comma, 3 in number. Full stop in the present case, comma, by handing over a copy of a purported attendance sheet dated June 2, 2023 of a meeting of the Committee of Executives on Willful Defaulter, comma, it is argued that as many as 7 persons signed the same. First of next para, by stressing upon the designations of the said persons, comma, it is contended that the statutory conditions as stipulated in the master circular were met in the present case. Full stop, only the communication was made by a single member. Full stop, next para. Secondly, comma, it is contended that a prior show cause notice was duly issued to the petitioner. Full stop, next para. Insofar as the argument as to reasons is concerned, comma, learned counsel for the respondent bank argues that the same that comma in an order passed by a willful defaulter committee, comma, no detailed reasons need be given, comma, on the same footing as a civil code. Full stop, next para. Heard learned counsel for the parties. Full stop, insofar as the argument of non-service of show cause notice is concerned, comma, since the same is disputed by both the parties, comma, the same takes the nature of a factual dispute between the parties. Full stop, next para. As far as the argument relating lack of reasons is concerned, comma, the argument advanced by the bank is rather more acceptable, comma, since it is not expected that a willful defaulter identification committee will give detailed reasons. Full stop. In the present case, comma, in the impugned order dated June 2, 2023, comma, it was recorded that the show cause notice was issued on the grounds as stated therein. Full stop. The ground was that as per the unit inspection dated July 19, 2022, comma, the unit was found closed and no stocks available. Full stop. The firm had disposed of the stock without informing the bank, and proceeds of stock sold is not routed through cash credit account but diverted the funds. Full stop, next para. It is further stated in the said order that even after service of notice, comma, no representation was received from the borrower stroke guarantor against the show cause notice. Full stop. In such view, comma, it is mentioned, comma, the committee of executives within bracket COE bracket closed was of the view that the borrower stroke guarantors have nothing to submit against the charges leveled against them in the SCN. Full stop. In the light of the said facts, comma, the committee was of the view that the borrower stroke guarantor had indulged in act of willful default as per RBI guidelines on willful defaulters. Full stop, next para. As such, comma, it was observed that the unit had defaulted in meeting its payment stroke repayment obligations to the lender and has not utilized the finance from the lender for the specific purposes for which finance was availed of, but had diverted the funds for other purposes. Full stop, next para. On such grounds, comma, the committee observed that the petitioner is a willful defaulter. Full stop, next para. Insofar as reasons are concerned, comma, I do not find any dearth of reasons, comma, since the committee adverted to the allegations made against the petitioner, comma, the fact that the petitioner had not responded to the show cause and also touched the main allegation within the contemplation of the master circular, comma, which was leveled against the petitioner prior to labeling him as a willful defaulter. Labeling him na kore it kore daw. It as a willful defaulter. For subnext para, however, comma, insofar as the third contention of the petitioner is concerned, comma, the same carries sufficient weight. Full stop. The master circular of the RBI on willful defaulters, comma, in clause
3, my lord.
Within bracket small Roman 5 within bracket small a stipulates that the evidence of willful default on the part of the borrowing company and its promoter stroke whole-time director at the relevant time should be examined by a committee C capital. তারপরে টাইটেল লিখে করো, headed by an executive director ED capital and consisting of 2 other senior officers of the rank of GM stroke DGM. Full stop, next para. Although the bank has alleged that there were as many as 7 members of the said meeting, comma, including the persons required to to form such a committee as per the RBI guidelines, comma, there is no reflection of the same in the order communicated to the petitioner. Full stop. The said order clearly depicts only the name of the Deputy General Manager, comma, who is described as a member of the Committee of Executives on Willful Defaulters, comma, who is also the sole signatory therein. Full stop. Nothing in the said order reflects that the other committee members, as per the master circular, were present and signed the said order. Full stop. Next para. Although the text of the order itself indicates that the decision was taken by the Committee of Executives, comma, in the absence of any reflection of the views of the other members, comma, mere subsequent production of a list of attendance, comma, which purportedly indicates that the relevant portfolio holders were present, comma, cannot cure such incurable defect in the order. Full stop. Next para. As such, comma, on such ground alone, comma, the order is palpably vitiated. Full stop. Next para. As such, comma, the remedy available to the petitioner, comma, to go before a review committee would, comma, as rightly contended by the petitioner, comma, be merely an illusory remedy, comma, since there was no prior adjudication worth the name by the first committee, that is the Willful Defaulter Identification Committee, comma, within double inverted, review, double inverted close, would be contemplated by the second committee. Full stop. As such, comma, the impugned order dated June 2, 2023 is set aside. Full stop. It is made clear that nothing in this order shall preclude the Willful Defaulter Identification Committee to give a fresh hearing to the petitioner and to decide afresh on the declaration of willful defaulter in respect of the petitioner. Full stop. Nothing in this order shall prejudice the rights of either of the parties, comma, if such a fresh undertaking is if such a fresh exercise is undertaken. Full stop. Next para. Insofar as the writ petition is concerned, comma, in view of the considerations in the present order revolving only around questions of law, comma, no affidavits were directed, and, comma, as such, comma, it is deemed that none of the allegations made in the writ petition are admitted by the respondents. Full stop. No address to cause urgent certificate.
I'm deeply obliged, my lord.
The documents handed over in court today be kept under. Thank you.
I'm grateful, your lordship.
Item number 5.
Yes.
I appeal for the respondent number 1.
Friendly disposal. Yes, Mr. Bhattacharya.
I would say that this is a civil dispute. If your lordship straight away comes to page 162, though I am the Union of India, my lord will kindly come to page 161, the order.
Carry your with me, not of the respondent.
I'll leave that. At 163, if your lordship kindly comes, my lord.
I would like to file an affidavit. This is that matter which was taken up for 10 minutes on, I think, last week.
My lord, I will be pressing for interim order. So therefore, my lord, this would be admitted on affidavit for hearing. That's one aspect. And so far, my lord, the interim order, I will be just trying to. My lord, with your lordship's leave, I'm filing a supplementary affidavit. One document.
My lord, this I was objecting to. My lord, lordship may kindly see the petition on the face of it before placing reliance on this. We have not been served. If the petition
not been served,
I'm giving a
the
copy.
supplementary.
Supplementary, I'm giving copy.
My lord, if the petition falls on the face of it, it cannot be supported by sub. This is the second. Earlier they filed a writ withdrawn because of some error. Now this is the second writ. Now second writ before moved supplementary. This practice should not be. Should be deprecated. If the petition stands on the face of it, kindly hear my learned friend.
All right. Lordship, my lord, let me, your lordship, proceed. And I will not right now. Your lordship, keep aside, your lordships.
এটা এখন ফেরত দিয়ে দিন, এটা পরে নেবো।
এটা নিয়ে নিন।
Yes.
Affidavit service charge. The affidavit of service we kept with the record. Now, my lord, straightway come to page 100.
You are sure this is not a civil dispute?
No, no. This is page 100, your losses kindly come.
100.
Now, my lord, your losses will find
Yes.
this is, my lord, page 101, your losses. Kindly, well, I'm sorry, page 101.
Right.
Well, this was addressed to the petitioner and his late father, my lord, and the mother. Your losses will find this is the assignment. Your losses, kindly, your losses, consider this was issued by my learned friend's client, the respondent number 8, restructuring company, asset restructuring company. Your losses will find the amount at the 3rd paragraph. I'm just on the amount.
You are the borrower. Who are you?
Well, I'm nobody. I'm neither a borrower, I'm neither a guarantor, nothing.
What have you challenged here?
I challenged here your losses, my lord, act on the part of the asset risk reconstructing company in deviation of the fair guideline, trade guideline. And for that, I'm asking immediate suspension of the licensee and license and ultimately the cancellation of the license.
What is your locus standi, Mr.?
My locus standi, I tell you, losses, I'm a owner of the property. Well, there was an agreement for sale. Always. Well, there was an agreement for sale with respondent number 12 and 13. Well, in furtherance of the agreement of sale, I handed over the deed to the 12 and 13. And, my lord, a portion of the ground floor possession I handed over. This much I had. Now, subsequently transpired, my lord, by using a forged deed in respect of one Tirupati and in respect of one Kadambari, from the two of the banks, my loan was taken. One UCO Bank and one Punjab National Bank, Erstwhile United Bank. Now, it went up to the anti-fraud section. Both the anti-fraud section has filed a report saying both the deeds were forged. And the basis of the forged deed, the asset reconstructing company, in deviation of the fair trade practice, have extorted the money to the tune of rupees 2 and 2.5 crore. 1.5, 1.46 and then others.
From whom?
From myself.
Because I have to save my property.
To save my property. That's my case.
Why did you pay up? I mean,
section 14 notice was issued. Possession was taken. That's your losses. I'm to say right now, what fraud the respondent number 8 have committed. Well, learned friend is clamoring for that.
After coming to know, after the charge sheet, I have filed a suit for
Well,
recovery of the money.
that's your losses. Another. Your losses kindly.
you are asking for a cancellation of the license now.
Yes, your losses.
Why the writ petition?
Well, because I have prayed for before the Reserve Bank of India under the act. They have the they have the right.
They have refused.
No, they are not considering sitting tight. You losses see the attitude of the Union of India. They are coming with that.
That I can make loose. That I can make loose.
Now your losses will therefore.
But should I, adjudicate it here? This will be the first forum then.
This is the first forum.
This will be the first forum if the Reserve Bank of India does not decide it.
They have not yet. Till such time, the decision whether, my lord,
apparently this requires some factual inquiry. Some factual inquiry. Your allegations are entirely facts. If you are right, maybe you have got a good case there.
Factual inquiry is complete. If I complete your losses.
Very well, let me.
Your losses, kindly will look at your losses first.
Page 101.
101. Just 101, kindly see the amount. They have given, my lord. This is a notice, your losses, page 101 and 102. Release of personal guarantee of Bomkesh Bhattacharya, my father and his law legal heirs for various credit facilities advanced to Kadambari Steels. Your losses got it. Then your losses. United Bank of India had assigned agreement. But I will take your losses immediately thereafter. 23rd September 2009 assigned the financial assistance granted to Kadambari Steels Limited, together with underlying security interest to Pegasus Assets Consumer Government Limited as the sole trustee of Pegasus Group of 6 trusts under Section 5 of the SABYASACHI Act. Pegasus, on the basis of the powers and rights vested upon them as per the provisions of the above Act, is pleased to release or discharge Bomkesh Bhattacharya and his all legal heirs from the personal guarantees dated such and such, given to the United Bank of India for various credit facilities advanced to Kadambari Stills, the above personal guarantees are being released subsequent to payment of 1 crore 21 lakhs and odd. Now, this is the amount they are mentioning. Pegasus and its predecessor in the United Kingdom will have no further claim on the late Bomkesh Bhattacharya and his legal heirs arising out of financial assistance given by the United Bank of India in the above account, which stood transferred in favor of the Pegasus. But kindly see what amount they are asking for transfer. You have also been satisfied that the Pegasus is the successor. Pegasus is receiving, then your losses in premises number and the signature of the authorized officer. Now your losses, kindly have a look at the assignment agreement. Your losses will be getting it at page P16. I'm gonna write your losses. The P16 at page 128.
Right, copy at 128.
Mr. Shanal will continue after 10 minutes.
All right.
Yes. 128.
Yes, may I? What I was placing your lordships, page 101 and 2.
Yes, that you have placed.
That I have placed before your lordships.
Yes.
And then
128, yes.
128. Straight will come to us. Kindly see, my lord, what's the amount assigned to the Pegasus by the bank? And I will take your losses to the assignment agreement also. The amount was, your losses, kindly have a look at this, 51,56,800.
So balanced.
This is balanced amount. Therefore, kindly your losses date is 16th March 2006. And your lordships, kindly have a look at page 101 for once. Right? Giving trouble to your lordships because of checkered history of the matter.
Yes.
This is updated after 6 years, 16th February 2012. So the amount which was assigned by the bank to the restructuring company is 51 lakhs. This becomes, my lord, they are claiming total amount 1 crore 21 lakhs. Kindly have a look at the assignment agreement. That starts at page 132. I need not take the entire assignment agreements, prototype agreement. I will be only the assigned amounts at page 151. Your losses will find, so for the first column, Amma Foods, then second one, Kadambori Steel. Your losses, kindly have a look at this up to 2009. With interest, what was the amount assigned? 67 lakhs 0.23. Now, therefore, my point before your losses, how could they claim, being an asset reconstruction company of the bank, the original 1 crore 21 lakhs?
1 crore 46.
46 lakhs. So therefore, my lord, this is the fraudulent act or unfair trade practice by an asset reconstructing company. That is only for the, my lord, purpose of interim prayer before your losses.
What is the interim prayer, by the way?
My lord, I'm asking that if this is the way the financial institution acting with the public property and money, my lord, they should not be allowed even for a moment to carry out their business.
That, Mr. Shanal, would be a very high interim prayer. Unless we take.
I'm coming to that. My lord,
this
this is your lordships. Well, this is in regard to second transaction in respect of the same property. There is another transaction. Your losses can look at that at page. My lord, 85 your losses will find. But not 85 is required. Your losses kindly straightway come to page 87. The same property deed by way of forged deed, another transaction with another bank was made by another Tirupati company limited. That's UCO Bank. This is UCO Bank, and there are other first one I showed to your lordships. That's PNB, Australia United Bank. Kindly have a look at this order, my lord. We were
PNB with Kadambori and UCO with Tirupati.
Yes,
UCO
with Tirupati. Both banks claiming myself to be a guarantor.
But the property remains the same.
Property remains.
Now your losses, kindly have a look at this, or might just place it to your losses. Kindly skip over the first few small paragraphs then. From the record so maintained in the present proceeding, it appears that on September 13, 2004, the appellant bank has preferred one application under section 90, subsection 1 of section 19 of the Debt Recovery Act against the 3 defendants, one of whom the defendant number 1 is the proprietorship firm under the proprietorship of the defendant number 2. But the entire controversy has given rise to the petition preferred by the defendant number 3, well, that is my father, brought on record as guarantor by the appellant bank. For the said defendant, Mr. Paja Learned Counsel has appeared and made an extensive submission on 3 categorical points, namely, the defendant number 3 who has been brought on record is not at all a grantor. 2, the signing or the execution of the letter of guarantee has not at all been executed by the defendant number 3. 3, the legal notice already issued under subsection 1 to section 13 read with section 2(1) of clause F as well as JLI of the Securitization Act 2002 upon the defendant has been strongly striven to be assailed off by the said defendant because of the predominant condition essential for the issuance of such notice, that since he does not qualify to be a borrower on account of non-creation of the security interest, an expression finding it used in the definition section of the Act, declared as the valid piece of legislation in the recent pronouncement by the apex court of the country, no room has been left for the bank to enforce its statutory foreclosure in respect of its dwelling house being illegally claimed as the security interest by the bank. Then your losses will kindly come. Then your last paragraph of the page, 88. After taking into consideration of the detailed submission made by the learned senior counsel, as well as bearing into mind that the relevant portion of the order, particularly made on September 28, 2004, it appears that the original title deed of the property at premises plot number 37B, which is actually the dwelling place of the said petitioner come the defendant number 3, has been the matter of disclosed judicial scrutiny. Not only that, the investigating officer of the CBI has also submitted before the said honorable court that the Xerox copy of the original title deed of the suit property, which is at present lying in the possession of the said petitioner defendant, it shall appear clear from the order made on September 28, 2004. Then your losses. In addition to the above, Sri Paja, the learned senior counsel, has also laid stress upon bringing on record Sri Lodha, as well as Lodha means respondent number 12 and 3, with whom I entered into an agreement for sale of the ground floor of the property. That's page, that last part, your lordships, is the present matter. Accordingly, the said defendant is being advised to make one application in this regard. Then your lordships kindly come up to the last paragraph. Then
the CBI investigation was at the instance of, on whose complaint?
At the UCO Bank manager.
Regarding
this, the same deal. Then your lordship kindly come to
both the loans were assigned to them, to Pegasus.
No, one Pegasus and one respondent number 9. That's your loss asterisk. Now your losses
according to you, the banks were not involved. Only the asset.
That's obviously informed. I am asking ultimately for that, but the first
they've also sought an injunction.
Yes.
The banks not to operate.
Also, I
them at on personal ground. All the banks also.
Yes,
Banks
they
also.
can always be closed.
No, I tell you, lordship, this is a peculiar case.
But this has to be looked at.
But then kindly look at it.
But before, at interim stage, Mr. Chandan, that would be too tall.
I am confined myself to reconstruction.
Not because of the names of the banks, but because they're functioning national banks.
I have prayed for, but I am pressing only in respect of respondent number 8 right now.
Anyway, let us
because they have ultimately realized the matter. So for respondent number 9 could not. Now your losses kindly page 90, the operative portion.
The CBI investigation.
I'm taking your losses to that, your losses.
The status is just as the other investigations.
Ultimately, anti-fraud section of the West Bengal police has said both the deeds were forged. If both the deeds were forged, I put a question to myself. Who executed the documents of the guarantee before the bank? Those must be forged. Now your losses kindly page 90, the order, interim order. Till further order is made, both the applicant petitioner as well as the appellant bank shall be refrained from taking steps in the form of parting with or dealing with any form the property dispute in 37B. Now, this is in respect of UCO Bank. In
that
point
is subsisting now.
I'm coming to that. On the point right now, this is your lordships in point of time earlier transaction, forged transaction. The documents I have placed, this is on latter point of time.
All right.
So if this is point of time earlier, kindly visualize the same property is being used by another forged deed in respect of another bank transaction. Kindly see the magnanimity of the rather, what should I say, the fraud. This is the step was directed by this authority that in respect of the nothing, in respect of one bank, of course. But the same property is being used by creating another forged document in another bank. Now your losses kindly come to the report, page 169.
Property seems to be very lucrative. Location from the location.
Location, I believe your losses.
I don't know. I mean exactly.
Kindly have a look on page 169.
169 is.
This is, my lord, in regard to the criminal case initiated at the my lord. At the instance of the bank, your losses kindly have a look page 169, 170. I will be your losses 171.
FIR 115
Your losses kindly will look at 115 plus first. 115.
Once I give him the money.
Page the ball. 115. Now your losses, my lord, this is the FIR.
Yes.
My lord, your losses kindly considered from, my lord, the Debjyoti Bhattacharya to the Deputy Commissioner of Police. That's my FIR. Now your losses kindly come to page.
This is regarding which transaction, UCO or PNB?
My lord, in respect of both.
Acha, very well.
Both. In respect of both.
Primarily, আমি বলছি যে Pegasus আমার থেকে টাকাটা নিয়ে নিয়েছে।
But ultimately, your losses kindly, my lord, keep in your losses mind. Ultimately, money was extorted from me by my learned friend's client Pegasus. That's point number 8.
And what about the UCO?
Well, that's they have not yet. Lord, I'm coming to that. That's their proceeding is still going on. Execution.
That has been given to assigned to some other reconstruction.
Other reconstruction. That's respondent number 9.
All right.
Now, my lord, on the basis of this, your losses.
Sharma is for Pegasus.
Naturally.
Yes.
Naturally.
Now you are saying. Yes.
My lord, 169.
169.
Your losses kindly skip over 169, 170, and then come straight to my lord 171.
171. Yes.
The brief fact, well, this is from anti-fraud section of the
final report.
Final report. Well, this is final report being filed in connection with my FIR. The brief fact of the case is that the FIR named accused persons and the others entered into a criminal conspiracy to deprive the complainant of his legitimate rights and in pursuant thereof have prepared forged deeds in respect of property number such and use those forged documents as genuine to obtain loan from UBI such and UCO Bank such and such, causing wrongful loss to the complainant and wrongful gain to themselves and thereby committed offences under such and such. During investigation, relevant documents were seized, including one title deed, wide such and such number with 2 copies in respect of the premises number. During investigation, several attempts were made to trace out the 2 companies styled at Kadambari Steel and Tirupati Textile, in favor of which loans were obtained from United Bank of India, Park Street branch, and from UCO Bank Sambajar branch, respectively, by using forged title deeds. But those companies and concerned responsible persons could not be traced out. Well, can you also fathom it? How long the hands goes? Then you'll see the DRT3 Kolkata and Messrs REC India Limited failed to provide all the loan documents as loan guarantee documents in original in respect of the loan from UCO Bank, Sambajar Bank, as those of the documents are not available with them. But can the bank say it before your lawsuits now? The loan documents are not unless the bank itself involved.
You are for the bank.
I'm
Which
for
one?
only UBI, PNB, not UCO Bank.
You are not for?
UCO Bank.
You are for PNB.
I'm for PNB.
And DRT.
Now, senior lawsuit. So those could not be seized and sent to the experts for examination and opinion. During investigation, the LICI authority was contacted, and on being asked, they stated that amongst the 3 seized title deeds seized from Piyush Lodha is the original one. Pause here for a moment.
Why LICI?
I purchased the property from LICI. That deed as I told you, lawsuit handed over to Mr. Lodha in furtherance of agreement for sale.
Naturally.
So therefore, your losses, that deed, this officer says this is original one. So it is pertinent to mention that the title deed used to get loans from UCO Bank, Sambaja branch and UCO Bank Past Street branch are forged deeds. During investigation, the documents in question, including 3 title deeds of the same property, loan guarantee papers in respect of loans from United Bank of India Park Street branch, along with admitted handwriting signatures of Bomkesh Bhattacharya, since deceased, was sent to the experts for examination and opinion. The expert opined that the signature of Bomkesh Bhattacharya, since deceased, in the loan guarantee papers of United Bank Park are forged signatures.
My father's signature.
My father's signatures were forged in obtaining the loan through the United Bank of India.
So the guarantee.
Other bank documents are not available. Then moreover, after several attempts, the responsible persons of United Bank of India Park Street branch and UCO Bank Sambajar branch in respect of those loans could not be fixed up.
Can the police?
But can the police say it, my lord? That cannot be fixed up. Then who would fix up, my lord, this responsibility? The police also wanted to somehow close it. Kindly look at the next year lawsuits. Therefore, the offender who made the forgery could not be fixed up.
What do they mean by fixed up exactly?
That's my lord, except they my lord, relieve me by saying that all the deeds are froze, documents are
We have
frozen.
Freudian slip sort of.
That your lordships.
Anyway,
Then your
so
lordship,
they could not be fixed up, yes.
though there are clear evidences.
Oh, investigation was closed.
You're close. Well, kindly see the language, your losses. So I'm taking your losses valuable time. Though there are clear evidences of the offense of forgery in respect of title deed of the premises number such and loan guarantee papers in respect of United Bank of India Park Street branch. It is pertinent to mention that offense took place a considerable time ago. During investigation, sufficient evidences could not be collected and found in support of the allegation made in the FIR against the FIR named accused persons.
No, where are you reading now?
Malad, page 172.
172.
That,
yes, yes.
Then the last paragraph, under such circumstances, investigation into case is closed, declaring as final report. FRT and FIR named accused person named Piyush Lodha, Parameshwari Devi Lodha, Animesh Mitro, Indonil Chatterjee, Rajiv Nair of Pegasus and Assets Construction Limited, and others discharged from the case for want of sufficient evidence. Kindly see the way the police, anti-fraud section.
Achha, Pegasus came into the picture later. So why do you want to fix up liability on Pegasus only?
Pegasus,
why not the
I
bank?
tell you losses. They realize the money ultimately on the basis of the forged documents. And Pegasus is the agent
That
of
does
the
not
bank.
necessarily mean they were responsible for
No,
the
I tell
forgery.
Forgery, and your losses. I will see that they have placed before
Forgery was committed. They took it. I mean, they may have been in the knowledge of the forgery or not.
They are.
How can you fix
They are
responsibility?
ultimately the beneficiaries of the proceeds of the crime, knowing it fully.
And knowing it fully, how can you get?
I'll
Show me that,
I will
please.
show. Now your losses, my lord, kindly look at.
This PNB appears to be responsible for this.
Yes. Now I tell you losses, I have placed two documents with your losses. The assigned amount was 67 lakhs and odd. They are claiming 1 crore and 20.
That's true, yes.
This is one of the indicative of the fact. They are the, my lord, beneficiary of the entire transaction.
That does not necessarily relate to the fraud or forgery. I mean, they may overclaim. That may be a different offense. I mean, they are claiming something which they are not entitled to. That does not necessarily, that cannot link them up with the forgery necessarily.
Even if your losses take it, I get your losses fine. Even that, well, today I am asking for suspension of their license.
Because this is a penal sort of consequence.
I'm coming to that.
That's why I'm very careful on that.
I'm coming.
We have to be.
Now, take it, my lord, granted for to that extent. Now, what they did, my lord, they committed an unfair trade practice.
By asking for more amount.
Own amount. On what basis, my lord, I'm putting a question to myself.
Very well.
This is one thing. On that, your losses, the Reserve Bank of India have the power to cancel the license. That I have made a representation.
Yes, definitely.
That's pending. This is one sort of.
What about the CBI thing? That's still going on. Police closed investigation.
Anti-fraud section.
Anti-fraud section was parallelly.
They have also closed.
That has not been informed.
They are not being informed, but I've come to know they have also closed. Let's say
There were independent investigations going on by the anti-fraud section and CBI.
Anti-fraud section because of my FIR. And so for CBI, your losses, so far bank is concerned.
The bank against this manager.
Which bank?
My lord, UCO Bank. My lord, your losses only one thing. Your losses kindly, my lord, possession notice, your losses kindly take for 94 page. The other point, I just to meet your losses point.
Yes.
They knew about it. 96. 94.
Immediately I protested.
Well, they gave a possession notice, your losses kindly take after the assignment. Page 13.4, page 94. Well, kindly see the date, 27th September 2010.
Yes.
Now your losses kindly come to the very next page, page 96.
That is the very, very next page.
Very next page.
Yes.
Well, kindly see the last paragraph of the page 96. This is addressed to first your losses, kindly see. The authorized officer of Pegasus Assets. This is updated 16 September 2020. 2010. Malad, your losses, the possession notice.
15 September.
15 September, Malad, your losses will find your possession notice dated 15 September 2010. I have addressed your lordships in the letter.
You are writing to the authorized officer.
Authorized officer. I put him on notice. Your lordships, kindly look at the last paragraph. My client does not know Mrs. Kadambari Steel Limited or any of its directors, nor had any transaction or nexus with the said company.
Next page, next page.
Next page, your lordships, kindly come to. My client did not agree to stand as a guarantor to any loan in favor of Kadambari Steels. My client did not sign, execute, or agree with any deed of guarantee or loan agreement. Thus, my client is not connected or liable to pay any loan to UBI Bank or to you. It is pertinent to mention here that the original title deed of premises number such and such was submitted before the DRT3, which is pending for disposal. Therefore, no question of further guaranteeing. That's why your lordships, I took your lordships the first order, 2004, in regard to UCO Bank. The first point of time, the transaction, I submitted the original document to the DRT3. Then how could there be another loan transaction in respect of the same document? Unless this is forged one. Self-employed, obviously. This need not be told to the Honorable Court. So therefore, my lord, kindly see whether they are not, my lord, entitled, my lord, involved in this transaction or not. They are very much involved. So I put them on notice. Even then they proceeded with that. They could have stayed their hands. Now your losses, I tell your losses.
This is a defense which you take, Mr. Chandal. This is a defense which you take by way of a letter. That need not deter the asset reconstruction company from proceeding with 13.
Therefore, your losses.
Everybody will take some defense or the other.
No, the defense or other.
Because you are asking for their operations to be stopped. That's why I am asking. Do they necessarily relate to their part of
they continued with that proceedings even after they put on notice. After they put on notice, they continued with that.
And during this entire period, the CBI inquiry was going on, or that started later?
CBI inquiry, I have not been informed anything. So far, on my FIR anti-fraud section, your losses can get.
Anti-fraud section was going on at that point of time?
Yes.
During this exchange of person.
Thereafter, immediate your losses can happen.
After the anti-fraud washed their hands, after that this happened?
No.
During that.
During that. Entire thing during that. Now your losses kindly see. My lord, after all this, I have filed a suit for recovery of money from the Pegasus. This is your losses. Kindly consider.
You paid the entire 1 crore something?
Yes. Entire.
And
my possession was taken. I was thrown out of my house by Pegasus.
Now you have got back possession.
Got back possession.
And filed a suit.
And filed a suit for recovery of money. But kindly, there are 2 orders at page 250 first. আসছি আমি তো পরে দেখি
লোনের ডকুমেন্টে কি মর্টগেজ ছিল
আসছি একদম দেখি মানে 250 your losses kindly consider.
Yes,
this is your losses. The first order, the ex parte ad interim order of attachment before the judgment under the provisions of order 38 facts remarks from the pleadings is alarming and raises several issues which are of seminal importance under trade and commerce and of the banking activities in securing or extending loan facilities upon the deposit of title deeds as security and standing as a guarantor. The appellant is admittedly the owner of the premises number such and such. At one point of time, intend to transfer and alienate or sell the property to the pro forma respondent number 5 and 6. An agreement was entered into, and in furtherance thereof, the original title deed of the property was handed over to the aforesaid intending purchaser. Subsequently, a proceeding was initiated by the UCO Bank before the Debt Recovery Tribunal seeking release of the amount advanced as a loan against a third party. The default had taken place and the attempt was made to realize the amount. And as the title deed of the said property was allegedly put as a collateral security and or mortgage with the bank, the appellant sought for his implement in the said proceedings. Pursuant to such intervention at the instance of the appellant, an order was passed upon the said respondent number 5 and 6 to produce the original title deed, which was handed over by the appellant in pursuance of the agreement for the sale. The said title deeds were produced before the Debt Recovery Tribunal and was kept on record. To protect the said deed, a suit was instituted by the appellant where an order of temporary injunction was granted not to give such title deed to anybody. The said suit ultimately culminated into dismissal for default, but it is a specific stand of the appellant that the said title deed was subsequently handed over to him and he is in possession thereof. Interestingly, the appellant was served with a notice under Section 13(4) of the Securitization Act, alleging that being a grantor and having deposited the title deed of the said property, he is jointly and severally liable for the loan amount advanced to the principal borrower. That led the appellant to take immediate steps by lodging a first information report alleging that the original title deed, which is in their possession, was never handed over nor put as a collateral security or mortgage with the bank for securitying the loan in favor of the third party. Since no progress could be seen on the basis of the said first information report, as no investigation was contemplated, the approach was made to this court by filing a writ petition. It appears from the record that during the contemplation of these to initiate proceedings at the behest of the respondent number 1 being the assignee of the United Bank of India, the appellant, in order to protect the ancestral property, deposited a sum of rupees 1,46 lakhs. In the writ petition before the division bench, the aforesaid fact was disclosed, and after noticing that a serious fraud has been committed, the direction was passed upon the police administration to investigate the issue as disclosed in the first information report filed by the appellant. And simultaneously, a liberty was granted to the appellant to file a suit for recovery of amount, which was deposited with the respondent number 1. Our attention is drawn to the final report submitted by the investigating officer, wherein it is categorically held that the deed submitted with the United Bank of India is forged and fabricated. But astonishingly, the case was dropped as the identity of the person being a beneficiary of the loan amount could not be traced out. The moment the investigating officer arrived at the conclusion that the deed relied upon by the bank is forged and fabricated, the present suit was filed for realization of the amount which was deposited with the respondent number 1 as the assignee of the United Bank of India. Such being the startling facts revealed from the record of the instant case, we do not find any justification in the stand of the commercial court that no interim protection can be granted at the ex parte stage until the defendants disclose their stand. In other words, it is held that the provisions contained in the order 38 of the Code of Civil Procedure is drastic in nature, and therefore the court should not be swayed by the ipse dixi of the pleadings filed by the plaintiff unless the defense is disclosed by the contesting defendants. There is no quarrel. Well, then your losses, kindly see the interim order granted by the court below. Accordingly, your lordship, page 254. Accordingly, the respondent number 1 is restrained from withdrawing or dealing with the money. My lord, just a minute. My respondent number 1 means Pegasus. The money account to the extent of 1 crore for shall remain intact in this for a period of 8 weeks. Now, my lord, kindly see the next order. When this was for a limited period, when the extension came, my lord, for extension the matter, they appeared. They opposed for extension. Well, kindly have a look at the order at page 256. My lord, the first paragraph I'm just keeping over your lordships, kindly see. Though the interim order was passed in presence of some of the contesting respondents who appeared at that point of time, but today the respondent number appears and raises a vehement objection to the extension of an ad interim order, which according to it was passed in its absence and therefore to be construed as an ex parte and interim order of injunction. We have no quarrel to the proposition of law. Then the second paragraph is very, my lord, kindly see the prima facie finding of the division bench. 257 page. The matter has a checkered history. The facts discerned from the record are not only alarming, but daunting to us, having a larger impact on functioning of the financial institution, dealing with the public money, while advancing a loan to a person on the basis of a security being put, which subsequently discovered to be an outcome of fraud and forgery. Then, my lord, the entire arguments was, my lord, their contention was considered. My lord, the next paragraph also, your lordship, the sordid state of affairs can further be manifested when a first information report was lodged by the plaintiff appellant with the police officials for investigation, which ultimately proved to be a mere paper, as the investigating officer, even after noticing the serious fraud and forgery having been made, does not find sufficient materials to arrive at a conclusion that there is a cognizable offense committed by the person named as accused therein. The final report revealed the closure of the investigation in the absence of any sufficient materials found against the named accused, although the contents thereof revealed otherwise. Then, your losses, the court dealt with the contention of the respondent
Have you
number.
taken any steps regarding the closure of the investigation?
I have not. No, I have
That rests at that.
That's they have not also challenged that the force.
What will they say?
No, your lordships. Then certainly. Then your lordships kindly consider the last page of the order.
Yes.
At 270.
Mr. Shanal, first of all, you have not prayed what you were asking for. That interim order is not there in your prayers.
Yes, yes.
That's entirely regarding the debt recovery proceeding, not proceeding and all this.
No, your lordships kindly will look.
They are functioning. One. Secondly, as of today, the investigating authorities, agencies have closed the investigation. Good, bad, indifferent. There are certain aspects against them. Yes, findings by civil court. I appreciate that. But how can we close their functioning at this point of time? I mean, being the writ court, if the investigating agencies themselves have closed the investigation, we cannot proceed on the presumption that they are corrupt and all these things. Even if they are corrupt, we cannot take that presumption.
No, these are for these facts at least admitted. They have also admitted.
I mean, how can we stop their functioning at the ad interim and that prayer you have made?
Yes.
Prayer?
Page I just. Prayer G.
Yes. Suspend the license of it. This prayer I won't grant it.
This prayer I have.
Investigation has been closed against them. At least against this Pegasus.
No, not another FIR thereafter has been filed with the
409 of the
409 of
fishing out FIRs.
That's similar. Now let us stand as the facts.
Whatever we have on paper.
On papers. Now, ultimately it was found by the anti-fraud section the deeds are forged one.
Yes, but their involvement
I am
is
coming
not
to that, Malad. Therefore, Malad, I took an exception as soon as they gave the possession notice. I took the notice that this is the thing I have. Now, if they realize the money,
you have a good case in the debt recovery proceeding apparently, and in the civil case also.
My civil case, that's realization of money. Realization of money. But
even then, yes,
that's the realization.
Oh, that's on a different aspect.
This different aspect. But the other aspect, Malad, if a financial institution take recourse to the unfair trade practice, what would be the consequence?
Can you decide that at the ad stage of a writ petition, Mr. Channel? Unfair trade practice.
I have made a complaint to the Reserve Bank of India also.
That can be decided, yes.
That they have not taken any step. Kindly see the link between the 3, 4.
Suppose I direct affidavits in this matter, Mr. Channel. It is coming up at the hearing stage. What best can we do? I mean, sitting in a jurisdiction.
But your losses can.
Because your debt recovery relief is before the debt recovery tribunal, which you are on a very good footing probably. Because if those documents have been observed to be fraudulent and all these things, you have a good case.
I'm all on that. Suppose affidavit discloses. Now, one thing transpires before your losses, at least.
Yes.
Banks are involved. Who gave the deeds to the bank?
Appears to be so, yes.
Who did give the deeds to the false deeds? Therefore, I will be extending or advancing my argument to this extent. These are all the state agencies.
Mr. Channel, there are criminal procedure code provisions by which you can reopen investigation. There are provisions.
I'm on constitutional provision.
Constitutional provision, yes, everything is constitutional.
I appreciate what I'm saying.
And everything pertains back to right to life. Whatever, under the sun.
Today I'm on that. Ultimately, your loss of relief, what can I ask for?
Yes, I am wondering about that also.
That's your losses. This is a constitutional tort.
Yes.
Why I'm saying this, your lordships? Admittedly, I have not created any mortgage or collateral security with my property. As of today, it transpires that both the deed used for taking loan in respect of my property are forged one.
Mr. Channel, if I was the criminal court, appropriate criminal court, probably I would have thought about reopening the investigation. I'm being very candid to you. At least on the documents which you have placed up to now, subject to hearing the other side. I could have directed the reopening of the investigation. At best that. But being in a writ court, I cannot.
Court can also do that, your lordship.
Can do many things, can pass civil degrees also.
That's one.
But I don't want to.
This is one aspect. But your lordship
Why don't you take steps for reopening of the investigation? I think that's the best.
It's not.
In Debts Recovery Tribunal, you have got a good case now because it has been observed by the investigating agencies that yes, those documents are fraudulent. Apparently, I've got a very strong prima facie case there. One. In the civil suit, that's a different proposition altogether. you will contest there. They will also contest there. I mean, now what about this investigation?
your
Unless
lawsuit,
this goes in your favor or against them at least, how can we pass any order against any of the parties?
Your losses kindly now. There are two things, one civil, one criminal. The third one I am espousing before losses, the constitution. What I am saying, who created the loan document? The bank has to come and say before your lawsuits. Bank has to come up and say before these persons executed the loan document.
Suppose a fraudulent document is placed before the bank.
Kindly see. Now today we are at the behest of the bank and any financial authorities to take out my forged deed of mine in the name of mine and take loan and go out.
It's a very large consequence. Yes, you are right on that, Mr. Shanna.
Therefore, your losses kindly see if this is being done not once, twice. I have faced 2 proceedings and still I am facing. But who will take the responsibility of this?
No, Mr. Channel, if the investigating agency close the investigation,
that's criminal aspect, your lordships.
If the criminal aspect is not there, Mr. Channel, the writ court does not have a charter
That's
to
your
do
lordship.
whatever.
Your lordship is one of the basis. But today, your lordship, it comes to this fact that I have not taken any loan.
Investigation is closed. It is said that the documents are fraudulent, but no indictment of any of these persons.
Now,
either Pegasus or any of the banks or the officers. Must be some of the officers of the bank were also responsible. Must be. But how can you proceed on that?
Question to myself. What the bank did in respect of this? At least your lordship can ask from them.
P24 of that one.
Kindly see the P24 documents.
Loan document.
And just page
183.
183.
What is the ultimate relief you have claimed here?
I'm ultimate relief I'm praying for. They have to, under the provisions of the act to take action, and your lordship has to do this, a constitutional tort, and I have to be compensated.
Why constitutional fraud?
Constitutional tort. But constitutional tort I'm asking for before lordship. This is now all the judgments have been considered by the Supreme. Kindly see your lordships. This is your lordship, the loan document. Original loan document. And this is police says, my lord, forged.
So there is no scope of an interim order.
Kindly see your lordship. Kindly see
Mr. Channel, if there is no scope of interim order, I don't want to, because if they want to use they have to use affidavits in this view of the nature of the allegation.
Now your lordship,
so let them use those affidavits and come back. I'm not inclined to pass an interim order as you have sought in G. Not at this.
I'm coming to the other interim order. Kindly have a look at this document once. Page 183.
183?
3. This is the loan document. Your losses top of the Kadambari Steels Limited.
Yes.
Now your losses, kindly see point number 2. Mortgage of landed property stands in the name of Messrs. Ornate Builders Private Limited. 10 Katas Malat Kakurgachi Road, Kolkata, having worth of rupees. Kindly see the next page.
No, not next page.
Next page 186. Property your losses, kindly see, kindly take note of the date and the Kadambi to address to Kadambi by the bank, and kindly see 2.
This is 8th of December, which year? 2001.
2001. And this is 2003. Kindly see the nature of the mortgage property change.
My property
included. All on a sudden. This is not, the court will interfere with this, my lord. A nationalized bank is doing it. Kindly see the side by side 183 and 187 or 186.
This is being done in the name of UPI, but the UPI has already initiated a proceeding. I mean, they have made complaints. So how can we say that they are also at fault?
But who did it then? UCO Bank write this letter to Kadambari.
No. UCO Bank.
That's one your losses, my lord. Your losses. Kindly have a look at page 183. This is United Bank of India.
Oh, this is United.
That was
so entire banking system has to stop functioning.
Kindly see that.
I don't think we should have banks anymore in India. And if this is the situation, really, I mean, then every other bank is involved here.
Suppose, therefore, nowadays we will be scary of using our.
Very scary. It's already scary.
In respect of any transaction, and that with the nationalized bank. This is the first pair of interim order. Now kindly see the second pair of the interim order, my lord. I'm asking for.
Interim order, Mr. Channel, very difficult.
The other one, your lordships.
One is G.
H.
H also.
Now, my lord, on the basis of these forged documents, my lord, the final order was passed by the DRT3. and there is an execution proceedings. Well, I appeared before the execution proceedings also and made an application.
That has to be decided. Why should the writ court
They say, they can't go beyond the order.
go
Beyond the final order, execution proceedings, your lordship, I'm taking your lordship to that order. 249 at page 249. Kindly see your losses. IA number, this is
Have you challenged the award before the tribunal on the ground of fraud?
No.
Why?
I tell you losses. That's I'm coming to losses.
Unless you do that, I mean,
I'll be on this point. That's I'm alleged by way of an application before the execution process.
you say this is section 47 akin to section 47.
I tell you losses, this is one. And the first year losses. If it is a fraud, it goes to the root of it.
Mr. Shanal, the difficulty is this recovery officer of the tribunal is somewhere midway between, I've held that somewhere, somewhere midway between an executing court and a bailiff. It does not have all the powers of the executing court. I cannot take out a proceeding under Order 21 Rule 197 to 101 before a recovery officer. He does not have the power to decide that. And he is better than a bailiff because he appoints bailiffs. But other than that, there is very little power to before the recovery officer. Although it's a haloed post.
I get your losses all the point.
But unless you challenge the award on the ground of fraud, that you can always
challenge it before your lordship.
the award of the tribunal.
But a final order of the if it is a fraud, I'm taking your losses to that. But kindly consider this. It might seems to be a very wide, but your losses can consider it.
Nothing less than Justice Krishna will do.
No. But kindly consider. The very first paragraph of it.
It gives a citation from Mr. Shah.
1994, volume 1 SCC, page 1. See, Chengal Naidu versus Jagannath.
Chengal is not recorded.
By
It's cited.
any court, the language used.
Is a parent case, 1994 1-1. Is a phone point?
The fraud goes everything.
ছোটবেলা থেকে দেখে আসি।
Jajuri করার সাহস পায়।
তাও মানছো না ছোটবেলা থেকে দেখে
Fraud vitiates all. Nullity.
By any court, your losses, see the language very first paragraph, by any court. So your losses can take cognizance of it and say this is wrong.
Yes. I can. I can under the law.
But therefore, your losses, today your losses, this I should not be. I am being penalized now with all these fraudulent proceedings based on fraudulent documents. Kindly visualize it. I am knocking at the door from one authority to another authority, one court to another court. I will be going on because of the fraudulent acts of the banking, nationalized bank. I am really in border aspect, but your lordship power is not limited to that. In the facts of the case, your losses can exercise your losses jurisdiction.
So as of today, Mr. Shanal, you
kindly stay the execution proceedings.
one of the aspects is the reports of the investigating agencies which say that apparently the frauds, that anti-fraud section, it says that there is a fraud, but he cannot fix liability. I mean, that is one aspect of the matter.
Both the deeds are forged.
So
They
portfolio
have
of
a
the
handwriting expert also. Banking documents forged.
handwriting expert was appointed in the criminal case.
Yes, by the
before
police.
the
By
anti-fraud.
the police. Anti-fraud section.
So you're
Yes,
relying on that report.
documents also forged.
As of today, apart from that, there is nothing else.
Nothing else.
Because nothing else is there to say that it is a fraudulent document.
Except that's anti-fraud section.
Why didn't you go
But
before the
my
tribunal?
original, they also said the original document with me.
Mr. Shanal, I'll give you leave to go before the tribunal and reopen the award. If it's based on a fraudulent document, you can go tomorrow and do it.
Why should I go to your lawsuit to tribunal? I can come up before your lawsuit.
Why did you avoid that? I mean, I'm asking for that. You should have gone before the tribunal
That's I'm saying. Kindly come to page 249
of this judgment.
No, of the order. I'm placing. They have
249, yes.
rejected my application. I can be added into the executing proceedings also.
They were not even substituted.
Recovery officer cannot decide this.
Now, then your lawsuits, I have to.
That is what I'm telling you, Mr. Shanal. The difficulty is very high. I mean, executing court and recovery officer are two different, if I may use the expression, different ball games.
That's why I'm on these judgment.
This judgment does not deal at all with the debts recovery.
Not that report. Any authority, any court.
The recovery officer was rather justified in saying that he cannot go beyond the
Order.
the award.
Now, he's asking me to go to before the appellate authority.
No, before the tribunal itself, which passed the award.
By saying that this is a fraud.
Yes.
Therefore, that I can argue before your lawsuit also.
No, Mr. Shanal. Despite whatever Mr. Bose says, you cannot do that. You can do that definitely. You can do anything. Anything is being done in courts.
Kindly visualize. If now it is, they cannot realize.
I'm telling you, Mr. Shanal, because the investigation as of today, I mean, I appreciate that the investigating officers themselves said that this is a fraudulent transaction, 100%. But investigation has been closed as of today. There is no pending investigation regarding this fraud. One. Secondly, you have an award staring at your face. You have to reopen that either before the appellate tribunal. Here, I think a better remedy would be to go before itself and say reopen it on the ground of fraud. That is one aspect of the matter. But for the writ court, what is there for the writ court to proceed on?
Question will pause that for a moment. Kindly take me.
Then I'll have to hold that these people are guilty of fraud and be on that premise. Or you may say that yes, the writ court can also say on the basis of forged writs, the recovery officer cannot proceed. But that same remedy you have to go before the award.
Point will arise under what provision of law I will go before
the debts recovery tribunal. I'll open that.
Then lawsuits can exercise your lawsuit jurisdiction.
No, debts recovery tribunal under section 17, the power is very wide.
But
all the subsections are there. Any of the subsections I can find out, at least one or two of the subsections will definitely support this point.
Final decree is passed. Kindly consider.
Let me hear the other side on interim.
No, sir, I'm appealing for the respondent number 8.
Yes.
Now your losses, the supplementary affidavit, one deed I have not annexed your losses that P14.
Annexed, but P14 is
no, for the purpose of interim order, since it was not given to them, I will not consider.
I'll give
you liberty maybe, but to file later.
No, Lordship, lot of factual incorrect statements have been made. First, madam, let me deal with those aspects. Before I come to I am for the respondent number 8, Pegasus. I am the assignee of Punjab National Bank, which was earlier.
I'm taking against the last judgment of our High Court Division Bench, the Pegasus went into Supreme Court. Supreme Court has rejected that. But even by disposed of by saying you.
The order was attachment of that amount.
Yes.
Now, my lord, first of all, my lord, Lordship is kindly note the dates. The loan, the original loan was in 2003 of rupees 50 lakhs. 50 lakhs loan was given by United Bank of India to the borrower in this transaction, which was Kadambari Steels. 2003, 50 lakhs. Today we are in 2023. The interest component, Lordship knows, will continue to run. Now, 50 lakhs has become 1.5 crores or 1.20 crores in 20 years is absolutely normal, but that will be given, that will be shown when the statement of accounts come. So the original loan amount, which was 50 lakhs in 2003, will always increase in 2020. The amount cannot stop. Otherwise, what does the role of asset reconstruction company comes to take over the loan of the NPF? This is the bad assets of the bank. We take the bad assets at a cheaper rate, and then we have a right to prosecute against the borrower. Now, that is what we have done. So the interest component will never stop. Today, if I go in 2040, this will become 4 crores. So the whole argument made that I have done financial fraud or constitutional fraud is absolutely illogical, because no bank or financial institution can claim a money if the interest component stops at the date of when the loan was given. So obviously my amount will be more. 50 lakhs have become 1.21 crores. Now, Lordship, kindly see the date of assignment is 2009. So I was not in the picture from 2003 to 2009 when the alleged fraud is said to have committed by, according to the petitioner is the son of the guarantor Bomkesh Bhattacharya, who expired. Now, Bomkesh Bhattacharya had given his personal guarantee to secure the loan availed by Kadambari from UBI. Now, how did he give his personal guarantee? He offered this Alipur property as security for which he gave the title deeds. Now, this all happened when I was even not there, or if I can say I was not even born. I came into the picture in 2009. Now, after I come into the picture, what do I do as a responsible institution who is in, because I have taken the bad assets from the bank. Now it's a duty I have to recover public money because ultimately this is the money of the public which has from bank has gone to Kadambari. I give the 13.2 and 13.4 notices. Now kindly comes to page 94, which was placed by my learned friend. This is the 13.4 notice. Possession lordship note 13.4. In the body it is given. The 13.2 notice is given. Kindly come to page 94. 18 June 2000, 6 lines from the middle, 18 June 2010 was the 13.2 notice which I gave.
Yes.
6 lines from the top, and then this is the 13.4, because obviously that is the usual procedure. We have to paste notice of physical possession, which is dated 15 September. Now, this is my first action as an institution, as an ARC, which I have to take, because I cannot, once I take over the debt, I have to take steps to recover. Now, he gives a reply to my possession notice. Now, this reply has come after the assignment has taken place. The submission made by my learned friend was that I was aware of the fraud before I entered into the assignment. That is not possible because assignment is in 2009. On the that is the lordship note, the asset reconstruction company have been set up under section 3 of this 2002 Act. So when I took the loan as an assignment, that therefore the question that in 2010 in 16 September he says that as a defense, which this court has rightly pointed out, every borrower has to give a defense. Here he takes a defense on behalf of the borrower, means Kadambari. He is the personal guarantor. He takes a defense that no loan, no guarantee, nothing. So this defense had come after the assignment. Now what happens after 2010? I gave a reply at page 98. Which is 22nd September 2010. No, I will not, that is not necessary. Now, section 14, obviously that is the next step under this is my statutory right. I have to invoke because I have to recover the money. 100 section, page 100 is this section 13.4.
But during this period, your persons were being investigated?
No, nothing. This is what I'm coming to say. Nothing happened. No, this is the thing which he had not mentioned. Kindly come to page 101. This letter was the first letter which was shown by my learned friend. This is the settlement in 16 February 2012 entered into between the legal heirs. By this time, Bomkesh Bhattacharya had died. So his legal heirs have entered, all of them signed by hand below the letter. Lordship says 101, 100. These are signed by individually by all the legal heirs of Bomkesh Bhattacharya. Now they signed this settlement. Based on the settlement, they give me 1.21 crore. I give them back the possession of the property. And based on the settlement, I withdraw my OA from the DRT. Matter is settled. I've recovered the money. My OA is withdrawn. Today, on my behalf, there is no proceedings pending before the DRT.
So as on 16th of February 2012, when this
settlement
was entered into between you,
no complaint, nothing.
But they were already aware of that allegations and
their stand is in 2010.
Taken in 2010.
They nothing. What do you do? Kindly come to 116. This is the first complaint they made 5 years after the settlement. In 23rd June 2017. This is the complaint on the basis of which the FIR is lodged. This is the first complaint made by Debojyoti, who is the petitioner, the son of Bomkesh. He makes after 5 years from the settlement, after giving the money, taking the property, and my OA is withdrawn in the section 19 before the DI, page 116. This is the complaint, or Chinese see the date.
This is the first
complaint of first at the.
But there was no complaint at all.
No bank, no CID, CBI. I could not find any papers. 23rd June 2017, at the instance of Bomkesh, there is nothing. What UBI and UCO have done, I am not aware. Bomkesh Bhattacharya, legal heirs, Debojyoti, files the first complaint, which is converted into FIR. FIR is page 115. And this FIR leads to the FRT, where there is no finding against the lordship of notice. So the trigger is 5 years after the settlement. Why 5 years? If he knows that his father did not even give any guarantee, he should not have entered into this settlement. He forces me to withdraw the OA. He forces me to withdraw the OA. So the money of, admittedly, the money has gone out from the bank. I am the assignee. I have to take steps to recover the public money. Now, Lordship sees the other thing. What is the report of the FRT? Absolutely incorrect interpretation is given. What is the fraud, alleged fraud? I'm not admitting this. What is the two things they have said fraud, which are done behind my back? First is, Lordship, see, the words are very important. The loan document has not been described as fraud. Kindly note my submission.
This is page 171.
171.
Yes.
Kindly see, two things have been described as fraud, though I'm not admitting it is fraud. One is title deeds. Lordship may see the third last, which has been pointed by my learned friend.
Yes.
Other is kindly see the second last paragraph. Third, second, loan guarantee papers. So what is loan guarantee papers? Bomkesh Bhattacharya had signed the form while giving the guarantee to the bank, which I've got the copy of the document, which I will put it on affidavit, signed by Bomkesh. But this is the signature of Bomkesh when he gives the guarantee paper to the bank. So the guarantee papers, he's saying that by his father did not sign. But the document which my learned friend had shown, I'm coming to that, the sanction letter, that is not described as fraud. Kindly see this sanction letter which was shown by my learned friend. Sanction letter. Lordship, give me one moment.
Sanction letter by whom?
By both the bank. It was shown by my learned friend. Just give me one moment. Yes, kindly keep 183 and this was shown by learned 183 and 186. So what is and along with this, kindly Lordship keeps a mark at 171. So the two documents are alleged to be fraud. First is the title deeds, because one loan, three title deeds. I am not going to title deeds. Second is loan guarantee papers, means the guarantee papers given by Bomkesh while offering the Alipur property as security or mortgage with the bank. The loan document, the word used by learned friend was loan document papers are fraud. That is not the case. Kindly see, loan document papers are not fraud. Now, why? This is not mentioned in the FRT. And no Narazi petition filed by them. Actually, they have lost. Lordship has pointed out correctly. I'm not supposed to file because there is no finding against me because they said that they cannot go. So they are the persons aggrieved. They have not filed any Narazi petition from this order. Now, kindly come to 183. What is happening here? I will just try to explain. 183 is of 2001. Lordship normally knows in what happened in those days in banking transaction. Initially, banks writes a letter to the borrower. This is my initial conditional offer. I can give you provided you do X, Y, Z. This is in 2001. But the second document in 2003. So ultimately, when the loan is given to Kadambari, Kadambari has brought, how he's brought, I don't know, Bomkesh into his picture and given his property as mortgage. So there is a period of 2 years which has gone by. It is not that all of a sudden it has vanished and A and come with B. Always, if bank has put three conditions, maybe he was not in a position to bring the landed property on it. So after 2 years, brings the property of Bomkesh and takes loan from the bank. These things always happen. If one of the terms condition bank say, no, I'm not happy with condition A, please put condition B. This is just which has happened. In any event, these documents are not described as fraud in the FRT. The only documents described as fraud is the loan guarantee papers, mean the guarantee papers which were signed by, according to him, not signed, Bomkesh Bhattacharya signing and giving the title deeds of the property to the bank. And secondly, the title deed itself they are saying is forged.
There is some doubt on the loan guarantee papers. What is referred to?
Loan guarantee papers is the guarantee document
in respect of loans from United Bank.
Yes, so because I've got this is the guarantee paper, Lordship sees. The guarantee documents were handed by the directors of Kadambari and Bomkesh to bank. Now this document.
Can you give me one copy of that?
Yes.
I mean, I'll just.
This is the photocopy.
Yes, whatever. I mean, just to distinguish between this.
This I will put it on affidavit. Kindly see the next page. It is signed by Bomkesh Bhattacharya. This is described to be fraud according to the FRT, though we are not admitting. Second signature of guarantor. This guarantor is the father of Debojyoti. This they are saying is fraud. and for which they are saying my father was not aware of this. So these will be under, this is subject to investigation, whatever happens.
Some doubt, loan guarantee papers.
This is the guarantee paper. Lordship, see the entry form for title deeds deposited by guarantor, inspector of guarantee obligation, heading. This is known as the guarantee paper. Loan papers are different from guarantee papers. This guarantee was brought in by Kadambari. I don't know what is the relation between Kadambari and Bomkesh, how these two are connected, I'm not aware.
These are the, you're right. Page 183 and 186 are
Is that
directly
loan
related-
sanction letters? This is different from loan guarantee. These have not been described as fraud. As loan guarantee papers are different from loan documents or loan sanction letters. This I will put it on affidavit. Now, thirdly, my lord, the last order which was shown by my learned friend, the DB order, the last order from which we prefer the special petition, which was disposed on Friday. Last 4th August order has not been uploaded. That is, I'm not aware. I've been informed that we have offered to deposit 1.46 crore before the learned suit court, and the suit has been expedited. So, and the attachment has been lifted. So the other point was that their submission was that because Pegasus has recovered, so kindly suspend the license. Now, whatever amount I had taken, that amount will be deposited before the suit court, where he is the plaintiff, to the credit of the suit, and the suit has been expedited. And it is being going to be deposited. So I will be also out of pocket. I cannot use that money also. Now, Lordship kindly sees the assignment document which was shown by my learned friend to show inconsistency. The assignment is at page 130. It starts as Lordship, the date is given. Now, the last page was shown to show as if something irregular or something astonishing has happened. Kindly come to 28. Sorry, 151, 151. This is the schedule. What was the contents of the assignment text? This is very important. Kindly see number 2, Kadambari. See the date 29/5 as on from, as I told, 2003-15, 2019-60, the clock will never stop. So if this happened 20, obviously amount will increase. So this type of submission made that I've done a financial fraud, constitutional fraud, every institution, the Lordship knows, either the bank or NBFC, the interest counter will never stop unless you pay the money. So this is not, this amount was in 2020. If 2009 it was 67 lakhs, in 2022 it will obviously become amount. There is that, and I will, when I put my statement of accounts, I will give the entire breakup. Now, Lordship, see the bottom 13. These were documents which were part of the assignment. This I got. This is the guarantee document which I showed. Letter of guarantee 50 lakh given by Bomkesh. This is the guarantee document. CL number 13. And CL number 16, the letter of intent by Bomkesh for deposition title. So this CL number 13 is the document which is known as the guarantee document. And therefore, this amount will bound to increase. Lordship is not fully aware much more than me. Therefore, I will not waste your Lordship's further time. And Lordship does one last submission, even if I will not cite any case that the evidence of a criminal court is not binding on the civil court, and FRT is a mere opinion of the investigation officer, which has no conclusive evidence. But then the ending is, the last is in my favor, that nothing is found. And from where they have not taken any further action. And Lordship, just one last submission. Lordship sees the cost title. They have included Reserve Bank of India, who are respondent numbers 2 and 3, but one is in Bangalore, one is in Maharashtra, Bombay. So I think that is why they are presumably not present. Reserve, they have gone to the anti-fraud section. I don't know why. They are Reserve
Which respondents?
2 is RBI Bangalore and 3 is RBI Maharashtra. So none is from RBI Kolkata. 1 is Delhi, 2 is Bangalore, 3 is always. So therefore, I don't find who is appearing. I don't know whether anybody is appearing for Reserve Bank. And regarding prayer G, Lordship has said, there is no scope for interim order, and prayer H is not against me because now my DRT is not pending because I already withdrawn after taking the money, and I gave them the property, and now that money which I have taken is also now gone to court. Today I'm not enjoying it. I'm not enjoying any money because that money I've undertaken before the Honorable Supreme Court that I will deposit to the credit of the suit. So today I'm also out of pocket. Those are my submissions.
You are not a party to the recovery proceeding.
No, my that is against therefore UCO Bank. My DRT is withdrawn.
Yours is PNB.
I might withdrawn because after I intend to settle lordship, no OTS, I have to withdraw it because that is withdrawn long time back.
Yes, there was a settlement between
Yes,
you.
man. I had withdrawn after that.
Right.
Those are my submissions.
Bank.
My lord, so
Add
far
on.
as PNB is concerned, my lord, I do not have much to add
You
after
have to,
his.
yes.
Yes, but the point is, this was done, the assignment was done way back in 2009. Thereafter, everything was closed, the entire thing was closed, the people were discharged. And now what happened before that, from 2001 to 2003, how they say that it's all forged, because the title deed, whatever documents were with us, we had deposited to Pegasus. And that has been communicated also, Annexure P10, page 98. So what happened and who were the people involved, if at all there was some fraud? Now that is very, very difficult to ascertain at this moment, because it's UBI merged to PNB. All the officers have retired or maybe dead also. The father of the petitioner has also died. So what, I mean,
You petitioner has retired.
Petitioner.
no, the father.
So either retired or dead.
The father is dead. The
Father is dead, so you must be retired.
So what happened actually, that is very difficult to ascertain. That's
No,
not
we'll come back after this. I'll hear the UCO Bank, the Union of India, and then come back to you. And then refuse your red interest. We'll continue after this. Do PMP fixed as any? I think we'll continue.
Number 5.
Yes. Yeah, for the UCO Bank.
My lord, I'm for the UCO Bank, respondent number 6. My lord.
Only one thing, my lord.
Yes, you are adding.
There was only one mistake, my lord, that Bomkesh Bhattacharya, he died on 14th October 2011. I mentioned the wrong date. 14th October 2011 he died, and therefore the letter which was shown by my learned friend, the first objection raised to my 13th
So he had reason.
during his lifetime, 16th September 2010. After that, the first complaint lodged by Devajyoti, his son, was after 5 years from the date of settlement, which is in 2017.
No, the 16th September was not to the investigating agency.
No, this is my response to the
That is your
13-4 response by the father when he was alive.
Right.
That date was nobody was with me. My date 14th October he died.
Right. UCO Bank means your recovery proceeding is being sought to be stayed by them.
My lord.
Right. What do you say there?
My lord, I would like to draw my lord's attention to page number 203. That is the final order which has been passed by the learned DRT. My lord. Page 203. Just, I would like to point out some factual aspects because I have already assigned the debt to ASREC, which is respondent number 9,
Yes.
who are actually conducting the recovery proceedings before the DRT right now.
This is the-
And they are seeking an order against respondent number 9.
This is the order which is sought to be executed now.
My lord.
Very well, yes.
My lord, originally applicant bank, namely UCO Bank, filed present application under section 19 on 14th September 2004 for such and such amount. Defendant Tirupati Textile, Animesh Mitro, Bomkesh Bhattacharya. These three. During pendency of the OA, defendant number 3, Bomkesh Bhattacharya died and his legal heirs have been substituted. Further, financial asset or debt in the account has been assigned by original applicant bank. So we assigned the debt, my lord, in 2008. And my lord kindly comes to the next page, page 204. Paragraph Roman 3, 2-3. On behalf of the defendant number 3, an IA has been filed taking objections to the claim made against him. Applicant bank was directed to file objections to the said IA in the order dated 20th June 2008. This has been recorded that applicant bank up to that date did not file objection to the petition filed by defendant number 3. This has been recorded in the order dated 21st July 2008 that applicant bank has assigned the debt to ASREC India Limited. My lord, they challenged that assignment. That is also reflected in this order in page 205. The first paragraph, my lord. This has also been recorded that applicant financial prayed for issuance of recovery certificate against all the defendants. Defendant numbers 1 and 2 have already been ordered to be proceeded ex parte. On the other hand, defendant number 3 prayed for quashing the assignment by the bank to the asset reconstruction company. In the said order, tribunal elaborately discussed the provisions of law and held that assignment of the debt to the asset reconstruction company is proper and not in violation of the Honorable High Court's order. So that has been completely dealt with, my lord. Now, a few things, my lord. Bomkesh Bhattacharya, as my learned friend said, died on 14th April 2011.
14th October, bro. October. Your record say April.
My lord, it is recorded in the order to page 206, paragraph 5. Paragraph 5, Roman paragraph 1. Defendant number 3, late Bomkesh Bhattacharya, died on 14th April 2011.
Very good. Very good. Either of the two.
My lord. Now, my lord, comes to same page, page 206, paragraph 5, Roman 2. In 1998, late Bomkesh Bhattacharya came across with one Shri Aboni Kumar Roy, advocate, who persuaded him to develop the said premises through one of his clients, namely Paramashri Devi Lodha and Bomkesh and another late Bomkesh Bhattacharya and Piyush Lodha. Late Bomkesh Bhattacharya handed over the original title deed to his property to the said Aboni Kumar Roy, advocate. A copy of the letter dated such and such, signed by Aboni Kumar Roy, has been annexed therein. Receipt of the original title deed is accepted in the said letter. Thereafter, said Aboni Kumar Roy, advocate, continued to hold the title deed illegally and refused to return the same to deceased defendant number 3. On receipt of demand notice, I will skip that. My lord, now comes to page 207, paragraph 6.
Right.
Second line, I find that security documents dated 14 September 2001 and 6 March 2002 have been filed. 2 security bonds dated 14 September 2001 and 6 March 2002 executed by late Bomkesh Bhattacharya have also been filed, whereby said late Bomkesh Bhattacharya confirmed having created mortgage for security of the loan taken by the defendant number 1 for 75 lakhs and 15 lakhs. Now, my lord, my lord goes to 1, 2, 3, 4, 5, 6, sixth line from the bottom.
Yes.
Late Bomkesh, same page, page 207.
Got it. Late.
Late Bomkesh Bhattacharya, V-Day of said security bonds dated such and such, confirmed having created charge by depositing of original title deed of the bank. Original title deed has also been filed by the bank. Same was sent to CBI also for investigation. This is a CBI inquiry that they're talking about. However, SP CBI returned the said original title deed to this tribunal. V-Day letter dated 31st August 2005, mentioning DRT has no such jurisdiction to direct CBI for causing further inquiry or investigation for settlement of DRT cases. The closure report has also been filed by the CBI. So this is the status. However, my lord comes to the last line. CBI did not give any conclusion and returned both the original title deeds to the tribunal as mentioned above.
Then CBI did not hold inquiry on this premise.
My lord.
That the DRT did not have any jurisdiction.
DRT did not have any.
Not on its merits.
No, my lord. Now, my lord comes to page 208, paragraph 9, Roman 2. I have carefully seen the confirmation of mortgage letters executed on both the dates. Signatures of deceased defendant number 3 appearing on the said documents letters are similar to his signatures appearing on the written statement filed by Bomkesh Bhattacharya. Original title deed has also been deposited. Said late Bomkesh Bhattacharya has also sent letters confirming creation of mortgage annexed with the OA as annexure C2 page 133. In the said letter also, signatures of late Bomkesh Bhattacharya are similar to the accepted signatures. Thus, this tribunal, without going into the merits as to whether title deed deposited with the bank is genuine or the title deed held by above-named third-party interveners, Parameshwari Devi Lodha and Pijushi Lodha is genuine, this tribunal holds that the late defendant number 3 executed guarantee letter and also created charge on the property. Therefore, said property stands charged in favor of applicant bank. Paragraph 3, my lord. Allegations and submissions made by defendant number 3 in his written statement cannot be accepted.
Sorry.
He stated that deed deposited with the bank is not genuine. He mentioned that handing over his properties deeds to some advocate, namely Oboni Kumar Roy. In the petition filed by third-party interveners, they stated having original title deed with them, that is Parameshwari Devi Lodha and Piyush Lodha. Thus, the statement of defendant number 3 cannot be believed. Legal heirs of deceased defendant number 3, namely Jyotikana Bhattacharya, Abira, and Devo Jyoti also filed additional WS, which cannot be accepted as the allegations made therein are not supported by sufficient evidence and documents. They do not possess the original title of the property. Admittedly, deed is not in possession of the defendant numbers 3A to 3C, which are the legal heirs of Bomkesh Bhattacharya. Applicant bank has been able to prove disbursement of loan and creation of security. Therefore, defendants are liable to pay the dues of the bank. So, my lord, this was the whole award or decree of the learned DRT. My lord, this has been passed in 2017. 11th January 2017. And my lord, the petitioner has pointed out, learned senior has pointed out that page 172. Page 172 is the FRT, which was submitted by the anti-fraud section of Lal Bazaar. My lord sees the date is 2nd December 2020, which was 3 years after the award, the decree was passed by the learned DRT. That order has not been challenged. They came up in recovery proceedings, which the learned recovery officer opined that he cannot go beyond the decree. Now, my lord comes to page 173. Page 173, column 1, 2, 3, 4, 5, 6, 7. Seventh column, my lord, accused number 5.
Page 173.
My lord, 173, it is a tabular form of the FRT. Accused number 5.
Yes.
Bank official of UCO Bank, Shambazar branch and UBI Park Street branch. My lord, the bottom sections are given and not charge sheeted for want of evidence. So this is the finding. So my lord, in this present writ petition.
Pegasus people were also there in the accused number 6.
Yes, my lord. So my lord, in the present writ petition, the only relief that has been sought against me is to cancel my license. My lord, I assigned the debt in 2008. A ward has been passed in my favor or the financial reconstruction company, much earlier than the finding of the anti-fraud section, my lord. And here there is no specific finding against me or any of my bank officials that I have committed fraud. And so, my lord, in terms of that, prayer G cannot be allowed in my humble submission.
Wait. Yes. I think union won't say anything. I don't think. You want to add anything?
Yes. Well, may I deal with the first submission of the Pegasus? Now, your lordships, well, those documents have been placed by me and my learned friend also, but I will take just once. Well, your lordships kindly take up the first assignment agreement. My learned friend submitted that amount cannot be the same, it must be inflated. Now, your lordships kindly will look at the page. Just a minute, madam. The agreement, assignment agreement at page 130. I'm sorry, madam. 130. The date will be, your lordships, 132, 23rd September 2009. Clear, your lordships? On there, your lordships kindly part of that agreement, the assigned amount, page 151. I placed it before, lordships, but I have to place it once again because of my learned friend submissions.
2009, yes.
9. Kadambari still, your lordships, principal outstanding amount, 29th May 2009. 44.87. With interest up to 29th, 22.36. Total comes to 29th May 2009, 67. All right, 0.23. Now, your losses kindly come to page 194. Kindly come to losses.
Yes.
Well, this is a notice dated 27th.
15th September 2010.
Page 94.
Page 94.
Date 15th September 2010.
তাই তো আছে।
Yes.
Now, your lordships, there are two pages, 94 and 90, possession notice. Your lordships, at the first paragraph, to repay the amount mentioned in the notice being 1,20,11,437. My lord, signed on 27th May 2010. Notice date, your lordships, next page, 15th September 2010. My lord, I am putting a question to myself. Within 1 year, can it be double? By what calculation, my lord? Unless it is forceful realization.
And where is the calculation?
Where is the calculation? My learned friend is talking about his no involvement. He's so innocent.
2022 তে ও বলছে
Acha, Mr. Shanal, you paid this amount without demur?
I have been ousted from the house.
After that, you have challenged?
Yes, my lord.
Where?
My lord, I went before the, my lord, FIR, then FIR. My lord, I kindly consider this is my residential house. At that point of time, I was not so mature and my father was dead even. I lost my father because of this. He couldn't tolerate all this. Kindly situation, my lord, kindly, this is not so easy. Kindly see the family situation over there. So one has to, my lord, stay, my lord, withstand the entire situation. It's very easy to say someone that you didn't challenge, you didn't do that. And kindly see the authorities, my lord. CBI was not taken because DRT has no power. I lost an FIR, my learned friends talking about after 5 years. But I had to first go to my house. It's a property of 12 crore. It was going out of 2 crore, 3 crore. I have to save my property first. I have to collect those money by loan from other persons, pay them, save my property. So it's not so easy, my lord. Somebody will come and say that this has been done because of this. So to save my property, I had to pay it. And then your lordships. Therefore, your lordships, all that I'm saying that they are aware of it. They cannot say simply. And one thing your lordships kindly will look at, my learned friend has tried to make a distinction between loan document and your lordships mortgage document. That's your lordships. Malad, that kindly come to page 169 once. Malad, that's 171, your lordships. Last but one paragraph. During investigation, the documents in question, including 3 title deeds of the same property, loan agreement papers in respect
Guarantee
of
papers.
loan guarantee papers in respect of loans from the United Bank.
That
Park
is where he
Street
tries
Bank.
to distinguish. Mr. Sharma tries to distinguish on that. Because he says loan guarantee papers are different from the loan papers.
Exactly.
The loan document.
Now the loan guarantee papers, Malad, goes with because I mortgaged it. If those documents are forged, Malad, something Malad with the loan documents. What am I to do with the loan documents? I didn't ask for loan. At best, I can put my signature on guarantee documents.
I am concerned with the guarantee document,
I'm concerned with the guarantee because my property is taken because of this.
not the loan. I am not the borrower.
And kindly visualize now, your lordships, the first notice and second notice. That your lordships, that the description, Malad, the property was changed. Go to page
186.
183 and 186, if I'm not wrong. 183 and 186. Collateral security property changed. Bank says if during the process they can change it, but how did you change it? Now see that document is forged one. So therefore, all that I'm asking before your lordships.
This document has not been held to be forged by any from any
Malad,
court.
this is what Malad, this
sanction.
document, but the loan guarantee documents, but this had been held to be forged.
Yes.
If that is forged, Malad, everything becomes forged. So far, I am concerned.
I am showing this only to show
I'm
my
still
property has been included.
Malad, this is I'm showing why. This is I'm showing to show your lordships how my property was included. How my property was brought under the mortgage. Who how I'm pressurized to give the money. So this is the situation. So for Pegasus, Pegasus can't say, I'm so innocent. And now your lordship, Pegasus is the agent of the ultimate bank. What is the answer of the bank, Malad?
There are two separate causes of action for this writ petition. One is regarding the UCO Bank proceeding. The other is Pegasus and PNB.
Exactly.
There are two components of this. So we cannot mix up the two. One is regarding functioning of Pegasus, which you say they're guilty of unfair trade practice, and the other allegations are there. The other aspect is regarding that UCO Bank recovery proceedings. You say that you are never a guarantor because your guarantee documents are suspect. I mean, forged or whatever. If that be so, your property cannot be recovered. I mean, that cannot be a subject matter of the recovery.
But on that, I'm submitting, your lordships, both the transaction in respect of the same property. And I am the owner of the property.
Yeah, that's true. That's it.
Now, both the authorities are under the RBI and the Union of India. They are the Malad wings of the state. And both the authorities, Malad, kindly see the, Malad, how the property, Malad, one property is being used twice in respect of the two nationalized banks.
But once it is used fraudulently does not mean in the other case also it is used fraudulently.
Malad, nobody knows.
Per se, maybe, may not.
But your lordships, the nature of it so, it requires interference.
Regarding Pegasus and this PNB transactions, let us suppose that your loan guarantee papers are fraudulent or if it says so. But what about the UCO Bank proceeding?
That's also say forged. Kindly have a look. So 171, both are forged.
171, yes.
Both are forged. I'm just your lordships. Both the deeds, except my original, your lordships. I'm coming to that.
Oh, yes. Title deeds used to get loans from UCO Bank and all.
Both are forged. So, Malad, therefore, Malad, I believe, Malad, this is a fifth case to be interfered with by your lordships, by any means. This is so far, Malad, Pegasus is concerned. Malad, so far, UCO Bank is concerned, this lordships, kindly consider. My learned friend has placed the orders. So, I intervened even. By this time, Malad, I lost my father. I have to recoup the entire, save my property, and then I have to fight with all almighty respondents who don't bother about the money. I have to engage lawyers. I have to consult with the lawyers. They don't need any money because they are being funded by Almighty.
Bruce or God?
Malad, that's Malad, I don't know. Malad. You'll also have to kindly see that. Now, kindly see by this time how much proceedings I have to initiate. All these are at the Malad, because of the actions of the state authorities. But I am being made victim by the action of the state. That's the whole thing.
State authorities is very vague, Mr. The state has so many authorities.
Your losses, Malad, ultimately one. Now, one, Malad, your losses kindly visualize one judgment is there. Suppose your losses, one authority, suppose the district magistrate. I have not made a party. I am questioning the action of the district magistrate. I have made the state. Malad, your losses judgment is that our court. If state is the superior respondent. When the state is the party, DM has to come and answer before your lawsuit.
DM and state have a different relationship than the RBI and the Union of.
But I'm telling you.
I mean, I don't know whether they actually have a different relationship, but on paper they have.
Relationship, but ultimately all are controlled by RBI. All.
The central government also.
No, central government. RBI is an wing of the central government. It can't be, Malad. So for the
should not be a wing of the central government. Actually.
That's an autonomous body.
Anyway, yes.
Malad, our is in our country autonomous body institution.
Maybe yes, true. You're right. But what about this? I mean, UCO Bank is a different entity. PNB is a different entity. There are two different lines of transactions on the same property. Yes.
But ultimately, Malad, your losses, Malad, a combined report of the anti-fraud section says both are false. My property is the one property. For that, Malad, I should not be saddled with two by filing two litigations.
Your DRT, that DRT award, which I'm asking
exactly
you to challenge. That was passed on January 2017.
17.
Your first allegation of fraud came when?
I made
2017 itself afterwards.
On paper for on 2017 by filing an FIR.
Yes. But that must have been after 11th January.
That I'm just giving you.
23rd June.
23rd June.
Has to be after
23rd June.
P15.
P15, 23rd June 2017. Now, Malad, the question now comes up. All said and Malad. Now, after it has come to the surface that the document was forged by which the loan was secured. Can the order of the debt recovery tribunal survive? And can I be forced to undergo
automatically by virtue of a finding in if an FRT definitely does not go.
But Amal,
an FRT, an investigating agency is observing that it is fraudulent and DRT award will go.
I'm coming to that.
Statutory authority
also says the original document who is with me, and that's the LIC document.
That is not even binding on a criminal code.
I'm not on that. Your losses, this finding your losses, kind of look at this. I'm just your losses.
Your only handle is that the FRT report that all the deeds are fraudulent.
This is one aspect. FRT also says which was the original document.
Your entire case is on the FRT, which has culminated in a dropping of the proceedings.
Not only on the FRT. Now everybody is now Malad following the FRT order. Because I tell you losses why. If the original deed is...
What do you exactly mean by everybody?
Everybody, all the banks. I tell you losses why. Kindly see the last but one paragraph. I just tell you losses. During the investigation, the LIC at page 171.
Oh, that, yes.
During the investigation, the LIC authority was contacted. On being asked, they stated that amongst 3 seized title deeds, title deed seized from Piyush Lodha is the original one. That's my lord, with whom I entered into an agreement.
And that deed I have now got it.
So it is apparent to the title deeds used to get loans from UCO Bank and UNR4 deed. And that title deed was with me.
Now,
today.
presently.
I've
got it.
Why do you say everybody acts on the FRT?
Because they have not questioned it also, my lord. Its findings, whatever, my lord, prima facie.
Yes, sold them to...
Mr. Shanal, it goes in their favor. Ultimately, it says that the responsibility cannot be fixed on them. And they will go and challenge.
Probably I couldn't.
The manager's job would go then.
I tell you, that they have saved somehow. That's the ultimate criminal liability.
This is the only thing which is against them.
Exactly. Now, therefore, on the basis of that, can they enforce the decree of the DRT? That's my point. I'm not on criminal liability. That's a civil liability.
Otherwise, there is nothing on record to say that they cannot. The only thing is this.
That's
your allegations are there. Allegations counter allegations.
If the original deed is with me, nobody is denying it. This is the original document. I have annexed the other documents. Should I show to your losses how this is fraud? Kindly have a look at the original document.
Can I decide even?
Your lordship has the power under the evidence, but I'm not saying that.
I have the power to do what?
Your lordship, so far the DRT can do it. Your lordship has been blessed with that part of the documents. Kindly have a look at the. If I go to say the DRT is also involved.
Definitely, DRT can take into consideration questions of fact.
Exactly.
Which I cannot into 26.
Your lordship.
Unless it's an admitted position or undoubtedly appears on the face of it.
Now, DRT says, now your lordships, on the face of it, that's my signature. Which the anti-fraud section, after examination, says this is forged on.
Unless that award goes, Mr. Channel,
that's I'm saying that's based on the false document.
Your entire case is based on page 171. Entire case.
That's your lordships.
That is the difficulty. Which is just an FRT. What is the binding effect of that?
FRT binding effect that there is no criminal liability. As far as my criminal knowledge goes. There cannot be any criminal.
Your criminal knowledge is better than mine.
Not at all.
It coincides at this point. I mean, yes, no liability on anyone. So how can that help you? I mean,
that's your.
I don't get this.
Finding on the investigation, your losses.
You are wanting to one against Pegasus at this point without inviting affidavits, Mr. Shan. It will be a too high penal order.
This was saying to experts.
But regarding your DRT proceeding, yes, I was thinking about that. But this is the only plinth you have. I mean, the only basis you have for your prayer.
Now, your losses kindly see. This was saying to the expert for examination. DRT.
Where?
Your losses. Page 171, last but one paragraph. During investigation documents, including 3 title deeds, loan guarantee papers in United Bank of India, along with admitted handwriting signatures of Bomkesh Bhattacharya, since this is was sent to the experts for examination, and they opine are forged. But what more required than your losses?
This has no binding force whatsoever in law.
That's one.
No binding force whatsoever in law.
Then your losses,
because neither the experts are adjudicating authorities, nor is the person concerned, the anti-fraud section DD.
After this, after the order, when the execution proceedings was going on, I made an application that was also rejected.
Made an application for what?
For decree, recalling the decree. Your losses can have a look at that.
Recalling decree, recovery office will recall the decree.
I took the plain that everything was forged. Your losses kindly have a look at this. I'm showing your losses 249. Can you have a look at this?
And 246.
249, I think.
246 separate.
246.
They have 246 petition.
But first look at my application and then your losses. Application starts at page. What was the page?
217.
217. But
cannot go beyond the degree.
No, that's go beyond the degree.
He's right. I agree fully with him.
Then,
her.
Then I should.
No, her. Sorry. I fully agree with her.
Now your losses, these probably
cannot go beyond the degree.
But then what am I to do your losses today?
Go to go to pass the degree, the DRT.
They
is what I am telling you
from the functions of officio. Now,
please read the first paragraph of your judgment you cited.
Yes,
the first paragraph.
That principle I'm invoking.
That principle I'm invoking here.
All fraud vitiates.
All. So why should I not before your losses to go before the
even your submissions are vitiated?
Now kindly your losses. Frauds avoids all judicial acts.
So what does that mean? You're asking me its function. You're telling me it's functus officio. It's recovery tribunal.
That's in respect of it's a statute created by statute. Your lawsuit is not created by statute. Point will come up whether he can review a judicial authority.
I feel elated, Mr. Shanal, that I'm not created by statute, but it's up to that. It stops there.
No, your losses. Now your losses. No, that should not be your losses.
Mr. Shanal, we have our hands, tied in the sense that regarding these disputes, we cannot decide, adjudicate on these. We can definitely, but we should not. Why should we?
If your
Read code 226 is not for this.
In such a glaring fact,
I appreciate, Mr. Shanal, if you showed me some criminal investigation is even going on. There is nothing on board.
I tell you,
nothing. You never prayed for reopening of the investigation.
I tell you, losses. after the FRT was filed, your losses, my learned friend, they didn't do anything. My lord, what I did, your losses, subsequently I have lost an FIR. But I have to save my property first. Well, suppose, my lord, I filed a Naraji petition to this. Now visualize your losses. I could not come up even today before your losses because of the pendency of the Naraji. And that Naraji petition will be kept pending for years together with my property.
So, Shanal, your picture does not look very well now. As of today, what you have done is you have entered into an agreement, a compromise with Pegasus, and pursuant to that, you have paid up the money. Yes, you see under compulsion, I appreciate that. You were to get back your house, but you did that. After that, you made the first complaint in 2017. After that, just see your conduct. First, you entered into that compromise with them. You got back possession. Thereafter, you lodged a complaint saying that entire thing is fraudulent.
I lodged the complaint with the bank, not to the police.
Police.
Well, that's my
Police also.
Police
Police also after that.
but not with the bank. Bank I lost before.
Maybe.
Bank I lost before.
But
so
this-
the first complaint should go to the bank. That I have lost.
But you have, I mean, that
then
has been obliterated the moment you enter into a compromise with them.
What is the compromise, my lord? Kindly have a look at the document.
Paid up.
Paid
1 crore and something.
Paid up because I was thrown out of the house.
You got back possession and thereafter you lodged this complaint with the police.
Exactly.
This is on the Pegasus aspect of the matter.
Exactly.
Secondly, you have regarding the UCO Bank matter. Yes, you have lodged a complaint long after. UCO Bank assigned in 2008. And after that, 2017, this award was passed. That award did not, you did not go unrepresented there. You were present, you took the point, various arguments were made, also on the merits of the documents, on the veracity of the documents. Those were decided in the award. After that, you come up in recovery proceeding, and recovery proceeding, the recovery officer says, rightly, I can't go behind the decree. What is the wrong in that? You are not going back to the tribunal, Mr. Shanal, because this point you agitated before the tribunal.
No, not that. Well, still on the I agitated.
In the award,
I have not executed the loan. Well, that ultimately found to be true. That ultimately found to be true. The DRT didn't go beyond that.
There's a scope of interim order, Mr. Shanal.
Your lordships,
is either of the respondents, either the Pegasus or PNB or the UCO Bank setup. And at this stage, no scope of that. If you want an interim, I can give you liberty. Nothing in this order refusal will prevent you from moving an appropriate application for recall of the award on the ground of fraud.
That's one aspect. So for the other aspect,
other aspect, your complaint with the RBI that remains.
And that's your lordship.
After paying up, Mr. Channel, the scope is very limited. Under whatever compulsion you paid, you pay, take advantage of that by taking the position. And now you're resigning from that position and you're saying, no, it's exorbitant.
Then would your lordships, I'm off the record. Then does it mean my suit, I cannot file the suit also after payment? That doesn't mean, your lordships. Kindly see the situation now. If that's the stand, your lordships, well, I cannot file the suit also.
When did the suit, when was the suit filed?
The suit was filed.
Suit, we have taken the point of limitation where that Honorable Appellate Court said all points are open to be tried. Because suit is filed after 9 years from suit filed in 2023, 9th March 2023.
After taking the possession?
Yes, possession in 12, suit for 9th March 2023.
So that's the suit is maintained.
Suit, we have taken the point of limitation.
That's what I'm saying. Under one situation, everything.
Can you see the list of dates once?
Now see, your lordships, whose voice is more forceful?
No, not forceful. I'm using the microphone.
At least it is clear with your lordship, I have not taken the loan. I have not made my property.
He has taken the property, he has taken the money, he has now the money is in the suit court, and he took the lordship seat, just one page, 101. Only one page, 101. I gave him the original title deeds also to him, which he said before. Kindly see 102. Second last paragraph. The title deed which they alleging forged was given to them by when this OTS was entered into. 102. Second last paragraph.
What is the photograph about? This is a sting operation.
No, this they are saying that some cash was also given, which we are denying. They are saying 25 lakh cash. I don't know what is that. That's just
literally shady.
This is saying 25 lakh cash was given to my client, which we are not admitting. No, kindly see page 102, second last paragraph.
What is the photograph about? I'm interested.
Cash,
Page
cash.
1.
They are saying 25 lakhs cash was also given to my client apart from 1.401 crore demand draft, which we are not. This is a, kindly see 101, second last paragraph.
Madhababu, Ashwin. Learned counsel for the petitioner contends that a scam of huge magnitude has been perpetrated against the petitioner. Full stop. By showing fraudulent loan transactions with regard to the same property of the petitioner, comma, the UCO Bank and the PNB have alleged that the petitioner was a guarantor in a loan transaction, comma, for which proceedings were initiated against the petitioner. It is contended that upon a complaint being lodged by the petitioner before the bank as well as the law enforcement agencies, comma, inquiry was undertaken by the latter, full stop. Subsequently, comma, in a report filed by the anti-fraud wing, anti-fraud section of the detective department, comma, it was disclosed that the title deeds in question, comma, on the basis of which it was observed that those were the secured assets, comma, the were fraudulent. Full stop. Next para. However, comma, the investigating agency could not fix responsibility of perpetration of the fraud on any person, comma, for which the investigation was closed. Full stop. Next para. It is contended that in one of the streams arising out of the same set of documents, comma, the UCO Bank had taken out recovery proceeding under the debts recovery before the debts recovery tribunal, comma, which culminated in an award against the petitioner as guarantor. Full stop. Subsequently, a recovery proceeding was initiated. Full stop. Next para. When the petitioner approached the recovery officer with an application to stall the said recovery proceedings on the ground that the documents which were the genesis of the claim of the UCO Bank were fraudulent, comma, the recovery officer shirked its responsibility by observing that it could not go behind the decree within bracket the award passed by the tribunal. Bracket closed, full stop. It is further contended that on the same basis, on the same set of title deeds, comma, which are actually in possession of the petitioners, comma, the banks in question and the asset reconstruction companies have been raising claims, comma, knowing fully well that the documents in question were fraudulent. Full stop. Next para. Learned counsel for the petitioner places particular reliance on the observations made in the FRT filed by the officer in charge, comma, anti-fraud section of the detective department, comma, where it was observed that during investigation, comma, the documents in question, including 3 title deeds of the same property, comma, loan guarantee papers in respect of loans from United Bank of India, comma, Park Street branch, along with admitted handwriting stroke signatures of Bromkesh Bhattacharya, within bracket, the father of the petitioner, bracket closed, comma, since deceased, comma, were sent to experts for examination and opinion. Full stop. The expert had opined that the signatures of Bromkesh Bhattacharya, comma, since deceased, in the loan guarantee papers of United Bank of India, comma, Park Street branch, are forged signatures. Full stop. Moreover, comma, it was recorded, comma, after several attempts, the responsible persons of United Bank of India and UCO Bank, comma, Shambazar branch, in respect of those loans could not be fixed up. Full stop. Next para. It is submitted that in view of such observations, comma, the proceeding before the recovery officer ought to be stayed immediately. Full stop. Next para. Apart from that, comma, it is submitted that the Pegasus, comma, Pegasus Asset Reconstruction Company, that is the
Respondent 8.
Now, Pegasus Assets Reconstruction Private Limited, comma, that is the respondent number 8, was assigned the debt by the Punjab National Bank. Full stop. Respondent number 8 raised exorbitant claims against the petitioner. Full stop. Whereas the claims as disclosed in the year 2009 were in the range of 67 lakh and odd, comma, the respondent number 8, comma, in the year 2010 itself, comma, gave out that its claim from the petitioner was to the tune of 1.5 crore approximately. Full stop. It is submitted that such exorbitant leap, LEAP, in the claim tantamounts to unfair trade practice, comma, for which the petitioner has also approached the Reserve Bank of India. Full stop. However, comma, the Reserve Bank of India is also sitting tight over the matter. Full stop. Next para. Learned Counsel insists upon grant of ad interim orders to the tune of to the effect that the respondent number 8 be restrained from continuing with its operations, comma, in view of the alleged fraud having been encouraged and perpetrated by the said respondent, as well as stay of all further proceedings in the recovery proceeding pending in connection with the award passed by the DRT at the behest of the UCO Bank. Full stop. Next para. Learned Counsel for the respondent number 8 strongly contends that the allegations of the petitioner are entirely misconceived. Full stop. It is submitted that whereas the assignment was made to Pegasus as long back as in the year 2009, comma, the first complaint lodged before the investigating agencies, that is the police, comma, by the petitioner was only in the month of June, comma, 2017. Full stop. As such, comma, Pegasus entered into the picture much prior to the first complaint being lodged. Full stop. Next para. That apart, comma, it is argued that the petitioner himself, the predecessor in interest of the petitioner entered into that
Himself.
that the
After
petitioner himself had entered
the
into
petition on all the legal heirs of late
the
Bom-
petitioner himself as well as the other legal heirs of the petitioner's father Bomkesh Bhattacharya, comma, the original guarantor, comma, had entered into a compromise petition with Pegasus and had paid up the amount.
This is not compromise petition.
settlement letter was signed by all of them.
Had entered into a settlement
It should appear from
with
letter.
the respondent number 8, comma, by way of a written letter of settlement. Full stop. The parties to the said settlement, comma, being the petitioner and the other legal heirs of late Bomkesh, comma, also paid up the entire claims of the respondent number 8 and thereafter obtained back possession of their property from the respondent number 8. Full stop. It is submitted that, comma, as an afterthought, comma, the petitioner thereafter initiated the complaints against the respondent number 8. Full stop. Next para. It is further submitted that even from the FRT relied on by the petitioner, comma, it cannot be seen that the loan guarantee documents, comma, that the loan documents themselves, comma, which were entered into in connection with the transactions in issue, comma, were observed to be fraudulent. Full stop. Learned Counsel for the respondent number 8 points out from the said FRT that it was recorded therein that 3 title deeds of the same property, comma, within double inverted loan guarantee papers, double inverted clause, in respect of loans from United Bank of India, along with admitted handwriting stroke signatures of Bomkesh, were sent to experts, and the expert opined that the signatures of late Bomkesh in the loan guarantee papers of United Bank of India are forged signatures. Next para. Thus, there is nothing to mitigate the petitioner's liability as guarantor, in respect of the original loan, on the basis of which the petitioner has already paid up to the respond number 8. Next para, learned counsel for the UCO bank also opposes the stand of the petitioner. It is submitted that the UCO bank assigned the debt as far back as in the year 2008. The debts recovery tribunal passed its award against the predecessor in interest of the petitioner on January 11, 2017. Next para, it is further submitted, by placing reliance on certain portions of the said award of the tribunal, that similar points were urged by the petitioner at the relevant juncture before the tribunal itself. As such, the present allegations made by the petitioner have no limbs to stand on. Next para. There are, upon hearing learned counsel for the parties for the purpose of consideration of the prayer for ad interim orders, it is clear that there are two limbs of the challenge of the petitioner. The first limb is in respect of the pending recovery proceeding before the recovery officer in the context of the award obtained by the UCO bank against the petitioner on the self-same set of papers, which are in dispute. Next para, the other limb is in relation to alleged unfair trade practice resorted to by the respondent number 8, and the veracity of the claims made by the said respondent, on the premise that the documents in question, which are the basis of such claim, are fraudulent. Next para, the plinth of the submissions of the petitioner, till date, is the set of observations made in the FRT, which is annexed to the present writ petition. Next para. Although the author of the FRT, that is the officer in charge of the New Alipur police station, in the capacity of his office with the anti-fraud section of the detective department, the same castigates certain title deeds with regard to the property as well as loan guarantee papers in respect of loans from the UCO bank, from the United Bank of India Park Street branch, and does not directly record any observation regarding the veracity of the original loan documents entered into by the borrower. Next para. Although some doubt is cast by the said observations on the role or involvement of the petitioner, apostrophe predecessor, as guarantor in all the transactions, the same cannot be decided conclusively at this stage, merely on the basis of the findings of an expert which were purportedly relied on in the FRT filed by the anti-fraud section of the detective department. It is well settled that the said FRT is not conclusive evidence, even for the purpose of an adjudication in a criminal proceeding, but, at best, furnishes a piece of evidence therein. More so, the FRT cannot even be relevant for the purpose of any conclusive finding regarding the civil claims made by the respondents against the petitioner. Next para. Hence, it would be premature at this juncture to hold that the claims made by the respondent number 8 against the petitioner are inflated or illegal, comma, to such an extent that the respondent number 8 can be held to resort to unfair trade practice, comma, of such stature that its business transactions should be frozen immediately by a court order. Full stop. Next para. Insofar as the FRT is concerned, comma, the same also indicates that although the documents in question were found to be apparently forged, comma, the responsibility for the offense could not be fixed on any person by the investigating authorities, comma, for which the investigation itself was dropped. Full stop. There is nothing on record to indicate that the petitioner ever approached any appropriate criminal forum for reopening the investigation on such issues. Full stop. Moreover, comma, as of today, comma, what is evident is that the petitioner himself, along with other heirs of the alleged guarantor, submitted to a settlement with the respondent number 8 for the purpose of getting back possession, comma, only after which a complaint was lodged with the police authorities. Full stop. Undoubtedly, comma, the petitioner may have a strong case in the criminal proceeding, comma, if any, comma, initiated, comma, as of today, comma, there is nothing to show that that apart from the FRT in question, comma, there is anything to indict or incriminate any of the respondents on the allegation of fraud. Full stop. Next para. Hence, comma, there is no question of grant of any ad interim order as prayed for by the petitioner at this stage. Full stop. However, comma, since the petitioner has made out a prima facie case for final hearing of the writ petition, at least on the factual allegations raised, comma, the respondents are directed to file their affidavits in opposition within 4 weeks from date. Stop. Reply, if any, shall be filed within a fortnight thereafter. Liberty to the parties to mention for inclusion in the list for hearing.
But, may I advise my plea for fixation of the matter for hearing in after completion of affidavits for your lawsuits?
Liberty to mention for inclusion.
To mention that will not.
Whoever is there, then we will be taking up.
At least your losses fixed up at some day your losses.
আচ্ছা, liberty to mention কথাটা না করে মাধব লাস্টে দিয়ে দিন, the matter shall be listed for hearing on September 27th, 2020.
This supplementary affidavit now I am trying to this can be recorded.
Let him include in the rejoinder, because then the
Very well. Since the petitioner seeks to file a supplementary affidavit and the matter has been fixed for hearing, such leave is granted to the petitioner and the supplementary affidavit filed today be kept on record. Full stop.
All parties.
Copies thereof are handed over to learned counsel, the learned advocates appearing for the respondents. Full stop. It is made clear that in their affidavits in opposition, comma, the respondents shall compositely deal with the allegations made in the supplementary affidavit as well.
Mentioned that award has been passed in favor of UCO Bank by DRT3. Award has been passed in favor of respondent number 9.
Who is that?
Your
assigned
of UCO Bank.
আচ্ছা, একটা জায়গায় না ইউকো মনে থাকবে না। Award has been passed in favor of the UCO Bank debt recovery proceeding in favor of the, they are your assignees. In favor of the UCO Bank বলেছি, in favor of the assignee of UCO Bank.
In favor of the UCO Bank.
এটা দি, yes.
In favor of respondent.
Yes, somewhere I said in favor of the UCO Bank. I'll make it assignee of the UCO.
Grateful, man.
Item number 6.
Lord, I am for the petition. Very short matter, non-issue of certified copy of the partition deed.
Service has been effected?
Yes, Lord, service has been effected. My Lord, kindly see that.
Yes.
Kindly see the page 45, the deed. Improved certificate copy of the deed has been supplied, page 45. There is no endorsement of the book number, deed number, page 45. No endorsement of deed number, book number, pages, volume, nothing else. As such, I made a representation.
This was written to you in this form.
Yes. Thereafter made a representation which is page 46 below. This is a certificate copy.
Which registration office?
ADSR contact, yes, 104.
Despite service, none appears for the respondents. Full stop. Affidavit of service filed today be kept on record. Full stop. The prayer of the writ petitioners is innocuous. Full stop. The writ petitioners applied for certified copy of a deed. Full stop. However, comma, when the certified copy was issued, comma, it was observed by the petitioners that there is no statutory endorsement on the last page of the same regarding the book number, comma, volume number, comma, pages, comma, year, comma, etc. Full stop. Next para. Accordingly, WPA 17801 of 2021 is disposed of by directing the ADSR. By directing respond number 4, the additional district sub-registrar, comma, contact 1 to issue a fresh certified copy to the petitioner, comma, on the basis of the application already made by the petitioner in terms of the representation given by the petitioner and annexed at page 46 of the present writ petition. Full stop. The said fresh certified copy, comma, needless to say, comma, shall contain all relevant details as indicated above. No address to cause certain certified copies.
Kindly mention.
Pardon?
Within certain period of time, within 1 month or
আচ্ছা ঠিক আছে shall furnish a fresh certified copy within 1 month from the date of communication of this order to the said respondent.
Item number 7. It may please your lordship, the petitioner's father was a freedom fighter, my lord. After
service?
Yes, my lord. Service has been affected, my lord. This is my affidavit of service. My lord.
This freedom fighter pension?
Yes, my lord. Freedom fighters pension,
on the basis of Mr. Giri's certificate?
No, my lord. What has happened is that, my lord, this is the second round of litigation that the petitioner has to engage. My lord, what has happened, the petitioner since August
6 and 7.
My lord, Union of India, Mr. Indrani Chakraborty is appearing. He has not come to court, for which instructed for praying for not today.
In the Union of India's presence.
Union of India.
Union of India is necessary.
Yes, my lord, necessary, my lord, because they are the pension disbursing authority, my lord.
This is appearing as a top matter.
Yes, my lord, top. My lord, it was mentioned before your lordship.
On the prayer of the Union of India, the matter is adjourned till tomorrow. Adjourned till tomorrow, when it will be listed under the same heading.
My lord, kindly makes it day after tomorrow, my lord, subject to lordship's convenience.
Come back tomorrow. Why day after tomorrow?
My lord,
At a fixed where?
36, my lord, arbitration.
Definitely not. Tomorrow. Yes. Please give all your names, yes.
Appearance.
ওনাকে একটা slip দিন।
Item number 8.
8.
My lord, in this matter, I beg to appear on behalf of the petitioner.
You are also appearing for the petitioner?
No. No.
I'm for the bank.
This is affidavit of service.
Yes.
In.
Bank is the main respondent?
Yes.
Yes, yes.
The account has been settled. They probably now want the return of the title deed.
Yes.
Give them back.
Yes.
Mr. Gupta is wanting, you are not giving.
My lord, may I submit?
The writ petition was filed at the time when the settlement did not take place. Now, settlement done. The only thing, as per the settlement terms, he has to withdraw all pending cases against bank. This is the only condition.
Settlement has been, have you given me a copy of the settlement?
My lord, what he has stated, kindly come to page 45, 46. 45 and 46. The writ petition has been filed on month of February 2023. The settlement has came out on 24/5/2022. Petitioner went several times to the bank. Bank said you pay 30,000 more, then the property will be released. And it has been affidavit by this. This is a heart patient, and he and his wife has been moved from one bank to another. Go to Salt Lake, go and obtain the copy. He goes. As you have retired being a conductor of the SBSTC, you have got many more money, so you give 30,000, which has been stated by the petitioner. My learned friend said the settlement has came out after filing of this writ petition.
Settlement is at page
46. This is the letter of the bank. 45 is my payment. I paid it within 1 month. Prior to that, my OTS 3,60,000. Prior to that, I made an OTS of 2,50,000. That was rejected. After that, I made 3,60,000. I made the payment. They have said that.
Is there any written precondition that you have to withdraw the cases?
No. Nothing was given to me.
Yes, why?
Nothing
Why
was
should they
given
withdraw
to
the cases?
Nothing was given to me.
As per the document which I have received by way of instruction, any or all pending cases with any court must be withdrawn.
That is your instruction.
This is the compromise document. As per the recovery policy, this is the compromise terms.
I don't have.
Produce a copy of that tomorrow. Tomorrow under the same heading. Just take out a hard copy and produce it, and take sure shot instructions that is correct. And because of this, learned counsel for the petitioner submits that the petitioner has cleared all dues of the bank, but the title deeds of the petitioner are not being returned. Learned counsel for the bank submits on instruction that the settlement terms between the parties also included the clause that the petitioner is required to withdraw all pending litigations against the bank. Learned counsel for the bank is requested to furnish a copy of the said settlement tomorrow with a copy to his counterpart appearing for the petitioner.
I have received a statement of account which shows that there is zero balance.
That you have said.
Yes.
You are not objecting to that. The matter shall be listed tomorrow under the same heading. Thank you. Audience. তাই করে দাও, একটাই আছে। আমরা থাকলে সবই দিয়ে দাও 10:30 দিয়ে। কিন্তু 10:30 কালকে দিলে ওরা জানতে পারবে, কালকেই থাকার কথা। একদিন আগে দিলে ভালো হয় না আন্দামান ম্যাটার? ওটা কি কালকে রিটার্নেবল? ও তাহলে ঠিক আছে, কাল 3টে দিন সব দিতে একসাথে।
Original side mentioning.
My lord, before your lordship takes that up, my lord, I apologize for even craving this indulgence, my lord, but under compelling circumstances, my lord, may I mention 2 writ petitions, my lord. This is against, my lord, original side, my lord, against declaration of willful default as confirmed by the review committee, my lord. They may go ahead and make the publications and forward the information to the credit information companies any day, my lord. There are 2 petitioners, my lord. I'm craving your lordship, my lord, petitions are affirmed. May I file, and my lord, also seeking dispensation with writ rule 26, my lord, for moving without notice.
After review committee, no.
After
No
review
dispensation of Rule 26.
My lord, will your lordship be intend to
There
take
is
it?
very little scope of interference, Mr. Shah, you know that.
I do appreciate, my lord.
Rule 26 I'll refuse.
Very well, my lord, but if
But
your lord-
leave is given, you have got the applications ready?
Yes, my lord, it is ready.
Prepare those applications and granting leave to for it to tomorrow. Is it possible now?
Yes, my lord.
File
Yes,
now?
it is, my lord. It is. We will
leave দিলে
do the
কালকে চলে
needful.
আসবে। তাহলে leave একটু দিয়ে দেবেন একটা। This will appear tomorrow.
I'm extremely grateful, my lord.
কালকে উপর দিকে দিয়ে দেবেন একটু। Leave-টা দিয়ে দিতে হবে।
My lord, I am praying leave to make an application for draw and complete of the order passed
What?
by draw and complete of the order passed by your lordship on 14 July.
এটা কি ডিগ্রি হবে নাকি? কিসের order?
Usually it is filed within 7 days of.
ও আচ্ছা আচ্ছা। তাহলে এটা কি করতে হবে বলুন? হ্যাঁ, লিস্টে দিতে কালকে দিতে লিস্ট। Yes, very good.
I'm grateful.
With your lordship's kind leave, may I mention item number, with your lordship's kind leave,
Sorry, Your Lordship.
Yes.
His Lordship, kindly may mention item number 6 of today's list, Your Lordship. Lordship, the matter is settled, Your Lordship. I'm praying to withdraw the matter, Your Lordship.
Your other side is there.
Not appearing since quite a long time. Bank
Then
is there, Your
please wait
Lordship.
for it to be called on. Otherwise, someone will come and make an allegation.
Deeply
Please wait for the call.
Deeply obliged.
Thanks.
Any mentioning? Monthly list for hearing, item number 1. What?
My lord, I'm to give my reply to them, not.
Yes.
Mr. Shah is supposed to join Melody. Said on last occasion he will take.
Hey, our joint code union, okay.
He has already completed.
Yes, yes, finished. No, he had finished. He had finished.
Finished.
He had
Lordship,
finished.
I'm appearing for the respondent and on behalf of Mr. Shah. He's supposed to appear before Lordship virtually today. Lordship.
I mean, to hear Mr. Bachawat.
Lordship.
Let him appear and hear Mr. Bachawat.
Lordship.
Yes, no difficult, no objection, no difficult. Yes.
Only difficulty, my lord, link. His,
No, you did not intimate previously.
yes, my link
Well,
is there. He has to just allow him to enter.
Yes, whatever has to be done, do it. I mean, get it done. Ki korte hobe link?
Okay.
There is no application for sending a link at any point of time.
But my lord, I have been told Mr. Joy Saha has a link, my lord.
I don't know how he has a link. So let him join from that link.
My lord, my lord.
ওনার যদি লিংক থাকে উনি সেই লিংকে জয়েন করুন অন্য কেউ তো দেখতে পাবে আমি না দেখতে পাই Yes, Mr. Bachawat, let us hear you. Yes.
I'll keep it very short. I'll keep it very short. Just remembers this that your lordship has heard it after affidavits. Now, most of the arguments your lordship will find which have been made are not based on any statement in the affidavit. I'll show that.
No, এই এটাতে কোনো নোটস ফোটস কিছু নেই আমার না নোটস আমার ওই যে হাতে লিখি না যেগুলো নোংরা নোট কিছু তো নেই না কিছু তো এত বড় ম্যাটার থাকে তাহলে Yes, I'm sorry. Please continue.
Either they are not on affidavit or whatever has been submitted is contradicted by the documents. In fact, two of the major arguments. Your lordship will remember two of the major arguments run by Mr. Shah and by Mr. Mukherjee, one of them. One is, I can transfer a non-stressed loan under Section 5. And that will override everything. Now, Lord, that I'll show your lordship. But again, is an imaginary argument or something in vacuum for a very simple reason. The notice of sale is for a stressed assets. The agreement for transfer that they rely on is of a stressed asset. So obviously, not that argument has no bearing at all.
No, Mr. Bachawat, only yes, you have a point there. Definitely, you have a point, strong point. But mention of stress, can that vitiate if they otherwise have a power?
No, there's a little bit more. It says that it is a sale of stressed assets under RBI guidelines.
Yes. They do that.
And the argument is Section 5 overrides all RBI guidelines. There is nothing. Although there is no challenge to the RBI guideline, not for a RCL which is buying under the RBI guidelines to say they are not binding an ultra vires Section 5 without a challenge.
Is there a qualitative distinction between the two sorts of sales? I mean, both are sales.
No. There. No. Not one is really speaking, not a non-stressed asset can only be transferred to a bank or a financial institute. It can't be transferred to an asset reconstruction company. That's the vital distinction, which is why I'm objecting to the transfer. It kills me. I can't have a bank hereafter.
No, you say that on the basis of the RBI circular itself.
Yes, I'll show that. I am not running away from it. I was just making the point and I'll show it.
Yes.
This is one part. The other part is Mr. Shah again based his argument on the basis that no moratorium has been granted to me. He says this after affidavits. His affidavits don't say that. And I have annexed the notice from the bank giving me this benefit. His letter is on record. After that, I don't know how this argument is made. So, two of the biggest arguments go straight there, ex facie. So, may I first take your lordship to the notice of sale. Please take page 125B. or rather not starts from 125A. 125A.
Yes.
Lord, in this connection, we inform you that your account is NPA. And in terms of the extent guidelines.
Same with my copy also.
Lord, in terms of the extent guidelines, bank will take necessary. He's talking about some guidelines. Now we'll see what that is on the next page. Now, my lord, please see the next page. The notice.
Yes.
Transfer of state loan exposure by SBI. Now, my lord, how is it being done? In terms of the bank's policy on transfer of stress loan exposures, in line with the RBI guidelines on transfer of stress loan exposure. Now, my lord, after this, and your lordship will find, my lord, 10 places where stress loan is not mentioned. Please see, my lord, before the box, brief details of stress loan exposure. Lord, please see para 3, further details of stress loan. Para 4 says stress loan. All over, my lord, stress loan is writ large. So what he is transferring is a stress loan, which can be transferred to a RC.
And they have said that it is in terms of the bank's guidelines regarding.
Also the bank's guidelines, but guidelines on transfer of stress loan, RBI guidelines.
That
Yes,
remains.
yes. So, my lord, after this, no section 5 argument.
They are following their own policy on transfer of stress loans also, which may not be applicable to non-stress loans.
Correct.
That may be there also.
Correct. So,
Very
not
good.
all that I'm saying is not, does this argument lie in their mouth? At all.
Probably what they were arguing, Mr. Bachawat, was yes, they say that it was spelled out as a stressed loan, but even if they have a power otherwise, they can assert that.
But I may have understood
yes.
differently. The way I understood it,
Yes.
Mr. Shah tried to first justify that this is not stressed. Or rather, this is a stressed loan. That is what is stressed.
Yes,
with this.
definitely.
So he's saying it's a stress. He's saying it's a stressed loan. But even if it is not,
yes,
I can transfer it. This is what I understood of
Yes.
it. Lord, I'll deal with that section 5 argument. Lord, later, let me first deal with the meat of the matter. Now, my lord, there were 3 limbs of his moratorium argument, as I understood. Number 1, you did not apply for COVID moratorium relaxation and you did not get it. Number 2, he says that, look, you were in default before the moratorium started. So I get 46 or 44 days before.
Yes.
And I get 46 after. On the 90th day, I have classified you. This is what he tried to show. I will also show how wrong it is, how horribly wrong it is. It has nothing to do with the facts. Number 3, he then argued that, look, even assuming that those dates are all wrong, under the RBI guidelines, I had the right to declare you as a NPA because the guidelines only stopped me from recovery. It stopped recovery proceedings, not declaration as NPA. This was the 3rd limb of his argument on moratorium. So, my lord, may I first, not straight away, bust the first rung of his argument, my lord? He says, I did not apply for and did not get it. Now, my lord, please take page 67. Now, first point to note here is he has not mentioned it anywhere in his affidavit, although I have disclosed this document. Page 67. Yes. Which is why, my lord, if your lordship remembers, when doing the PNB matter, I said, Lord, someone should make this statement of oath, otherwise don't permit such arguments. Lord, after all, he is also a public bank. It's not, Lord, that he can come and say anything he wants to. Now, my lord, please see this. SBI writing to Atibir. So, genuineness of this letter is not denied. With reference to your request for deferment of interest and installment of term loan, it is being advised to you that the following change in repayment schedule has been approved by the bank in terms of COVID-19 relief package extended by the bank. And Lord, days have been spent arguing this. Now, Lord, please also see the dates. Lord, the first 2 dates are relevant here. Original repayment term. So, Lord, I'm not in default before that. 29th May 2020, I have to pay 80 lakhs. That is rescheduled to 30th September. On the right-hand column, proposed. So before 30th payment, 30th September, nothing is due from me. This much is clear. But please see the next date also. 29th of August 2020, 80 lakhs is due. That is shifted to 30th of December. Now, Lord, if these dates are correct and the bank's letter is correct, and it must be taken to be because there is no dispute to this letter, then, my Lord, 30th of September is when I had to first make payment. In which case, NPA cannot be for 90 days thereafter under the RBI guidelines. So this October date falls on his own document. He chose the date of 16th October as NPA. So, not first I'm busting the theory that no extension has been granted. I show your lordship, extension was granted. Now, second thing I will show your lordship is that I never crossed the limit. The term loan limit. Now, Miller, please turn the page, comes to page 68. This is my bank statement, no challenge. It's issued not by the bank, not by me. Please see the second date over there. 6th of April, 2020. Deposit transfer, 80 lakhs. Installment for February. So I've paid the installment for February, maybe 60 days late or something like that, but I've paid. And moratorium was from 1st March. But not, please see the extreme right-hand column. Please see the limit over there, 16 crore. Your lordship can make a note, page 34. Lord, if your lordship goes to page 34, your lordship will find that the limit was 16 crores. I'm sorry, not page 30. I'm sorry, my memory has it wrong. Page 30. Number 30, your lordship will find the heading facility. Under it, please come to the third one, ABC. C is TL, term loan. Please go to the fourth column. Please see 16.80 crores is the limit. So, my lord, I am well within limits. As per his document, which is issued on 15th of September 2020. So, my lord, as on April, there is no default. If there was any earlier default, that also is not there. In his, he referred to one letter, which I'll show your lordship presently. But if there was any default, it is cured by this payment on 6th April, where I have come fully within limits. Now, my learned friend relied on one document, which was the NPA notice, which is at page 94.
Yes.
5th of April 21, he relied on this. The account of, this is the one by which I was declared NPA by him. The account of Messrs. Atibir has been running irregular since, this is the date he relied on, 17 January.
Yes.
Since Honorable Supreme Court has lifted the blanket ban on NPA classification on 23rd March 21, the account of the caption company has been classified as a NPA on 31st March 2021 with effect from 16th October. So this is what he relied on. Now, please see something. First, there's a blanket ban by Supreme Court. Forget RBI circulars. According to the bank, there's a blanket ban by the Supreme Court on declaring as NPA till 23rd of March. He declares it with a back date. That back date, in any case, I show your lordship is wrong. Now, let me take Mr. Shah's argument a little further. Let us assume that on 17th of January, I was running irregular, not NPA. irregular. In February, I've paid 80 lakhs. Default cured, I've showed your lordship, I'm within limits. But I'm not relying on any fairy tales. I'm relying only on the bank's documents to not falsify each of his three arguments. This letter of the bank, read with the sanction limit, read with the bank statement. So, no question of NPA before or after. No question of it being a stressed asset at that time.
So this 44, 46, this goes.
So this 44, 46 goes out of the window. His theory of 17th October goes. My learned friends also, they have a calculation point that even if you go by 17th, there's still a one-day difference. But not the main point is, I was not stressed. I could not have been stressed. His documents say so. His affidavit does not bear out what he's saying. Now, if that goes, the entire thing falls. Because, the transfer is dependent on this being a NPA. If it is not a NPA, no transfer can take place as a stressed asset in this case. So the precondition for the transfer goes. Now, if that goes, if I may put it this way, his other arguments fall because the necessary effect of it is all consequent actions are then rendered void. If there is no NPA, the declaration falls. The declaration falls means the transfer notice also goes. Now, one argument made by them is, look, I have already assigned. So, too late. Now, can anyone show the thumb like this to court? My writ petition was filed. I had an interim order. I withdrew. Within the next day, they issued the notice. I moved with the during the pendency of the writ petition if they choose to transfer in hot haste. I'm sure your lordship will not turn a blind eye to this conduct. And given the fact that ex facie, no NPA, nothing, and an attempt is made to run the case, look, I never gave you extension. Then they argue, look, you were in default earlier. But none of this is borne out by any statement. This conduct from the bank, where they are permitted to make an argument which is not backed up by a statement from any reliable officer. But I think in future, should be discontinued.
Mr.
Lordship will not permit.
Another angle was sought to be opened by Mr. Shah probably
Yes.
vis-a-vis what you said.
Yes.
That even if it is transferred to an asset reconstruction company,
Yes.
how are you affected in the sense that,
Yes.
I mean,
Yes,
bank-
I've showed your lordship.
told-
I don't have a banker left anymore. What is the job of asset reconstruction company? I've showed your lordship from the act. It can't carry on banking business. Now, two things follows. What is therefore its business if it can't do banking business? Its job is selling my assets and recovering its money. That's all.
And if your NP argument is accepted, then in any event, all the banking activities are kept open. I mean,
yes, absolutely, absolutely, absolutely. I can't be kept out from having a bank, and that's the object. Please remember, this is a special statute. SARFAESI is a special statute. But if my learned friends claim rights under the act, then they must also live up to the fine points. They must follow it to the T. They can't say, look, it doesn't matter. I may have said this. That was one of the arguments made. Very well, the date is wrong. So what? I don't know how this argument can be made. These are responsible bodies. Today, State Bank of India is the largest bank in the country. Now, if these statements are not backed up by the statement of a responsible officer, and on that basis, my death warrant is signed, look at the effect of it. This is a large industry, with a steel plant or running steel business. 2,000 employees. You can't sign the death knell when there's no, your lordship has seen. Please, let's go back to that bank statement once. I need to show your lordship something. page 69, no? 68.
Yes.
Now, my lord, your lordship has seen 16.8 was the limit. I've showed your lordship that.
Yes.
Now, my lord, please see at the beginning of the month, I was over the limit by 19,000 rupees. Or, no, sorry, 99,000 rupees. No, 19,000 rupees. Then I brought it down, my lord, to 16 crore 80, the limit. Then I brought it below the limit. And Lord, when it goes up the limit thereafter, after I've cured it and after no NPA can take place, please see, Lord, please see how much it's in moratorium during the period. How much have I crossed it by? 15,000, 20,000, Lord, on loans worth such a large amount. Lord, is this not random, Lord, action by the bank? I can understand someone with Lord 300 crore due, he is not now owing 5,000 crores. That's a different thing. But for few thousand rupees. And during the moratorium, now, Lord, let me bust the third argument which Mr. Shah had. Mr. Shah said that, look, the circulars only prevent recovery proceedings. They do not prevent me from declaring you as an NPA. Now, my lord, let's just have a look at those circulars. They say to the contrary. They say I cannot be classified as an NPA during that time. But please take the first circular, which is at page 58. I'll show your lordship from the first and the last, both. Two clauses I'll show your lordship.
No, but probably Mr. Shah said something like that you cannot classify during that period as NPA, but the time runs sort of. I mean, that.
I'll show your lordship, it doesn't run. I'll show you
on the reopening date, you can.
It says that not everything is shifted across the board by 90 days and nothing can be done except in accordance with the revised due dates and the revised schedule.
The expression residual tenor is also there in your favor, apparently.
Yes, I'll show you a lot.
Says
yes.
also the residual
Absolutely.
tenor. Anyway.
Lord, please comes to page 58, clause 2 at page 58.
2, yes.
Now, my lord, I don't think I need to read the first sentence. Your lordship goes to the second sentence. The repayment schedule for such loans, as also the residual tenor, will be shifted across the board by 3 months after the moratorium period. So, my lord, moratorium period, my lord, 30th August, it ends. My lord, 3 months thereafter. My lord, please see at the bottom the footnote. Installments will include the following payments falling due from 1st March to May 31st, principal, interest, etc. Everything is not included. Then, my lord, please turn the page. Please
the
see.
only catch is that interest shall continue to accrue on the outstanding portion of the term.
I'm not disputing.
That is the only thing you are suffering.
My lord, I have never said that I will not pay interest. But am I saying that? I'm not running away. Now, my lord, please take page 59 now. Now, my lord, first see clause 5.
Yes.
Since the moratorium, deferment, recalculation of drawing power is to be provided specifically to enable borrowers to tide over economic fallout of COVID-19. The same shall not be treated as a concession or change in terms or conditions of loan agreements due to financial difficulty of the borrower. In other words, it's not to be seen as a default on my part. It is a general concession being given because of COVID. That's the meaning, not what my learned friend said. Then, Lord, please see under para 2 of the annex directions, etc. Then, consequently, this line is what Lord gives it that. Consequently, such a measure by itself shall not result in asset classification downgrade. So, if I'm not an NPA, I will not become a NPA. And that's made even clearer by the next one. The asset classification of term loans, which are granted relief as per para 2. Now, my lord, have been granted that relief. I've showed your lordship the letter. Shall be determined on the basis of what? Revised due dates and revised repayment schedule. End of the story. Similarly, working capital we are not concerned with. Now, my lord, please turn the page. Please see 7. The rescheduling of payments, including interest, will not qualify as a default for the purpose of supervisory reporting also, my lord, and reporting to credit so and so. So, my lord, nothing can be done which can affect my right And that too for such a paltry sum. My lord, please see the last circular also, page 64. My lord, at the bottom of the page, similar line, accordingly, repayment schedule for such loans as also the residual tenor shall be shifted across the board. Your lordship has got that. Then, my lord, please turn to 7. At page 65, asset classification, the conversion of accumulated interest into FITL as permitted in para 3 and changes to credit terms to specifically tied over economic fallout in terms of para 4 will not be treated as concessions granted due to financial difficulty of the borrower under so and so, and consequently will not result in asset classification downgrade. Same language. Then, my lord, in respect of accounts classified as standard on 29th February, even if overdue, and the moratorium period which granted in respect of term loans shall be excluded by lending institution from the number of days past due.
তুই একটু 9 নম্বর কোর্টে যা।
Under the IRAC norms.
কোথায় আছিস তুই, কোথায় পড়ছিস?
The asset classification for such accounts shall be determined on the basis of revised due dates.
Yes.
Lord, I believe your lordship had more interesting incidents.
I have some knack for attracting these things.
Yes. Your lordship also has a skill at deflecting it. Your lordship has
only non-advocates, not members of the bar.
Somebody was asking me, you should not know that judges also have sense of humor.
So, my lord,
so this is always settled.
So, my lord, these 3 points are the points raised by them. Now, my lord, the section 5 point, if I may take 1 more minute on that, my lord, I've already showed your lordship that, my lord, the transfer is being sought to be made by the bank as a NPA. Now, my lord, please see. Lord, this is the seller. Now, the buyer. What has he got? Please take his opposition.
Circular for yes.
But in his opposition, he has annexed his assignment agreement. Now, what did he buy? Please come to page 46. I'm taking your lordship straight away to the relevant clause. I'm not taking your lordship through anything else.
Yes.
46, subpara C. The loans are non-performing assets and have been duly and validly classified as such. Duly and validly classified as such. In accordance with the guidelines issued by whom? By the Reserve Bank of India. In this regard. Now, my lord, after this, these not arguments, not purely academic. Purely academic. Not we, I mean, there are matters and matters we may sometimes not come and argue a law, my lord, where it not there are wider public considerations involved. But to make this not argument in pure academia, where the facts are all completely to the contrary, not it's something which not I must say it leaves me a little stunned. So, not seller bank says I'm transferring a NPA. He says I'm buying subject to this being a valid transfer under the RBI guidelines, and then an argument is made RBI guidelines are not applicable. Now, Lord, this is on the basis of section 5. If I may take 30 seconds on that, and then I finish. Lord, if your lordship not please take section 5. Lord, according to me, section 5 is nothing but providing the mode of transfer. And saying, look, technicalities such as Stamp Act, Registration Act will not apply to such transfers. That's all that it is. Nothing more, nothing less.
Yes.
But all that it is doing is permitting transfer of an actionable claim without having to follow the rigors of TPA, MLODA, Stamp Act, Registration Act. Is providing the mode, nothing more. But it does not nullify the RBI guidelines for a very simple reason. Not the RBI, not what the RBI guidelines say bears this out. Not these provisions have come into force in 2005 with some amendments here or there. Now, Lord, your lordship has seen all the RBI circulars at 2017, 19, 22. Would the RBI not frame guidelines knowing that they are all overridden by this? Is it not believable? And can, my lord, this argument be made both by the bank and the RCIL, which are governed by those RBI guidelines. And will your lordship permit this argument? Go challenge the Viris if you don't accept it. But no one can say a act of parliament is void and I don't need to comply with it. If it is void, go have it declared as such. But till then, you have to follow it. That's the end of the matter. Don't permit these arguments to be made at all. This, in my respectful submission, at least in this case, deserve some punitive damages. Now, if I may read 5. Notwithstanding anything contained in any agreement or any other law for the time being in force, any asset construction company may acquire financial assets of any bank or financial institution. How? So it's providing the mode by issuing a debenture. B, that's A. Or B, by entering into an agreement. So these are the two modes by which you can take it. Notwithstanding, my lord, any requirement of the TPA, Registration Act, Stamp Act, etc. That's what this means. Now, my lord, why? Please see, my lord, 1A. Any document executed by the bank or FI under the subsection 1 in respect of the asset reconstruction company acquiring financial assets for the purpose of asset reconstruction shall be exempt from stamp duty, provided that the provisions of the subsection will not apply where acquisition of the financial assets is for the purpose other than asset reconstruction or securitization. Then, 2. If the bank or financial institution is a lender in relation to any financial assets by the so-and-so, by the asset reconstruction company, such asset reconstruction company shall on such acquisition deemed to be the lender, and all rights of such bank or financial institution shall vest in such company. So there's an automatic vesting happening. And all of this, but this is only providing the mode. It does not say that all laws in India are not abrogated when it comes to a transfer made to RCIL. A transfer made to RCIL is a holy relic which can't be touched with anything else. But that is certainly not the meaning of this. It provides the mode, not 16(1) A and B. May transfer A, B. That's it. There's nothing more, nothing less. The RBI's guidelines have come in after that. No one has ever challenged it. No one has ever said that, look, those are not binding. Their sale notices say it's being done under the RBI guidelines. Not after that to not say that they are not binding. When it suits me, it is binding. But I will take action against people under those very same guidelines when it suits me. When it doesn't suit me, I say they're not binding. Don't permit this kind of thing. But those are my submissions. I don't think I need to trouble your lordship any further in this.
Self-close arguments. Yes, Shan Pleasure. Learned counsel for the parties. Yes. Yes, please file that. When, how soon can we do that? Very short.
Kindly give us 3 days time. We'll file the notes.
Nothing new should go into this. That's all.
Section 5. All this nice innovative punitive damages he wants.
Learned counsel for the parties. Hearing is concluded. Full stop. Learned counsel for the parties are requested to file their written notes of arguments on August 11, 2023, when the matter shall be listed at the top for the purpose of filing such written notes.
Right. One last point was left, not as my learned friend points out. There was another point they had argued, point of suppression of NCLT proceedings.
Yes.
This was another point. I deal with it, but this will matter at the stage of not trying to obtain an ex parte order. Here we never tried to obtain an ex parte order. We moved on notice. Not after affidavits. This doesn't matter. There are judgments to that effect. I have them, but I don't think one needs to cite it. At the final hearing, it doesn't matter. Do the meter. But my learned friend is very thorough.
Yes. I'm close to the world. Written notes are near. Thank you. Thank you.
I am obliged to you.
Deeply obliged.
Yes, sir.
I am for the petition. My lord, may
I am for the respondent lordship, Mr. Avinash
But
Kankani.
this is my lord, the same case. Your lordship, my lord, please let me complete. I am not going to proceed with the case. Please, I am not going to proceed with the case, my lord, because actually your
You
lordship
are
has
going to do what?
My lord, Mr. Kankani is very ill, not feeling well, my lord. He is not.
My lord, I am not going to proceed with the case. Your lordship has already told me to
Our
not press
opposition,
this
my lord,
application.
ready. May I, my lord, submit our
What
opposition?
is opposition?
Yes, lordship.
My lord, one mail,
Yes,
my lord.
Mr. Dhatt, yes.
One mail, my lord. This is a similar type of case as the item one was, my lord. And my lord, kindly see the last order, my lord. How, my lord, they should be more responsible than the nationalized bank, my lord. They should be more responsible than the nationalized bank. It is a registrar of company, my lord. Still, I have not filed the application for perjury, and my lord, I waited for this opposition. But still, there's nothing, my lord. So, my lord, I believe they will not appear, or they should, my lord, apologize before your before my lord that they have made this wrong submission. This is recorded in your last order, my lord. I myself was, my lord, actually shocked on the last hearing that my client is misleading. Before I should also believe the authorities are saying the right thing, my lord. So I myself was shocked that thereafter I
This clause is in a reply.
They have nothing stated. This is nothing. Even after affidavit,
So they are filing their opposition.
there's nothing in that.
You can use this. Put this in your reply, if you want. It take to Ferot.
My lord. Thank you. On this basis, your lordship, actually, I've kept this petition pending. Otherwise, I was going to.
When would you file your reply?
Within 1 week, my lord, I will file it.
My lord, may I file, my lord?
The affidavit in opposition filed by the respondents be kept on record. First up, the time for filing reply is extended till August 14, 2023. First up, the matter shall be listed on August 16, 2023 for hearing. Extension করে দিলাম যে এক সপ্তাহ আগে কোনো ডিরেকশনই ছিল না there was no direction previously.
Yes, lordship.
There was a
Affidavits
direction.
are directed, lordship. Your lordship.
Direction, this is the order, my lord. Sorry. My lord said there is a disputed question of fact need to be decided on affidavit. My lord said.
Did a direct affidavits previously?
Direction has it.
Let me check up.
Yes, my lord, page 2, it is there at the last paragraph of page 2. However, since factual disputes have been raised by the parties, the respondent authorities are directed to file their affidavit in opposition. So, there's a direction. I'm grateful, my thank you.
Let's see.
Item number 3.
Lord, I am for the petition, my lord.
Service.
Yes, my lord.
What is your grievance?
My lord, they misplaced the page 3 of my deed, RA, Register of Assurance. When they scan and keep the documents in their computer, during that time, they missed. I applied for the certified copy and I found that page number 3 is missing. My client went there. RA told my client to go and approach before the bank to give the documents. That was mortgage. So bank refused. My client petitioner informed the bank and also RA. But
no, this document was used for taking a loan.
Loan, my lord. It was mortgage. The flat was purchased via way of mortgage.
No, who lost page 3 of that?
Page 3, RA, Register of Assurance, my lord.
So when you gave it to the bank, subsequently you
their page is there. Bank took the original documents, page is there.
How you sought for a certified copy?
I sought for a certified
How
copy.
did you discover when you asked
for a certified copy? They give certified copy and page 3 is missing.
So what do you want now?
Lord, kindly ask them to rectify that. Ask the bank to give the page and to insert that page in that documents. Otherwise, I can't get each and every time when I ask for the documents, they don't supply the page number 3.
The bank has the originals.
Bank, my lord?
Bank has the original.
Bank has the original, my lord.
So
And-
how can there be a liaison between between the registering authority and the bank? If they were present, represented through counsel, I could have directed them to produce an authenticated copy which could have been placed before the registry.
Kindly then make a
I'll
note
give
to
that
them.
direction and dispose of the writ. Despite service, none appears for the respondents. First of the affidavit of service filed today be kept on record. Stop. The petitioner is facing a peculiar predicament. Stop. The petitioner had obtained a registered deed, comma, which was placed as security for obtaining a loan from the Axis Bank. First up, next para. However, comma, subsequently, when the petitioner sought for a certified copy of the same from the Registrar of Assurance, comma, Kolkata, comma, the said certified copy which was handed over to the petitioner had page 3 of the document missing. First up, at this point, comma, the petitioner came to know that at the time of scanning the document, comma, the registering authority had apparently misplaced page 3 of the said document. First up, next para. In order to prevent the perpetuation of such omission in future, whenever the petitioner seeks a certified copy, comma, the petitioner approached the Axis Bank for handing over the original document for the limited purpose of placing the same before the registering authority, comma, to rectify the defect. First up, however, comma, the said documents were not released by the bank, comma, since those were the securities for the loan obtained by the petitioner. First up, next para. In the circumstances, comma, the only plausible option is to direct the bank to furnish an authenticated copy of the original deed of title of the petitioner, comma, which is lying with the bank as security for the loan obtained by the petitioner. First up, if and when the same is furnished, comma, the petitioner can produce the same before the registering authority for rectification of the records of the latter. First up, next para. In such view of the matter, comma, WPO 1468 of 2023 is disposed of by directing the respondent number 4, comma, that is the manager of the Axis Bank, comma, Arch Waterfront, comma, 16th floor, comma, F4, comma, block GP, comma, sector Roman 5, Salt Lake, Kolkata 7,91,000, to issue an authenticated copy of the title deed of the petitioner, comma, dated November 25, 2020, comma, a copy of which is annexed at page 8 of the present writ petition, comma, to the petitioner within a fortnight from the date of being approached by the petitioner with a server copy of this order. First up, upon such authenticated copy being handed over to the petitioner by the respondent number 4, comma, the petitioner shall produce the same before the respondent number 2 or 3.
Milord.
Additional register, I suppose. Additional register or registrar?
Register, Milord. Before the register.
Before respondent number 2, comma, the registrar of assurance, comma, Kolkata. First up, upon such copy being furnished, comma, the registrar of assurance shall take necessary steps for immediate rectification of its records pertaining to the deed of the document, comma, a copy of which is lying with the registrar, comma, to the effect that the missing page 3 is incorporated therein. First up, next para. The registrar of assurance will be at liberty, comma, at his option, comma, to keep on record the authenticated copy, comma, if necessary, for the purpose of rectification of the records. Full stop. Such exercise shall be completed by the respondent number 2 as expeditiously after being approached by the petitioner with the authenticated copy as possible, comma, positively within 4 weeks thereafter. Full stop. Upon completion of the said exercise, comma, the registrar shall furnish a proper certified copy of the document, comma, containing all pages thereof, comma, upon a fresh application being made for the same by the petitioner. No address to cause urgency.
Affidavit of services.
Affidavit of service filed today be kept on record.
For hearing, item number 4, Pathat.
Your Lordship, before my learned friend moves his application, this application was served with an indication that it will be listed on Tuesday, tomorrow.
I'll take it.
has.
May I file my opposition
To the writ petition.
to the writ petition? Till today, no reply has yet been served.
What about the reply?
Your Lordship, 1 week. Within 1 week, we'll file.
Since the application was to be listed tomorrow, comma, as per the impression of the respondents,
Your Lordship, the writ petitioners.
as per the impression of the writ petitioner, comma, the same is not taken up for hearing today, full stop. Affidavit in opposition filed today in connection with the main writ petition be kept on record, full stop. The time for filing reply is extended for a week from date, full stop. The matter shall be listed along with the connected application on August 16, 2023.
I'm grateful.
Thanks.
Item number 5,
My lord, item number 5, I beg to appear on behalf of respondent number 2 and 3.
On behalf of the petitioner, my lord.
My lord, with your lordship's leave, may I file the affidavit in opposition and the affidavit of competency in court? Grateful, your lordship.
There was a previous direction to file.
Yes, your lordship, there was a direction.
What about your reply?
My lord, Ms. Rashi Kajaria is appearing in the matter,
Sir?
my lord. Ms. Rashi Kajaria is appearing in the matter, my lord. She's on her way. My lord, kindly grants a short passover, my lord.
No short passover. What about your reply? Do you have any idea?
Yes, my lord, by an order dated 21st
Do
July.
you have a
2023.
copy of the reply with you?
No, my lord,
Is it ready otherwise?
no, my lord, we need some time, my lord. Just
Till
1
that-
week, just 1 week time, my lord.
The affidavit in opposition affidavit in opposition filed today be kept on record. So the time for filing reply is extended till 1 week hereafter. First of the matter shall be listed on August 16, 2023.
Grateful, my lord.
I'm deeply obliged, my lord. My lord, I'm led by Mr. Owen Banerjee.
appearance to.
He is there in court,
Not now, not.
in the court premises,
Yes,
court
my lord.
building?
Yes, my lord.
Then give his.
I'm grateful, your lordship.
Item number 6,
I'm appearing for the petitioner.
Yes, please move on.
Uh,
What
we-
about service?
uh,
Service has been affected on the respondents.
We have served, my lord.
Affidavit of service is required. Somebody was appearing for the other side.
Yes, no, my lord. My senior learned advocate had mentioned the matter before. We are withdrawing the matter.
You're withdrawing the matter?
Withdrawing the
Oh,
matter.
say that. Without liberty to file affidavit.
Without.
On the prayer of the petitioner, WPO 1460 of 2021 is dismissed as withdrawn without any order as to cost.
Published.
Interim order, did I pass any interim order here? Interim order, if any, stands automatically vacant.
item number 7 to 10.
My application.
Right. Respondent. He's in Kolkata now?
Yes, he's here. But he was my other side in the other matter that we were just doing before Kotu number 36. I ran down, he was walking down.
Yes, seven. Let us start.
But 4 matters are connected. It pertains, Lordship will take up it Bali Jutta first. Bali Fab. Right. Lordship is looking at Bali Fab, which is the first matter. But after the matter was filed, they took out a supplementary affidavit in opposition. To that, we've given our opposition to that supplementary, and they have given their reply. I'll just file the affidavits. We've given them advance copies. All four are there.
Lord, may I file the supplementary affidavits? And Lord, also
reply.
reply.
সবকটার আছে না, যে একটা কল হবে শুধু সেটাই থাক। বালি ফ্যাব যেটা আপাতত।
আচ্ছা, একটা করে দেবো?
হ্যাঁ, বালি ফ্যাবটাকে দে। একটাই করি।
না না, আমি জমা করে দিচ্ছি, ওনারা জজ সাহেবকে দেবেন একটা করে।
হ্যাঁ, 4টি করে দিয়ে দিন।
আর এটা রিপ্লাইটাও দিয়ে দিতে হবে। I'm taking up Bali Fabs first.
Yes, ma'am.
All are connected basically.
Yes, same different companies, same scheme, same respondent.
With few differences that will
I'll point out, two can be clubbed together. But I can just address your Lordship on Bali Fab today. It will be more or less the same for respect of other. There is an incentive scheme for acquisition of plants and machineries. This is the name of the scheme. In short, they call it ISA PM. Now, when I apply, I'm entitled to certain incentives if the machines are in a certain condition and they're used in a certain way. Now, in Bali Fab, there are two schemes. One scheme came effect from 1st of October 2013 till 31st March 2017.
Yes.
1st October 2013 till 31st March 2017. And the second scheme is 1st April 2017 to 31st March 2020. The first scheme is at page 22. And the second scheme is at page 69.
There's just one point, Lord, because it goes to the root. That's why, my Lord, I'm interrupting my learned friend. My Lord,
I can't forget Mr. Banerjee's comment. He said that both of you are appearing in the same matter before the same judge, obviously. He came running in and you were walking in. So you were walking and you came a bit later.
If I was the
Can't forget
petitioner,
that. And I can't put it out of my mind.
No, there is a real reason is item number 4 was also mine. So to catch that, I was
You entered immediately after that, actually.
I entered immediately after. Oh, after my comment,
yes.
he entered.
A few minutes after that, you
The
entered.
thing is, my Lord, if I
sauntering.
was the petitioner, then I would have been running and he would have been coming a little later. My Lord, we have a point saying that the money which my learned friend today wants from us is basically stopped, Lord, by the PSC. That's the Union of India. I have in my affidavit given every explanation possible, my Lord, that the Union of India needs to be a party before your Lordship because they will have to put up a stand of their own. And the Union, my Lord, is not a party.
Do you for an effective relief? I mean, if you need not.
The money is not going to come from me. The money is going to come from Union of India. It's my point. I give it.
You do not oppose their claim.
I am opposing their claim, but it's basically coming in from PSC. Basically coming in from
Ultimately,
PSC.
even if they win, they won't get the
They
money.
won't get the money. They won't get the money.
No, there is a little.
Even if they get an order from your Lordship, my Lord, there will be no contempt on me because the money will come from them.
Mr. Banerjee, you take your call on that. I mean, if Union of India, ultimately, if it's found that they have to disburse the money, then it's no use. At that point of time, you have to hear them again then.
Kindly have a look at the scheme once. I'll tell your Lordship what has happened. Under the scheme, why he says that? Because Mr. Chatterjee has another scheme in his head. These two are here. The third scheme is in his head. I'll tell your Lordship what that scheme is. I have benefits that I'm entitled to under these two schemes. Here, they have no ground to withhold it. The opposition is cast on the ground that in respect of another group company, some fraud has been detected. So there is a direction or some kind of a decision that whatever benefits are extendable to the other group companies, that should be withheld or it should be adjusted. Now, my point is only 3, that under the scheme, no such clause or condition is mentioned. grounds that are extraneous to the scheme can't be put to use to deny benefits under that scheme. Second is that recommendation I'll show. Nothing has happened on the basis of the recommendation. What they say is an order is actually a recommendation. There are no criminal cases pending against me. No steps for recovery of any money against me. Nothing with regard to these petitioners. Now, all are separate juristic entities. So whatever.
No, but those are your sister companies or group companies.
Those may be group companies. Maybe group companies. But nothing has happened on some Kankaria group of companies. They say that because of that, they file a suit against this particular company, which was earlier called Usha, has now become MFL. There is a suit that they file against MFL for recovery of money that has allegedly been fraudulently availed of a scheme. There is a suit. In that suit, I don't know what has happened. I am not a party. There is also a letter which they say that it has been adjusted. That absolutely extraneous extra legal measures have somehow come on record here. The authority as an authority is not a preferred or a privileged litigant. They file a suit and they say now whatever is payable to me stands adjusted in respect of that suit. So that suit against MFL be accordingly amended.
You are on a subsidy scheme.
I am on a subsidy scheme.
How can that be adjusted with some other?
That's right. And that's
I think they are saying that they won't disburse it to you because of your link with the
specific stand is adjustment. It has been adjusted against what is allegedly falsely taken as subsidy by one MFL corporation in respect of a separate scheme, MM4 scheme. So there is one MM4 scheme.
So Banerjee, if you even if you win the writ petition, if you can't get the money,
this is the authority that pays the money. I'm entitled to the scheme. Kindly have a look at the scheme.
Let us see that.
Page 22.
This is an autonomous body.
That's right.
Statutory body.
Statutory body. So who's in control? Who will pay? If they face contempt, I'll take it up. Let that defense, Mr. Chatterjee will keep up his sleeve. And if I don't succeed in the contempt, I'll come back. This is page 22 is enough for me to just show that the respondent is a board. It's a statutory authority that has floated the scheme. The incentive comes from them. Now they want the union. Now the third scheme that is up Mr. Chatterjee's head is they want the Union of India to come and to put a complete cloud on this entire issue of MFL Corporation, how there is some other company who has obtained a benefit under some other scheme, and with nothing that can be legally countenanced, but possibly with highly prejudicial fact that, look, your group company was in something as with respect to a fraud.
There is not a single allegation against you, this company.
That's right, Manoj.
But your group company.
Group company, one MFL corporation. Again,
that will be the basis of your argument is that group company, whatever happens against the group companies, that cannot affect the scheme.
Cannot.
Yes, absolutely.
There is one document I'll just show you. Just have a look at one document. Your Lordship will just have a look at page 110. Of the writ petition.
Yes.
This is revised guidelines from that incentives. I say PAM, whatever. This just let's call it.
What is this own source? I mean, own source.
Two kinds of purchase. If I put in my own money and take, or if I take bank finance. If I put in my own money and I have bought the machines, then how do I claim my incentive is 110? I could have taken your Lordship through all the clauses, would have been wasted for time. This is part of that scheme. Just have a look at this chart. Jute mill approach, unit to approach NJB with a letter of expression of interest for purchase of machinery. On completion, disregards all of that. Kindly have a look at the second last heading, box. inspection to be conducted within 30 days on receipt of IJRA's report. Then arrow, incentive to be disbursed within 30 days of inspection subject to fulfillment of all conditions by the unit as laid down in the scheme. This is it. I have their own inspection report, which has certified machineries under this scheme, which are entitled to benefits for the incentive. Now, what I would request your lordship to just make a note of is under the first scheme, the benefit is 20%. And under the second scheme,
yes,
the benefit is 30%. Now, under the first scheme, I have one LOI.
You are claiming under both schemes.
I'm claiming under both schemes. There are total 4 applications. Don't have to make a note of this. This will be confusing. There are total 4 applications. 1 under the first scheme, 3 under the second scheme. In respect of 1 under the first scheme, lot of machineries have been inspected. Some have been certified to be entitled to the disbursement of the incentive. I'm saying what you have found to be, I have found me to be entitled, disburse in respect of that. That's scheme 1. So I'll have to just show your lordship that in inspection report. That's with regard to scheme 1. Scheme 2, I have 3 applications. Application 1, application 2, application 3. Application 1 and application 3 is unnecessarily going to cause confusion. I'm giving it up. Application 2, they have held inspection, found machines to be payable. So application 1 under scheme 1, application 2 under scheme 2. I'll be able to show from the inspection report that machineries have been found to be in order, in consonance with the requirements of the scheme. I am eligible to that incentive. There is not one line in the opposition because respondents can't challenge their own order in a
So what about scheme 1 and 3?
Scheme 1 and 3,
I mean, application 1 and 3 under the
scheme 2. Their inspection only has not happened.
Achha, very well.
So my initial prayer was that the court should allow an inspection to be held in respect of that. But my specific instructions from a client are not to make this murky, to stick to 1 and 2 of 2. And at least get out what I'm entitled to. Now to enforce, I'll tell you, lordship, what the difficulty is going to be. Now, if I ask for an inspection under these 2 schemes, this is going to become slightly contentious because they say the scheme has expired, which scheme will apply, all that issue will come. Although I'm protected by a judgment that if I've applied within the period of the scheme will apply, but the client doesn't want to push it anymore. He wants his money because these are very expensive machines that I purchase, hoping I'll be able to offset the cost with the incentive that I get. Keeping this in mind, the board also uses these incentives so that people in jute industry use these machines for optimization of the product. And by and large, from my experience, what I've seen is once you apply under the scheme, they don't disburse the benefits. Here also is a case where the defense or resistance is not that I am not entitled under the scheme. The resistance is not I am not eligible under the scheme or an inspection. What I'm claiming I'm not entitled to. The solitary defense is that of NFL Corporation, some group company availing benefit under some other scheme. Therefore, there is some recommendation. 2 things I'll address your lordship on. Legally, 1 is grounds extraneous to a scheme cannot be put to use to deny benefits under that scheme. Second is internal correspondence between departments is neither justiciable nor can be the basis to either grant or refuse a benefit.
In what sense are you saying this?
Because these are internal correspondence between them. Not having translated into any order.
in both the schemes, the National Jute Board was I mean, it
Yes,
floated
yes.
the scheme.
It has floated the scheme.
But it's a different scheme altogether. And
Completely.
different
That is some MM4. That is some MM4. This is the ISAPM.
internal correspondence, you say, is not a basis for this refusal.
Can't be. Internal minutes, internal notings, internal correspondence, unless it translates into একটু পরে করে নিই। unless it translates into an executive or an administrative order.
Obviously, yes.
Then simpliciter relying on notings or interdepartmental correspondence, you either can't grant or can't withhold. Factually, I'll just indicate two things, Manoj. Not two. Factually, I'll have to show your lordship 3 pages. And the opposition is a gem that your lordship will allow me to place. Opposition is completely Mr. Chatterjee's brainchild, because somebody with a very sharp, astute legal mind
Definitely
would have come up with that.
Then I'm
And I'll give him full credit for that. Because because the scheme, they have nothing.
I admit, Pillar, it's not.
They in the conference try and find out this, that, and then they come up with MFL Corporation. I'll show that.
I can't go beyond this. That it's not mine.
Well, 3 pages your lordship will allow me to just show. (127) kindly has a look. I'm coming to that second last block of that chart, because the last one is why I'm here in court, because the payment incentives have not come. I'll show that second block I have crossed. 127. This is inspection of machinery installed an incentive claimed under NJB's incentive scheme for acquisition of plants and machinery at Ballyfab. The inspection team comprising of so-and-so on so-and-so, claim number 2, claim application of Ballyfab, date of application 1st December, date of claim 21st August 2017. This is scheme 1, claim 1. Lordship will kindly turn over, Milan, to page 129.
Yes.
4, 5, 6, and 7. Inspection team observed that the above imported machines are procured new and in operation.
Yes.
The date of installation and technical specifications of the machine are found to comply with the claim application of the unit submitted to NJB under ISAPM. The inspection team has observed that the machine or machines was installed after submission of LOI. The date of inspection, inspection serial number, and the initials of the inspection team mentioned in the scheme are earmarked on the machine plate by permanent marker or brush and paints and stencil. Well, this is an important number 7. The representatives of the unit have also certified that they have not availed any claim or loan assistance, incentive whatsoever from Ministry of Textile Government of India or any of its organizations for the machines inspected today under ISAPM by the inspection team comprising of the undersigned representatives. So not all, your lordship will see that of all the machines that they inspected, some were not found to be in order. But some have been found to be in order, which is mentioned in that particular chart, which your lordship will turn over, Milan. This is following documents, attachments have been verified with the claim along with physical verification machinery are found to be in order. Then they write yes, 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 and payment receipt N in respect of something, which I'll show at page 131. All this is YY and verification of board N to be signed by the members of the inspection team on the board. This is what is happening now. Kindly turns over, Milan.
Yes.
Now they make a note with regard to certain machineries that they could not find. Machineries item number 6 to 11, they could not take inspection of, they wanted to come back on another date. So they come back on another date. And that your lordship will find at 134.
Yes.
They again carry out that inspection. Now 136, kindly have a look. Last line of that first paragraph. Serial number 6 to 11.
Yes.
Reinspection is carried out on today. The team observed the following A, B, C, D, F, kindly see. The inspection team signed on the machines under serial number 11, subject to verification of genuinity of the manufacturer plates supplied by the vendor or not. Visiting team observed that the above imported non-core machines at serial number 11 is procured and new in operation. The date of installation, technical specification, just kindly gives it a cursory glance. So some machines are certified under the scheme. Some are not.
6 and 11 are accepted.
6 and 11 are accepted, and first one, 131.
Yes,
Those schemes were accepted. Out of that, some. So for your lordship's convenience, I have made a chart depending on these two, and it is nobody's case that this chart is incorrect or my understanding of the inspection report is wrong at 139.
Yes.
This is prepared by me, the petitioner. This is not by the authority. This is calculation of incentives. Kindly have a look at the bottom. I've given the total list of machines, calculated only the incentive amount at 20% for the ones which got certified on inspection. The bottom is the figure. It is 9,43,704. So scheme 1, application 1, it is 9,43,704. Similar for scheme 2, application 2, your lordship will find same again. Volume 2, lordship will kindly come to 186 once. Yes.
Yes.
Again, that same Bali fab. 2 will be important, Lord, date of application. Just to show to your lordship that this goes to the next scheme. Date of application 25th July 2017. Date of claim 22nd February 2018, because that second scheme is from 1st April to 31st March 2020. This your lordship will turn over at 187.
Date of application and date of claim, how are they different? Page 186.
Date of, so first I have to make an application with the LOI. With that LOI, then I procure. Then I give all the documents and back it up and then file an application for the claim. This also, what I just said could also be slightly incorrect, but that is my understanding of it. I'll still check the scheme, but this is what I have been told how these two differ. 18 kindly comes to 187 once. Serial number 3. Visiting team observed that the above imported non-core jute machines are procured new and in operation. The date of installation and technical specifications of the machine are found to comply with the claim application of the mill submitted to NJB under ISAPM. 6 will again be important, Milord, in view of the defense that has now come.
The representatives of the mill have also certified that they, I'm on this word, they have not availed any claim, loan assistance, incentives whatsoever from Ministry of Textile or any of its organization for the machines inspected today under ISAPM by the inspection team comprising of the undersigned representative. Again, for your lordship's convenience, we prepared a lordship, give me a minute.
letter of intent,
Correct, বললাম তো এক্ষুনি, LOI টা দিয়ে একটা।
Their allegation is that you have your group companies have claimed under under different schemes.
Claim under some MFL corporation has claimed under some MM4 scheme and fraudulently taken more money than it should have. So they have filed a civil suit against this MFL corporation for recovery. The stand is that I am not going to be disbursed the amount because my entitlement is going to be adjusted towards the head of MFL. So the moment they use this, it means that I am entitled to the benefits. That benefit is actually disbursed. Then the adjustment happens on another count, on another company's head. This under the Contract Act also, between the same parties, it can't be done. Because claim under one head cannot be adjusted against another unless the party is put on notice. This is a different company, different scheme.
Yes. I'll release the other matters. Other matters are released. Yes.
এটাও release.
Mr. Chatterjee is also released.
Now, for your lordship's convenience, we
তার innocence আমি innocently তুই কথা বলিস না।
Yes. Sir.
Page 196, Manoj. There was a brief period for considering it's almost 4:20. I'll take 2 minutes, Manoj.
421.
421.
Specific.
And I am also International Parliament Court judge.
I thought your lordship was your lordship was enjoying my lord's self.
But commendable the temperament that your lordship
Not
is.
temperament. Your lordship was enjoying it. It was not about temperament or patience.
Actually, I thought he was a party to that.
we figured.
Some cases are there, Mr. Chatterjee and Mr. Banerjee, where people are actually suffering and they don't know the forum where to go. So my second thought was that probably this person is also of that. But when I heard his language, I could decipher that I could not decipher. Then
Best was when he was saying that, your lordship says he has
Because
this
he said,
algebra
I was
geometry.
trying to figure out.
Your lordship is viral all over the world with a view of 26 lakh.
It's internet.
26 lakh views. No, not funny.
26 lakhs?
I hope I'm not within that 24
Within the 24?
to be notified.
Oh, okay. No, nobody from Calcutta.
That is not the language.
Also, that's not allowed.
The language is different.
Language will be
Maybe some from some of these courts, but not necessarily not from others.
There was an inclusive thing thereafter, which did not have Calcutta written.
No, it has been kept open. That
Any
reporting is
24
open.
from somewhere. Now the reporting is specific. I've seen that. There were Patna, Bombay, Delhi, Andhra Pradesh, Telangana.
No, those have been named.
Yes.
Including from these.
Including.
Or maybe from these. I mean, it's a conjecture till now.
এতদিনে জানতে পেরে গেল।
Nobody knows. Anyway, hopefully not for this.
No. But now nobody knows for what. Manoj.
Nobody knows.
Now nobody knows for
And this
what.
is also being recorded. So-
Good.
Yes. This message should go.
Good. It should get recorded and it should get circulated.
My lord, for your lordship's convenience, at page 196, again with regard to that second scheme, second chart,
Yes.
my entitlements are here.
Chief কোকড়ানো চুল নয়, এটা কিন্তু
So there is nothing much to elaborate upon in your case.
Nothing.
I mean,
Just-
this is all.
This is all, just the
no
defense.
extraneous consideration. There is no such consideration in the document itself.
But that
you have
affidavit I'll have to show, my lord.
Yes, yes, definitely.
There's the because otherwise factually there's nothing. Facts come for the first time in that affidavit.
Acha.
That supplementary your lordship will take because in the parent one there is nothing. Actual chart ki abar.
In the main writ petition, there were no affidavits directed.
Yes.
Or affidavits have been
Yes,
extended.
affidavits are complete.
There is a supplementary to that.
There is the supplementary to his opposition. My lord, the same flow chart that I showed to your lordship at that particular page 110 for scheme 1. For scheme 2, it is at page 104. It's the same thing.
Which writ petition? Oh, the same.
Same. But two different schemes. So I have to indicate that that is my entitlement, that after inspection, incentives are to.
In this writ petition itself, you have disclosed that also.
That
Yeah.
also. Because one petitioner claiming from the same authority under two schemes.
Alright.
So I've pleaded order 1, rule 1, order 2, rule 3, and I've done it in both. It's also not their case that I could not have done it in one or those points, thankfully, Mr. Chatterjee has not taken. That supplementary your lordship will see, my lord.
Yes.
Supplementary on behalf of the respondent.
Yes, yes, Mr. Banerjee, don't get distracted. Yes.
No. So what I wanted to indicate, my lord, there was a brief time when I went to International Parliament Court. So for about 12 days, there was a time when I was going and staying with him when he was in college. And we used to play cricket together. And he had taught me that when you bat, don't get sledged by a wicket keeper. Page 3, part of paragraph 3.
Yes.
Well, I'll place paragraph 3. This is important. This is their solitary defense to my claim. I say that several anomalies were discovered which were committed by several jute mills, which include the petitioners. In the mini mission 4 scheme, kindly marks this, this is a separate scheme. Public Accounts Committee, a committee of Lok Sabha, in the 39th report dated 24th March 2022, captioned as failure to implement scheme objectives, has noted on query from them that the NJB Ministry of Textile has taken legal action against the jute mills for recovery of the subsidy amount wrongly drawn under the said scheme. PAC is very strict with regard to the recovery of the wrongfully drawn subsidies. Apart from filing of money suits with regard to recovery, simultaneous action were proposed by the committee to bring the perpetrators to justice. The committee recommended that all jute mills, units, and the directors or promoters who have been found to be involved in the irregularities related to capital subsidy be blacklisted from availing any benefit under any scheme of the government in future. This is with regard to PAC. I say, Bali Fab is a company which is incorporated under directorship of the promoters of Bali Jute and Ambika Jute. I say that in my affidavit in opposition, I've already demonstrated that the owners, promoters of Bali Fab, Bali Jute, Ambika, Kelvin, these are the 4 petitioners, are all identical and same. It is a matter of record that Ambika Jute Mill and Bali Jute Mill have already defalcated substantial public money in mini mission 4 scheme. Incorrect, I'll show that. Therefore, in terms with the direction given by the PSC, the capital, this is where it gets interesting. Now they call it a direction, what is earlier stated to be a recommendation. The capital subsidy in the future scheme has been, kindly mark this word, adjusted. And they have been debarred from availing the benefits of the scheme. Factually all incorrect. There is no criminal proceeding against Bali Fab, Bali Jute, Ambika or Kelvin? I'll show. There's a recommendation. Nothing has been done. There is no order of blacklisting. There are no suits filed against any of these companies.
This is not Mr. Chatterjee's draft.
No, not his draft.
I mean, not settled. He has not settled.
But if it's wrong, it's my draft.
It's not wrong, that's why.
Come back.
Yes. Hard in part. Not further hearing tomorrow. Supplementary affidavit, arekta line hard in part report. Supplementary affidavit, comma opposition thereto, and the reply filed to the opposition be kept on record.
Also, the fact that we wanted the Union of India to be made a party, but he doesn't not want.
Very well recorded something on. Actor line at Kurudin. Learned counsel for the respondent authority submits that since the Union of India is the disbursing authority, comma, the same may be impleaded as a party to the suit, as a party to the writ petition. However, comma, learned counsel for the petitioner submits that in view of the nature of the scheme, comma, the liability to disburse lies on the respondent authority and, comma, as such, comma, the Union of India need not be implemented.
Grateful. Thank you.